Please take your seats. The meeting is about to begin. Please stand by. We are going on air in 5, 4, 3, 2, 1.
Okay, good morning, everybody, and welcome to the April 25th Planning Board meeting in our fancy new digs. Actually, I'm really impressed for a makeshift room. This is pretty impressive. So thank you all for being here. I want to start by having great news that Nick Kalergis is staying with us, the city. And
thank you.
Seriously, great news.
I appreciate that.
And with that, I will turn it over to Nick for some comments.
Thanks, Mr. Chair, and good morning to members of the board. Today's meeting of the Planning Board will be conducted in a hybrid format, with the board physically present at Miami Beach City Hall, and applicants, staff, and members of the public appearing either in person or virtually via Zoom. In order to participate virtually in today's meeting, the public may dial 1-877-853-5257 and enter the webinar ID, which is 861-4342-6327#, or log into the Zoom app and enter the webinar ID, which again is 861-4342-6327. Anyone wishing to speak on an item must click the raise hand icon or dial *9 if they're participating by phone. Next, I'll read the city's notice regarding lobbyist registration. If you're appearing on behalf of a business, a corporation, or another person, you need to register as a lobbyist with the city clerk's office. If you haven't registered yet, you should register before you speak to the board. You don't have to register as a lobbyist if you're speaking only on behalf of yourself and not any other party, or if you're testifying as an expert witness providing only scientific, technical, or other specialized information or testimony in this public meeting, or if you're appearing as a representative of a neighborhood association without any compensation or reimbursement for your appearance, to express support of or opposition to any item. Expert witnesses and representatives of neighborhood associations shall, prior to appearing, disclose in writing to the city clerk their name, address, and the principal on whose behalf they're communicating. If you're an architect, attorney, or employee representing an applicant or an objector, you must register as a lobbyist. These rules apply whether you're appearing in favor of or against an item, or encouraging or arguing against its passage, defeat, modification, or continuance. And lastly, I'd like to swear in any members of staff, any members of the public who intend to testify today. Please raise your right hands. Do you swear or affirm that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thanks, Nick. Before we get into the agenda, we need to approve the minutes from March 26th meeting. Can I get a motion to do that?
Second.
Okay, all in favor? Anyone opposed? Okay. After action reports approved. Okay, the first is a deferral. Mike, do you want to just go
Sure,
through
Mr.
that?
Chairman, before we begin, I just want to clarify, we do have all 7 members present today. I'm not sure if that's aware from the camera's point of view, but we do have all 7 members present today. As the chairman noted, we do have one deferral. which is PB 24-0661. This was commercial, industrial, residential height and setback regulation modification citywide. This has been deferred, so there's no action that the board is required to take on this item. It will be re-advertised for a future date. So just wanted to bring that to the board's and the public's attention.
Okay, so we'll move on to requests for continuances and withdrawals. The first is Planning Board File 230609, Alton Road Palomar Hotel.
Yes, and I believe the applicant is requesting a continuance to the June 25th, 2024 meeting. Mr. Marrero is here on behalf of the applicant.
Good morning, Mr. Chair, members of the board. Actually, Joseph was in communication with my client. Again, this is for the restaurant expansion to the rooftop. They're currently working to finalize deals with the new restaurant operator that's going to replace Meridian. By the way, Mickey Marrero, 200 South Biscayne Boulevard. We actually would like to request a continuance to July to make sure they have enough time to work out those details. We originally said June. Mr. Belush is right. But if we could have a continuance to July, that would be great.
Let me ask you, have you had reach out with Sunset Harbor Neighborhood?
We've talked to, we actually had a meeting scheduled, but I told them, since we're deferring, so continuing, let's delay it. We've reached out to Palm View, to Sunset Harbor, and several other affected parties, but since we don't have the final details now that we're working on a new operator, we deferred that meeting, but we will be having it.
Great, okay. Anyone have any questions? Okay, do we need to move it, or
We should just ask if there's any public comment on the request for continuance.
is there any
I see
public
no one in
comment?
the audience and no one with their hand raised.
Is there anyone on Zoom?
There is one person, no, they lowered their hand, so there's nobody with their hand raised on Zoom.
Okay, so someone want to move it
Motion to approve the continuance
Second.
to July, correct?
to the July meeting.
Okay,
Was it June?
Originally,
July.
email was
Okay.
June, but it is July.
okay. All in favor? Anyone opposed? Okay.
Thank
See
you.
you in July on that one. The next motion for continuance is Planning Board File 230643, 1212 Lincoln Road, 1628 Alton Road, padel or paddle courts.
I've learned it's paddle, apparently,
heard
according to
multiple.
I've gone through that exercise too. I'll let Michael take
I was
it.
going to say, Mr. Pence here on behalf of the applicant.
Thank you. Good morning, everyone. Graham Penberg, Howard Fernandez, Larkin Tapanus, 200 South Biscayne Boulevard. As you probably know from your emails, we've had some concerns raised on the application, especially from the Bayview Plaza, which is to our west, and we met with the some of the board members. The president's here, Darren's here to speak, and as well as WAVNA. But we need additional time to keep talking about issues related to lighting, et cetera, for the property. So we would ask for a 30-day continuance until the June meeting.
Okay.
You mean the May meeting, right?
Oh, are we in? I keep thinking we're in May. Yes, 30. Yes, I didn't want to go to June. Thank you. The May meeting.
Okay, anyone here in chambers to speak on this motion? You are? Okay. Good. Just introduce yourself and your address.
You bet. Darren Spadale, 1621 Bay Road. Good morning, everyone. For those of you I haven't met, I'm the board president of Bayview Plaza, which is an 80-unit condo building at 1621 Bay. I'm also an active participant in WAVNA, which has been integrated into the discussion, has been very helpful and supportive in this matter. Since the topic has been postponed till next month's meeting, I just wanted to stop by to put a face to the name behind the emails that you've received. And just to say we appreciate 1212 Lincoln's willingness to work together to try to find common ground. We'll collaborate in good faith to try to find solutions to the issues that we raised to you all, and we hope to return to you next month with a collectively favorable outcome. Other than that, I just wanted to thank you all for taking the time to read my initial communications outlining the concerns of my residents in my building and the surrounding area. And lastly, I just want to thank you all for the hard work you do to help make our city better. We, your fellow residents, greatly appreciate it. Thank you.
Thank you.
We do also have, are you here to speak on this item, James?
No.
Okay, we have one of the callers to speak on this
Sorry.
item.
Wait, well, then what are you getting up
Apologies.
for?
I have a request for an additional continuance for
hold
another
on a
matter.
second.
Yeah,
Okay.
Absolutely.
We have Gail Durham with her hand raised online. Gail,
Okay.
are you there?
Gail?
Oh, hi there. Thank you. Thank you. Yeah, just watching these continuances, and I just remember that a lot of cups and wanted to come during the summer, during June and July, so that there would be less residents around to push back against their requests. I'm really surprised the Palomar said they reached out to WAVNA and the Sunset Harbor, because I don't think they did. I think the
Actually,
neighborhood
actually,
association
Gail,
tried to reach out.
actually, Gail, they said they had not yet, that they were waiting for final plans with the restaurant before they do that.
They said Nicky Marrero said he reached out, but that they decided, to push it back. They didn't reach out. Yeah, July is when most people aren't in town. And I don't think, when I was on the planning board, we didn't rubber stamp continuances because we knew this trick. So I'm really surprised this just went through without really asking the right questions. Why is this on the agenda? Why are you making people show up to meetings like myself when it's not going to be heard? I went to the meeting that was set up for the 12 Lincoln because Russell Galbert and his daughter Marisa were supposed to be there, and they didn't show up. And they didn't even tell us beforehand that they weren't showing up. They just didn't come. So I didn't think that shows good intent. Thank you very much.
Thank you.
With
Anybody
that,
else?
there is nobody else with their hand raised online. So I believe the applicant is requesting we need a motion on the request for continuance to the May 28th planning
Yeah,
board
just to
meeting.
address Gail's points, I mean, part of this is good faith, and I have to assume that if an applicant needs more time to either work on specifics or deal with the neighborhoods, sometimes we have to accept that as good faith, I mean, her point about people not being here in the summer, that may be true, but I don't want an applicant to have to come here if they're not prepared. But I appreciate your comments, Gail. Yeah. Yeah. Okay. Anyone opposed to the continuance? All in favor?
We need someone has to make a motion
Oh,
to
sorry.
continue.
Motion to approve the continuance to the May meeting.
Okay. All in favor? Aye. All opposed? Okay. So now you have a motion that's not on the agenda for continuances?
It's not under that section,
Which
Mr.
one?
Chair. It is number 5 on your.
The Mondrian?
Yes, sir.
Okay, go ahead. Well, Mike, you have anything to say first?
Well, so, yeah, I would normally give you an introduction from staff, but
Right.
because he's asking for a continuance, I'll let him make the request for continuance, and then we will take public comment on the request for a
Okay.
continuance before the board decides what to do.
Thank you, Mr. Chair. James Rao with Greenspoon Martyr Offices, 600 Brickell Avenue, here on behalf of 1100 West Investments. Thank you, Honorable Chair and board members. I'm asking for continuance primarily because our client's ownership appeared before the board on these types of items, and they could not be here due to observing Passover. So they would like an opportunity to be heard. In your staff report actually requests to hear this matter again in 60 days. So if you could just continue this portion, this progress report, for 30 days to your May meeting, I think you can accomplish that same goal. You can have the discussion in 30 days, and again 30 days later, and you would still be back in the same place. But that's the primary reason that I'm
Staff,
asking.
remind me, this gets on our agenda because you all said it in
Yeah,
light
so
of noise
we
complaints.
sent a cure letter to the applicant advising them of the planning board meeting today and let them know this was placed on the agenda for a progress report.
Right, but because you all received noise complaints?
Correct,
Is there
yes.
some threshold, I'm just curious, is there a threshold of complaints that need to be reached before it comes?
It's not a hard and fast written in stone
Okay.
number. It's up to the planning director's review of the evidence.
I would also just add that since the cure letter didn't provide any detail on those complaints, we started investigating it. We sent a response to the cure letter, which you all were passed out. But since that time, we obtained numerous other documents from code compliance, which we actually believe supports the hotel being in compliance. But you haven't had an opportunity to review those documents. So at a minimum, I think the board should be able to view the full picture, all of the facts and the documents, which I've shared with the city attorney's office so far, but we just got them, so we haven't had an opportunity to put it together in a format for the board. So I think it would accomplish that goal too, is giving the board all the information so that you can have that discussion perhaps at your May meeting, and then you can still hear it again at your June meeting
All
as
right,
the
so
staff
you want to move
requested.
to May?
Yes, sir.
All right, let's see if there's public comment. Anyone in chambers to speak on this?
morning. My name is Tim Carr, West Ave Neighborhood Association, a resident of West Avenue. Again, I am the president of WABNA. This is Amy Litos and Susanna Purucker. We would ask that you hear this today and hear what we have to bring forth, because we're talking about residents' quality of life. And not only are we talking about quality of life, we have some videos to show you the impact. We have, in this 1100 West Avenue, we have 2 residential towers that flank on either side. Over 450 units on either side, and on a daily basis, starting as early as 7:30 in the morning till well into the early mornings of the night, they have been assaulted, and it's an ongoing issue. So I would ask that we do listen to this today, have a good discussion, and then take it from there. So if I could turn it over to the video, please, so you could get a snapshot of what these residents are dealing with.
I think before we go to that, we should just talk, this is just a discussion on the request for continuance. So you can make your argument.
Our argument is
opposing-
no continuance. We need to have this heard today because of the significant impact on the residents' quality of life.
Right, so with that, if the board will make a decision whether to continue or not, and then at the time, if the board does not continue the item and wants it heard today, after I give my initial comments, Mr. Rao has a chance to respond, and then we open to public testimony. At that time, you can bring forward that information.
All right, thank you.
I got a couple questions. When did they get notification, the Mondrian, about the about today's meeting?
The cure letter was sent out on March 18th.
So March 18th. So they've had a couple weeks. They've had like almost a full month. So it's not because of Passover. I mean, Passover date hasn't changed. It was in the calendar for a while. So, and so you guys had a month to prepare for this meeting and have not prepared, to your comments. I'm just a little concerned that you guys are asking for a continuance this morning at the last minute when we have a bunch of people that have already showed up and when you guys had a month to prepare for this.
Just to clarify, I was asking for a continuance due to Passover because my client couldn't be here, and he typically likes an opportunity to be heard, particularly when there's going to be residents that have things to say.
Are you referring to Russell?
Yes.
But
Yeah.
my
Mr.
comment
Gallo,
is
yeah.
that, he could have given notification earlier last week, or that he wasn't going to be able to show up at the meeting today, so that these people that weren't showing up all prepared to be speaking today.
And our first request was, and not to get into the substance, but because this came up, our first request was that the cure letter be withdrawn because the facts did not support a cure letter. There were complaints that supported the hotel being in compliance, none of which were violations, and were not violations of the conditional use permit. So we were asking originally that the cure letter be withdrawn. We didn't know if that was going to be the case, and then that's why, when that turned out that the staff wanted to have the matter continue on the agenda, that's why we're here today asking for continuance.
So obviously, this is a progress report. So the ramifications of continuing it, because if we hear it today, then we can set it for a modification revocation hearing. So it would delay that issue.
Correct.
That's
Okay.
right.
Well,
All right.
and your staff report still asks that you hear it again in 60 days. So in terms of moving this discussion to your May agenda, it would keep that same timeline. You'd still hear this discussion in May, and then in 60 days, you could still take whatever action you were going to take. It's not really going to delay any action. It would just give us an opportunity, as I said, one, for our client to be here to be heard, and two, for us to give you all the facts, because the cure letter paints a picture of complaints that are just not accurate.
I mean, I see it's beyond just the complaint. I mean, there's clearly a deep issue that's been sort of simmering among the neighbors for a while now, and so I think we should at least hear preliminarily what the neighbors have to say today. We can't take any action today on it, other than noticing it for a future hearing. But if we're going to continue it for 60 days anyways, let's at least hear what the neighbors have to say today. That's what I would think.
Yeah, I agree, and I think any evidence on the merits, you would have that opportunity, because all today is a progress report. So you'd have the opportunity to challenge the merits at a revocation hearing or the next progress report. So I agree, just because I don't think it's fair to have them come here and not know you're going to seek a continuance. in
We
advance.
would just ask the board not to take any formal action
I
today.
understand. We're going, I mean,
that
unless
reason.
the board disagrees, we're going to go ahead and hear it, James. And like I said, any arguments you have, like what you just mentioned, obviously you can present them at the next hearing.
Okay.
And I'm sensitive to the Passover. I'm sorry Russell can't be here, but, you know, it was on the agenda and they show up and all of a sudden it's being asked to move. So I just don't see there's real downside to hearing it only because you still preserve all your arguments for the future hearing.
I agree.
And Mr. Chair, if the board is not inclined to continue, then I would suggest allowing staff to make the
Yeah, we are.
presentation and
We are.
then open to the public.
But I want to make, first, I guess I have to have a motion to deny the motion for continuance.
You don't need a motion.
Oh, we don't? Okay.
Yeah, unless somebody wants to move that the progress report be continued, you don't need a motion.
Okay. All right, does anybody want to move it to be continued? Okay, all right. Michael?
Okay, thank you. So again, this is PB 0616-0034, 1100 West Avenue, the Mondrian Hotel Progress Report. Now, back initially in October 8th of 2008, the board did approve a conditional use permit for a neighborhood impact establishment, the subject property, consisting of a restaurant and bar lounge located throughout the garden, lobby, and pool deck areas. Specific to the current, the subject application, on March 18th of this year, the planning department did send a cure letter to the applicant in response to 9 noise complaints that were received for the pool area between January 1st and March 24th of this year. We did advise the applicant that the progress report was scheduled for today. We did provide a summary on pages 14 through 16 of the board packages, which outlines the noise complaints that were received by code. Since the planning department sent the cure letter to the applicant, there was a violation issued, and that's noted on page 16 of the board packages, including a photograph that shows a live band performing on the property. Now, as noted in our staff report, that unless associated with an approved special events permit, entertainment, which includes music played at a volume that interferes with normal conversation, is prohibited. And absent a special event permit, music may only be played at ambient background levels. Generally, the CUP also requires that all exterior music, except in covered areas such as cabanas, cease by 10 p.m. Sundays through Thursdays and 11 p.m. Fridays and Saturdays. There are some exceptions to those hours for certain holidays. As noted, that the CUP does expressly prohibit the use of percussion instruments on the exterior, you know, at all hours, all times, and clearly prohibits such instruments as outlined in condition 7J. And we noted that this is exacerbated by the fact that it occurred late at night after 11 p.m. when even ambient music is prohibited. So our recommendation is to discuss the progress report, take testimony, and continue for 60 days to allow ongoing monitoring. However, if the board wishes, you could set a revocation modification hearing. The earliest that could happen would be for the June meeting, since we do have to notice it in accordance with all the noticing requirements of 30 days. So with that, I'll turn it over to Mr.
So
Rao.
both a continued progress report and a modification
No,
will
the
have to be
progress,
in June?
the progress report could be continued till May, if you wish.
Well, you said 60 days, so.
Our recommendation is 60 days.
Right,
However, if
so
the
it'd be
board
June
wants
either
to-
way.
If the board wants to recommend
Okay, it's
a
earlier.
continuance, as James is suggesting, until May,
Right.
and at that time, discuss whether or not they want to set a revocation hearing.
All right.
I think that's what Mr. Rao's requesting.
Okay, all right.
Thank you very much, Mr. Chair, board members. James Rao with Greenspoon Water, 600 Brookville Avenue, here on behalf of 1100 West Investments. Just at the outset, I'll just repeat what I indicated previously. There are numerous documents in terms of detailed case reports from code compliance, which we believe supports that the hotel was in compliance. We just got those. We shared them with the city attorney's office, but we haven't had an opportunity.
What do you mean by that? I don't understand what that means.
Sure. Let me, so our response to the cure letter, which was provided to the board today, provides some of that information. But to elaborate on that, the case reports, well, for one, of these 9 complaints, 0 resulted in a violation. So the code compliance officers went out, they inspected, and they determined there was no noise violation. And that's what we're here on today, because the cure letter cites to a violation of condition number 21, that's for late night noise as defined in the noise ordinance. A number of those case reports that relate to the violations, which were not included in your package or the cure letter, have comments as follows. Not unreasonably loud or excessive. Pool area was not unreasonably loud, excessive. While I was entering my notes, the complainant called again. I assessed the music again, and it did not seem as though it was turned back up. It sounded lower than before, and I'm reading from the reports. In one case, the code compliance officer even indicated in their notes, this sounded like a civil issue between the complainant, tenant, and the hotel. The complainant called again to speak with a supervisor. The manager explained that the resident who is complaining has registered complaints with the hotel because they will not let her out of her lease early. To move on to, and I'll finish quickly. In one instance, when they observed music being played, they indicated specifically that it was at an ambient level, which is the standard under the conditional use permit. And lastly, in one instance, the pool area music was not unreasonably loud, excessive. They went out to the pool area, and there was literally no one there. So not only was there not an event, but there was no one on the pool deck. So those are typical of the comments in the case reports on these 9 noise complaints. So when you see a cure letter with 9 noise complaints, it sounds like there must be a noise problem here. All of the case notes indicate otherwise. They're the best case we could give you to show that the hotel's in compliance. So that's why we initially asked that the cure letter be withdrawn. In addition, condition 21 that's cited to in the cure letter is very unique. It's not about just violating the noise ordinance. It's about late night noise complaints. And as mentioned in our response, except for New Year's Eve, all the other complaints were issued, or all the other complaints were documented during daytime hours, before 11 p.m., which is the standard of the noise ordinance, somewhere in the afternoon, 1:30 p.m. So it didn't fall under that condition either. Whether there are other things to discuss with regard to compliance under the conditional use permit or relationships with the neighbors could be something to discuss another day. But as to this cure letter that's before you, it has to do with condition 21, late night noise complaints that violate the noise ordinance, and that's not what happened here. So if you have all the facts, and that's why we ultimately wanted you to be provided with all the facts ahead of time so that you could review those case reports yourself and see exactly what we're telling you. I provided some of those to the city attorney's office in advance.
I have a question first. James, give me 1 second. Michael or Nick, so again, this gets back to the threshold about putting this on the calendar. And everybody knows that a complaint can come in and code may not, at the time it's cured, whatever. So forgetting that, if what they're saying is true, that none of these became a actual violation, I'm just curious again how it works internally to put this on the agenda. So you're getting complaints by neighbors. According to them, code went out every time and said there's no violation, right?
Right.
Is that true? First of all, is that true?
That is true, that in the end, it came out that there was no violation because, as Mr. Rao mentioned, condition 21 does talk about complaints for loud, excessive, unnecessary, or unusual late-night noise. However, since the cure letter was sent out, there was another violation that he didn't reference yet that was issued regarding the live band that was performing on the pool deck. So we
Right,
think,
but before I get to that, my question is this: if you get multiple complaints from residents, and code goes out every time and says no violation.
if it was 1 or 2, we probably wouldn't be here. If
But
it's
let me finish my
repeatedly, yeah.
question. Let's just say there's 20 of them, and every 20 of them is determined by code not to be a violation. Well, the complaints alone allow you to still put it on the agenda?
Yes, that's
my
to be
question.
determined by the planning
So it doesn't
director,
matter
yes.
what code ultimately determines?
Correct.
According to putting this on our agenda?
Correct.
Okay.
And, Mr. Chair, just
I
to
have one
elaborate on that.
question. Are these all from the same building? Are they different people? Who are they?
I think you're going to
I'm
hear
trying
that. I think you're going to hear that from them.
Yeah,
I think so.
Thanks.
There's not an there's a name or two mentioned, but there's not an indication as to necessarily who made the complaints, which is another issue because under state law, in order to have a violation and have enforcement proceedings, the individual and their address needs to be identified ahead of time. But in this case, our position is essentially that, number one, the fact that there were 9 complaints that were invalid.
But are
actually
you aware of the one that Michael just said has come up since?
Yeah,
the
that was
cure letter?
issued after the cure letter.
Right.
It's under appeal, and it's not a violation for late night noise. It's a violation under the section that pertains to having percussion instruments and live music. So it's a different issue.
But wouldn't
It's
that
not-
still be a violation?
It was issued, if that were true, that would be a violation. As I said, that's
So
under
you're
appeal.
appealing it, saying there was no percussions
That,
or live
I mean, that's under appeal before the special magistrate. The special magistrate has sole jurisdiction over that violation since it was issued, and it's now under appeal. But even so, that was issued after the fact, so
we
it's not
understand- I
before us
understand your
on the
argument.
complaints. But
Okay.
essentially, our position is, if an applicant can be called back before the board for invalid complaints, that essentially renders a conditional use permit nugatory. I mean, and the number of complaints actually supports our position, because there were 9 complaints. I don't think in 20 years of standing here, I've ever had a hotel with 9 noise complaints that didn't result in a violation. And virtually all of the comments from co-compliance confirmed the hotel was in compliance.
So,
Unlike-
okay, I don't mean to be a jerk, but are you suggesting then that the residents are just harassing the hotel for no reason?
What I'm saying is, no, look.
No, I'm serious, because-
Sometimes when there's smoke, there's just a smoke machine. We don't know the facts. That's what I'm saying.
Mr.
Now
Chair.
that we know the residents are here, we could have a discussion with
All
them,
right.
of course.
All right, well,
But
let's let them, sorry.
On the facts, there's not.
No, I understand,
facts to
I understand
action
your
on.
position. Elizabeth?
Mr. Chair, I'd like to know how many, since the CUP was modified in 2019, how many violations they've had that have resulted in actual, calls that they've had that have actually resulted in violations, because it seems like this has been an ongoing issue, and, I mean,
I'd have to go back into the research, and I
Okay.
could do that if we come back.
All right, but you agree with his statement that all 9 of these did not result in a violation?
That's
I just
correct.
want to make sure the facts
That's
are
correct.
correct. Okay. And then the one that came after is pending appeal?
Right.
Okay. All right, let's let them speak, and
We'll just ask for
we'll
some
bring you
time
back
and
up.
response later.
Okay.
All right, thank you, everyone. I'm going to turn it over for Amy and just wrap it up at the end, but she's going to kind of walk through the actual presentation for you that she put together. So, Amy?
Good morning, everyone. My name's Amy Litos. I'm a resident of West Avenue. And if we could please start the slideshow. Thank you. So we could
Just so we
stand.
understand, you live in a building next door to the Mondrian? I just want to get a perspective.
I do not, but Susanna does.
You do, okay. And you live on West?
On West Avenue.
But somewhere not next door?
Not
Okay.
next door, no.
Got it, okay.
We could stand before you and talk about this, but we believe it's best for you to hear it yourselves. There is no disputing what goes on at the Mondrian, and we have a presentation which will make that evident to you. So let's begin with where the Mondrian is. This first slide shows that it's a hotel within a neighborhood. It is surrounded by multi-family condo units. So if you have, let's say, 300, 400 units, let's say you have 2 or 3 people within each unit, you are potentially affecting thousands of people with this noise. Next slide, please. This shows the proximity between the Mondrian and where Susanna lives, which is the 1200 Mirador. And it's the same thing on the south side. Next slide, please. So now we're going to play a few videos for you that will demonstrate what this sounds like for residents. And keep in mind, this is supposed to be ambient sound. Please play the first 3 videos. Bear with us. This is actually on the property itself. but it would be hard to believe that this sound does not carry to the buildings next door. Video 2, please. Potentially hundreds of people on this pool deck. And again, remember the proximity to the buildings next door. As you see, that's the 1200 Mondrian behind me. And video 3, please. These are all just random days, no special events. DJ. Thank you. Next slide,
So I have a
please.
quick question for you
Yes.
before you keep going. So it's, obviously we saw what we saw, and it's hard for us to determine how far out the.
We'll
noise
show you
goes.
some.
My question to you is, why do you think the code officers who came out, every one of them determined there's no violation?
That's
Do you have
a
any
mystery.
thoughts on that?
That
No?
is a mystery.
Okay, I just wondered if maybe you had an idea why that, okay, keep
Well, a lot
going.
of times, a lot of businesses use a thing called a spotter, so they know when they're coming, and they turn it down. And actually, some of the videos will show you that after they left, the music comes back up.
Okay. Sorry to interrupt, go
No,
ahead.
no worries. All right, so now we have, oh, actually, we can skip that one. Yes. So here, another random afternoon, just to let you hear what it sounds like from the 1200 Mirador. Please play the next video.
This is the next door building, right?
Yes,
Okay.
just to the north. There's not any way this is ambient sound from the Mondrian. We're hearing this from the Mirador.
So this is someone on the balcony of the next door
Correct.
building? Okay.
On the 16th floor. Next video, please. Again, later on in the same day, this goes on for hours.
That's one of the sports and fitness classes. They sometimes have boot camps where the trainers have headsets and microphones and scream at people and count down, and it goes on for hours.
I'm sorry, can I ask you to state your name for the record?
I'm so sorry. My name's Susanna Purker. I live in 1200 West Avenue,
Thank you.
right next door.
All right, we also heard earlier that the music is supposed to be turned off at 10. We have a video that was shot at 10:40 on another random evening. Please play slide 6. This is almost 11 o'clock at night. Thank you.
Of mariachis. Okay, go ahead. That's one of the boot camps. There's different videos. There's one where they don't use a microphone and one where they use one, and you can see how the sound travels.
Please play slide 7.
And this goes on for hours. It starts as early as 7 a.m. and goes on for hours and hours. That's those daytime complaints that seem to be hard to understand. But our building we have people that work from home. We have people that have small children, people with newborns. We have people who have to work.
And one last video. Again, just another random evening. So again, back to the question, how does code not hear any of this? And we could have selected dozens of other videos. This has gone on for years.
Every day.
So we heard that these calls amount to nothing. However, here we have a graphic, and it's a bit small, but there are 28 special magistrate hearings that have been had for this one property. All but one of those has resulted in nothing. Yet you just heard what goes on there day in, day out, and has for years. How did all these special magistrate hearings find that nothing's occurred? Another mystery. And the last slide, please. As a second aspect of what we're presenting to you, we would ask that the special magistrate system be revamped, just so occurrences like this, disturbances like this, are properly adjudicated. As we can see here, there are some simple processes that could take place to make the special magistrate system work for residents as opposed to work for businesses.
All right, so in conclusion, what we would ask is actually, so you saw some of this and you saw some of the challenges, and the latest thing they did similar to the standard is they now have a beach membership or pool membership. So that's why you see videos of why it's so crowded. It's not just pool guests, it's outsiders coming in to help create the chaos. So the West Ave Neighborhood Association would ask that you all consider no further continuances. Let's act on this today, and we really ask you to take further, immediate action on this and actually remove the cup. Because again, this outdoor license
Let me
situation.
stop you a second, just so you understand, you have to understand the process. That can't happen today. This is a progress report. So we don't have the authority to take action today.
All
But we
right.
wanted to hear it, just so
The
you
challenge,
understand.
Laura, we appreciate you taking the time, but the
Okay.
challenge is, again, the impact. We've already talked about the special magistrate process and how it's broken, how there's a workaround around code, but unfortunately, the residents of our neighborhood continue to suffer, and as we do a continuance for 2 more months, they're gonna live through that as well. And that's not fair to the residents to have to put up with that.
Okay.
And that's what we struggle with.
Thanks for your time. Before James speaks, I'm just curious on the special magistrate hearings. Do affected residents not get notice of those hearings? So is it only the applicant and the magistrate?
Do you know that information, Nick?
I don't believe affected nearby residents get specific notice, but there is notice that the special magistrate is going to hold hearings, and those cases, I believe, are posted online, and the public has a right to
So they have to
speak during the public
proactively go
hearings.
look at it.
But it's not like a hearing before the land use boards, which triggers, for instance, a
That is a
meeting.
little odd, by the way.
It's a challenge, and not only
Yeah.
that, if you do find it and you do participate, oftentimes there's many continuances too.
No, I
So
get
again,
it, but I
residents
find it odd
constantly
that,
chasing.
that there's no one,
And
none of the
actually-
complainants are there to give evidence. But anyway, that's for another day, but your point is well taken about the magistrate system.
And oftentimes when there are fines, they're punitive and they're just factored into the cost of doing business.
Right. Okay.
And we would ask that you all of us are going to thank Commissioner Suarez for bringing this onto the agenda. It's gone on for so long and no one has really heard us until now. So thank you.
Thank you all. James?
Thank you. First, I have to lodge an objection to the videos and documents that were shown online. If the intention was to take those as evidence, we don't know who took them, when they were taken, or what they pertain to. So that's unduly prejudicial to our client. Again, there are facts that exist. They're in the city's records. We provided you with some, but there are other documents in the city's records that support the hotel's position, and that's the evidence that's before you today. Are the 9 complaints and the comments from code compliance. I don't think it's appropriate to criticize code compliance, that they somehow didn't do their job or didn't do it right. That's what's in the record. In terms of opinions about other days, and like I said, I don't know what videos there were. I don't know when they were from. I don't know if they're, for example, the special magistrate proceedings list that they showed you, some of those were before a client bought the hotel. So, again, it's unduly prejudicial. It's trying to paint a narrative like there's a constant problem here, a constant history of problems here. If that were the case, there wouldn't be a CUP. It would have been revoked by now. So I would just ask you to stick to what's before you, the evidence that's before you. We're here on a cure letter for 9 noise complaints, none of which resulted in a noise violation, and the code compliance comments, detailed case notes for that, support that the hotel's in compliance. This, and another reason why I wanted my client to have an opportunity to be here to be heard, they can talk to the neighborhood, they can talk, they have in the past, there's no problem with doing that. They've done that before, and I'm sure they'd like an opportunity to do it again, but that should be before
Well,
throwing a
he's gonna have
number
an
of different-
opportunity at the next hearing.
Yeah, I just don't think it's fair to the board to throw a bunch of things before the board that may or may not be true.
Well,
You
hold
have
on,
some
Jay,
documents.
Hold on. The videos, I mean, they're not going to come here with false and misrepresented videos. So you heard it, we heard it. All I'm saying is that you're going to have an opportunity to have your client here next time. But I think you've kind of been given a peek at what the argument's going to be. So I think you should be thankful to have seen
Right.
what they have instead of springing it on you next time.
Right, we would just like an opportunity to be heard
I understand that,
at your
but
next meeting.
do have a legal question for you, Nick. Does the city have any exposure if a CUP is modified where every violation or every complaint was found to be not a violation by code? Because that concerns me, to be honest, with you, from a legal standpoint. And I don't know the answer to that, but like if you went to a court and said, hey, they modified our CUP despite the fact that their own code department found no violations.
So the standard in the code for you to modify or revoke a CUP is evidence of intermittent or repeated noncompliance with the conditions of the order. The best evidence of a code violation is an adjudication of that violation, right?
Correct.
But
That's my concern.
But your modification and revocation hearings are quasi-judicial public hearings, much like an initial hearing to obtain a CUP. So you can take evidence and testimony from nearby or affected property owners. You do have one violation here that was issued, so a continuance would allow time for that to play out.
I get all that, but my question's a very narrow one, is would the city have exposure for modifying a CUP or revoking one if all of the code officers found no violation, despite what evidence is presented, if that's the ultimate conclusion by the code department? And if you don't know the answer, that's fine, but
No, I know the answer. I think the way I would answer it is just to say, on when you have one violation that is subject to appeal, I would recommend letting that play out, because again, the best evidence of a violation is going to be an adjudication of that violation.
Right, which we don't have any right now.
Not yet.
Okay, all right.
But, sorry, a question on that. In the event that it was appealed and overturned, the violation, you still have a whole bunch of videos which, at least anecdotally, seem to show that there's excessive noise coming from the property. So how would the city then deal with that?
And a lot of calls.
But the calls can be somewhat arbitrary. I mean,
True, but the videos
videos
speak
are-
for themselves, and they are dated from your phone, and they are dated. I mean, it's not like you can just go present a video.
I'm just curious, like the legal process.
Let me do one thing before we see. Is there anyone else here to speak on this? Anyone on Zoom?
Yes, we have one person with their hand raised on Zoom.
All right, let's finish the public hearing and then we can discuss it. Go ahead.
Sarah De Los Reyes, are you there?
Sarah?
Hi, this is Sarah De Los Reyes from Sunset Harbor. Even though we do not, we're not close to the Mondrian, this is the same thing happened with Purdy Lounge. It took me almost 12 years with videos and nothing ever happened with the Purdy Lounge. And you know what? We have this issue. That code comes and it's so true. As soon as you're going to call code, somebody lowers the volume and then they go on. As soon as they leave, everything comes back. And Tim Carr is correct, and I'm happy that they have videos, because that's the only way to show you guys, even though we say this is what it is, but it happens all the time. I had experience about this, and you know that. And I also, we actually would like to hear what's going to happen to the Palomar. I already told Mickey, we do not approve this. We do not want to change the code. This is going to happen to us and to West Avenue. The same thing is happening with the Palomar. It already did last year. The Palomar had this big event, and we heard it in the neighborhood for 8 hours. Thank you.
Thank you, Sarah. Anyone else?
We have another caller, Bruce Backman.
Same building.
Yes.
Hey,
Yes.
Bruce.
How you doing, Brian? I'm just calling because although you mentioned about the special master's hearings being public, if you go to the Miami Beach City website and click on agendas, there are no special master's hearings that show up. There's Historic Preservation Board, Design Review Board, Planning Board, Finance Commission. I'm reading the list. I'm looking at the agendas. public safety. There may be some other special place to find the special master hearings, but they are not on the agendas. So for all practical purposes, they are not published publicly, and people who are not aware of them as bad. And of course, it's outrageous that the affected parties are not even notified. If you wonder why people do not want to see you give CUPs to hotel rooftops or terraces, whatever, this is the reason why. This has gone on for years. I've heard this hearing before because I use it as relevance of what the planning board is likely to do in our neighborhood should such an application come. A few years ago, I listened to a hearing where a woman was in tears, her windows were shaking, the noise is so bad. You guys don't do anything about it. The code doesn't do anything about it. Special masters do nothing about it. This is why we do not want to have CUPs, CUPs allowed for venues like this, whether it's on the roof or on a terrace. Thank you.
Thank you. Anybody else?
And now we have Gail Durham.
Gail?
Yeah, the reason, my name is Gail Durham, I live on West Avenue, and I'm a former member of the planning board. The reason why you shouldn't rely on beautification is because that is not the only testimony you should be relying on. Second of all, as we know from the Mondrian, the Good Time Hotel, all of these noise violations, valid, are appealed because these companies have lots and lots of money and they hire lots of attorneys and they appeal it at special masters. And residents don't show up at special masters to defend their cause. It's just the attorneys for the venue who twist the law. Sometimes they don't tell the truth to the judge. And for example, at the Good Time Hotel, the last 6 valid noise violations, 6 hearings, the judge dismissed the case for very strange reasons and it's just not fair. So my recommendation, I don't know why next month you can't have a revocation modification hearing next month. I know maybe it's against the rules. You have to wait 8 weeks. And if that's true, then we should change those rules too. We should have an ordinance to change those rules. Thank you.
Thank you.
And Mr. Chairman, I'd just like to respond to Mr. Semen and Ms. Latone asked. It's a public hearing and it's a quasi-judicial hearing. So, I'm sorry, if and when you schedule a modification revocation hearing, that is a quasi-judicial hearing. So you can take evidence and testimony from affected parties.
Okay. Anybody else on Zoom?
No, Mr. Chairman, before we begin, if I can make a couple comments.
Sure.
On what I've seen and what we noted in our staff report. So in terms of the noise that happens on this pool deck in the daytime, the standard should not be whether it's loud or unreasonable. The standard really is it above ambient background levels? If anywhere on the pool deck during the day that audio interferes with normal conversation, that would be a violation. Another thing to comment on is that I saw a DJ, although that wasn't referenced in any of the code violations. The code specifically says entertainment is not allowed unless authorized by a special event permit. A DJ is entertainment. So by the fact of seeing a DJ on the property without a special event permit, that would be a violation as well. So just to clarify for code, the residents, and the applicant.
I have to time and shinely. We don't know there was not a special event permit.
Yes,
Whatever video was
I'm not
taken
commenting.
there.
I'm just commenting on generally. I'm not saying that was a violation. It wasn't a special event, but just so everybody is aware that a DJ on the property would be considered entertainment and is only allowed during the times of a special event permit.
I'll just close it. You've heard a lot of comments today, videos, things, some of which are not supported by fact. For example, somebody mentioned that businesses have spotters that identify with code compliance. There's no evidence in the record of that, and no evidence of that happening here. We just want an opportunity to be heard. Yes, we have some insight as to how some residents feel, so we have an opportunity to address that with them individually. We'd like an opportunity to come back to you for this progress report. And of course, you can make your decision at that time. But right now, there is no evidence in the record upon which to set a modification revocation hearing. We're traveling under a cure letter that has to do with 9 complaints, all of which did not result in violations. But further, all of which the notes in the code compliance on reports support the hotel. Position there.
One question before you go. 2 questions. Had you seen those videos before today?
No.
Okay.
I haven't seen any.
Is the special master hearing set for the currently code violation under appeal? Is it scheduled?
I don't know.
You don't know if you have a hearing date yet?
I'm not 100% sure we have a hearing date yet.
Okay. Typically, how long do they take to get heard?
What we can do is get that information for you and also notify any members of the public who expressed interest on this application and let them know when the special master hearing is set.
All right, okay, go ahead, Yashil.
Based on the feedback, and I totally understand this is the first time you've seen the videos, so could certainly be caught off guard by that. But let's not just play the kind of technical game, right, where maybe there's like a technical reason why it's not right or it is right, whatever it is. I mean, clearly they have videos, clearly they are impacted somehow. Clearly that music was above ambient. So just between now and whatever it is that this board sets, whether it's for a progress report or revocation, please just get with them, truly listen to what they're saying and work towards a solution.
Sure.
Because objectively, we hear it. So.
Mr. Chair, I'd like to make a motion to schedule a revocation modification hearing. I think that there's a lot of things that have been a problem for quite some time, a number of years actually, and I think those need to be addressed. So.
Okay, before that motion's heard, do any of y'all have questions of?
I wanted to jump in, something that you touched on. You know, you talked about a sort of a legal exposure that the city has if we modify the CUP. And Nick said that, I guess the best evidence is a valid noise complaint.
That's adjudication, meaning the.
But there's more, Nick. You know, we heard that they are now, I guess, they have a day club there where there's memberships. That's obviously something that if, you know, whenever the CUP was originally granted, if it, you know, was on their application, this board would have looked at it and maybe put restrictions on it, maybe said yes, no, or whatever. So when they sort of change their operation, that's something that we could look at and say, well, we want to jump in on that. We want to comment and we want to either allow it or not, or allow it with certain conditions. So that by itself, I think, allows us to modify. Is that correct?
I got the same question yesterday from one of your colleagues from Ms. Latone, and I'll give you the same answer, which is whether a hotel, restaurant, pool, bar operate, you know, whether it's open to the public or whether they charge a fee or whether they charge a membership fee, on its own would not require amending a board order. Now, if there were other changes made, you know, physical changes to the property or other changes to the operation itself that would have required amending the conditions, then that would need to come before you. But I don't know enough about this particular establishment's private club model to say whether any of the conditions of the order.
The hours are different, timing's different. There are a lot of things that are different that are not within the outlined CUP. So I think that speaks for itself.
Okay, maybe that's something staff can
We'd have
look
to
at.
review and see if there are
Yeah.
differences.
I don't want to be accused of invited error, so I would just implore you not to set a revocation hearing, to set a progress report.
Well, my inclination is to set a progress report to give your clients the opportunity to present evidence and refute, you know, I mean, that's my gut, and then we would set it for a revocation, but we do have a motion to set it for a revocation hearing on the floor. So.
Can I
I'm going
ask?
to second that motion.
Can I ask a question though? Like,
And do you have I'm sorry, do you have a date for you want to put, it's got to be June?
June.
Okay.
but the
And that gives you time, and to talk to people, to have more people from the neighborhoods associations to come and speak. I just think that I know from being here for so long that this has just become an issue. And it's not anything against the Mondrian per se, but it's about the residents' quality of life, and I think that's really important.
I appreciate your position, but revoking a development order is extreme.
And this is a question for Nick and Michael. I mean, whatever is being claimed by about the supposed error, the error is not necessarily in setting the revocation modification hearing. The error would be that if at the modification revocation hearing there's not sufficient evidence or there's not appropriate evidence or not sufficient notice, and then we modify or revoke the CUP, that's where the issue is. There's no need to give them additional notice or sufficient, sufficient time to be heard at a status report before doing a modification revocation hearing. Is that correct?
I would agree with that. Yeah, and actually, any decision you make on a modification or revocation is reviewable by petition for cert, just like your.
But the issue
CUPs.
isn't setting of the hearing. So I'm
Correct.
saying, right, so the setting of
agree,
the hearing.
yeah.
So that's why I'm in favor of setting the hearing, and largely because I think there needs to be a change in this process for residents. I mean, it's just the process that I've seen for the last 2.5 years, just, it seems very unfair to residents who are dealing with this day in, day out, who are hearing boot camp classes outside of, their window and with their balcony doors open, especially in a beautiful building like the Mirador, which is right on the water. I mean, to have to listen to that every day, and then to have to come to a hearing on a status report, and then have to come back to another one, and then there's the summer break in the month, so that's extending it, and then, waiting another 60 days, for the hearing. I mean, it's a lot, and I think that we need to be more receptive of neighborhood input, and I think we need to, be more accommodating for the residents who are taking their time out of every day. So I think I would err in the side of setting the revocation modification hearing now without waiting any longer, and then, if it comes to that hearing and we need to continue that for 30 days, that I would rather that, so that they can work together and everything like that. But I'm glad we had this hearing today, and that's it.
All right, so we have a motion and a second. Let's go ahead and vote.
Just to clarify, our
What was
due
the
process issue relates to the cure letter, which starts the process that leads to a modification revocation hearing. And that is what we are suggesting is deficient. So just leave that in the record. It's not.
Okay, yeah, you got to preserve all
If
your.
it starts with that, if it starts with that due process violation, that carries over to the quasi-judicial hearing.
Right.
Well, sorry, what was the date that you wanted?
June.
So, just slight suggestion, just to hopefully help avoid whatever legal loophole there might be, couldn't we, and this might help it or not, couldn't we set a progress report for 30 days from now, and then concurrently set a revocation/modification hearing for June? You can't run those two
We
paths.
already have a motion on the table.
No, I'm just curious if legally.
You could do both, and I think this board has done that before.
It would
I
still
think
get
it-
you to the same time, and it hopefully helps.
But then what would the benefit of a 30-day progress report be?
Just legal loophole.
But when we're setting the revocation modification hearing, when we actually get to that hearing, it doesn't need to be, the basis for that modification or revocation does not necessarily need to be related to the original cure letter. It can be part of it, but if the original cure letter was formulated off of something that was dismissed by a special master, but we still receive evidence from the neighbors of other violations, I would think that would still be sufficient. But listen, I think there's a motion on.
There is a motion. My only concern is I'd love this other appeal to be adjudicated, but like you said, Jonathan, if we need to continue it from them, we can do that. So there's a motion on the table with a second, so why don't we vote? And this is to have a modification revocation hearing scheduled in June.
This would be for the June 25th, 24
Right,
meeting.
Elizabeth made the motion, and I think Scott
Second by Mr.
seconded it.
Needleman. All in favor of that?
Aye.
Any opposed?
Aye. No.
The motion passes 7-0.
Can we just make sure we have some of the compliance officers for that meeting too? I just want to understand the other side of it, just to see if it highlights a bigger problem that we have in dealing with these.
I agree with that, Melissa.
And just one other question, because we have code compliance here, and Michael, you mentioned that a violation of the CUP would be, if on the pool deck, the music is louder, or more than ambient, you can't hear yourself. What we heard seemed to be the case. Could we hear maybe from code compliance, if that is how they've been looking at the noise coming from the property, and if not, will they look at it that way in the next few months?
Mr. Villar, do you want to speak on that?
Yes, good morning. Manny Villar with the Code Compliance Department. Our officers are trained to do a 360 view when we're responding to noise complaints, and gauge the noise or the complaint from several vantage points. As you all see, these are very large towers, so when our officers arrive, they are on the east side of the property, where the tower obviously is in front of the pool area or the pool deck. They have to access the building, they have to go through the lobby, they have to request to go in the building. So there's several, I'm not gonna say security points, but they have to go through several points to enter the property and evaluate the noise. We do request to meet with the complainant. That happens rarely. Most of the time, the complainants do not want to meet with us. They want us to just go assess the noise on our own. Sometimes they do allow us to meet with them. All right. There was something mentioned about people monitoring or monitors, et cetera. That is widely known. It's probably almost impossible to prove, though, because these locations have several layers of security, several employees, people that work for them. When they see a code car in the neighborhood, obviously we have to drive there. And I'm not saying this is the case for this particular establishment, but there are several obstacles. It's not as simple. We don't have a boat where we could access it from the rear of the property. There's
no water
The code boat.
So, Mr. Villar, can't the residents, when they call in code compliance, can't they have you guys show up at their building before showing up at the Mondrian Hotel so you can assess the noise from that point of view where there won't be any security alerts to the building?
Yes, absolutely, absolutely, and that is the preferred and what we usually suggest to them, but oftentimes they do not want to meet with code. Oftentimes, I'm not saying.
The complaining building.
The complaining person, it has to be a person or obviously we go to a building, but they have to provide their name and their address legally by Florida Statute 60. That changed a couple of years ago. The governor enacted that law. So that is the preferred method.
Tim, you guys might want to take note of that and, into voicing that with your residents to just have an extra layer there.
And also, when I've had, to your point, Melissa, when I've called code before on, I don't even know, but they came to my house first, and they wanted to come into my unit and listen to the noise and all of that. So I'm not quite sure how, they said they wouldn't even go to the property without entering my apartment first, which I thought was odd, but in any event.
No, I'm sorry, that's not correct. I mean, again, the preferred method, we contact the complainant, we request if they want to meet with us, we ask them. The majority of the time, they do not want to meet with us, sometimes they do. If the complainant wants to meet with us, that's the first place we go, and we meet with them. We assess the noise from their vantage point, from their unit, from wherever they are, and then the investigation begins right there. A lot of times, like I mentioned, they do not want to meet with us, so we have to gauge it from public property, public areas, et cetera, approach the building. We can't just storm in the building. We have to go to the front desk, ask them, tell them what we're there for, ask to see the manager, et cetera. So that's the way it works, and it functions in real life.
I have a question, if I could. So you mentioned that you have to drive there and that it's widely known. You have your white SUVs that say code compliance. I have seen code compliance on bicycles before. Is it possible to help avoid some of the spotters, maybe, let me just finish, not undercover, but, not wearing giant shirts that clearly identify themselves, so that you could possibly go to some of these establishments that have multiple layers of security. Obviously, you'd still have to go to the front desk, but you would create less of a,
Yes.
be less obvious.
Yes, the answer to that is no. Policy dictates that all our code officers must wear a uniform. They can ride bicycles, but depending on the day of the week, et cetera, staffing levels, that may not be practical. So typically, bicycles are used for special events, spring break, Memorial Weekend, things like that. When we're operating in certain areas like the entertainment district, et cetera. But no, our officers wear uniforms and they have to drive their city vehicles. That's the way policy dictates we have to respond.
I have a question. Is there any process, so, in looking at the Mondrian CUP, it looks like there was a speaker design plan created by an engineering firm back in 2013, and then this CUP that I'm looking at now is from 2019. Is there any process either from the planning department or from code enforcement to when there are properties like this that are, you know, high impact establishments to, I mean, I know that they go in and verify, you know, right after the property is built or opened, you know, the speaker placement, but, you know, 5 years from then, or even when we're getting this onslaught of new complaints, even if they're not validated, is there anybody who does like a walkthrough to check to see that the speakers have not been moved from those locations and, you know, periodically?
That's a good point. That's something that planning could do with an inspection. We don't typically go out there and do that, but if we're notified that, hey, the speakers that are there now are not consistent with what was approved, we can go out there and do an inspection and see if they're, you know, take a look at the plans that were approved and see if the plans inside are consistent.
I guess the problem is, like, who could possibly ever know unless you do like a deep Gail Durham dive into the history
Well, I
of
think it makes sense as part of a progress
the
report.
Durham dive.
So I think for this property, especially now that we have it scheduled, it's you know, it's on the agenda now, it has all eyes on it. We can go out and do an inspection and confirm if the speakers are consistent.
Because listen, you know, that's, to me, I'd like to have a process, a better process of doing that. That's not really penal to do that. It's really, you know, sometimes new staff comes in, they just shift a speaker, and then next thing you know, the neighbors are hearing all this noise. Or, you know, there's you know, with the Good Time, I know things have changed there. That, you know, there was a wall with vegetation that, you know, we'll talk about later. But, you know, things change over time and operations change, and so I just think having a more streamlined process, and I guess it sounds like it's planning, not necessarily code.
That was my question. Who is that, a code or is that planning?
No, I think we would probably have planning go out there and do an inspection.
And would you go by the original sound design?
We would go by based on
plans,
what's in the CUP,
okay.
because the CUP typically references the speaker locations and the design.
Right, I
as
just wanted to
presented.
make sure.
And then, you know, it could be the case where if there was a change out, we would probably ask them to provide like a substantive comparison by their sound consultant and have it reviewed by our sound consultant to see if there was an equivalent change out or not.
Yeah, and then the last thing I guess is, do you guys, when your code officers are out there, they pull up, I assume on their computers, they have an easy way of pulling up the CUP for each property? Is that what they do?
Yes, sir. The first thing they would do on a noise complaint is check the history for noise complaints, review those code records, complaints, and violations, and then they also can access the CUP, obviously, in the field on their computer, on their laptops.
Is there, I assume there's not any sort of like executive summary that code compliance officers have, like with just quick bullet points of what's allowed and what's not allowed on a particular property, right?
There is no official executive summary, but they carry a copy of the CUP, and the supervisors review them with their officers. We review them during training, especially, say, for the entertainment district. Those officers, we meet periodically and go over the CUPs and obviously any hotspots or problem properties. We review it with them and highlight the most important points that code needs to be looking out for.
Because I don't know if this is something that would be cleared with the legal department, but to me, I mean, I'm going through this, I'm a lawyer, you know, it's taking me like time to go through this and understand, you know, there's ambient and then there's no band, no live music. And so I guess the point being is if there's 5 bullet points for code enforcement officers to make sure, because part of the reason is, you know, there may be a live band there. They may show up, it's not unreasonably loud or whatever the standard is. And then they leave not having seen or recognized that there's a prohibition on live bands as well, and that would have been another, you know, violation. I know that they did violate them on this one, in this particular case that we were talking about, but I guess just making sure, you know, that it's clear and easy to reference, especially since I know you have new code officers starting all the time or changing locations, and, you know, going through these, you know, in your car on the laptop is not the easiest thing in the world. So I don't know if, you know, there's a way to have to add that to, like, especially for some properties that are, you know, more the CUPs are more complicated.
And it's a good suggestion. The challenge is, I mean, as you know, is that every word matters. And I would want code to rely on the text of the order. And we, our office and planning routinely field questions from code. We work very collaboratively with code to interpret these orders. The best advice I can give the board and staff is just in your approvals is just making sure that the conditions are as clear as possible. So that code can enforce them.
All right, last question, then we need to move on. The code officers, when there is a violation found, they all go to the special magistrate hearings, correct, to present their evidence?
That's correct, sir.
Okay. Can we put on the agenda, not for June, maybe July or August, just the magistrate rules and procedures? Special magistrate rules and procedures? just
Sure,
to
we can do that
review?
as a discussion.
Yeah, as a discussion item.
And I just one last comment
Yeah.
before we move on is
Sure.
just out of an abundance of caution, if there are additional violations, or even for this 10th violation that was issued, additional cure letters may be transmitted to this particular or any other property owner. And if we need to schedule another progress report before you, we'll do that.
Are you talking about generally?
No, it's like for the last application, we can send out another cure letter to the applicant and schedule a progress
talking about the
report
Mondrian.
for the Mondrian. So even though you scheduled the revocation modification hearing for June, we can send another cure letter and set a progress report either for.
Why would we do
I'm just
that?
saying if it's necessary.
If legally it's necessary.
Yeah,
Okay,
yeah, I just want to
got
give the
it,
board a
got it,
heads
got
up.
it, got it.
Yeah.
Okay.
Yeah.
Sir, thank you so much. We got a lot to cover today, so appreciate your time, and tell the neighbors that showed up, James, thanks. You know what's going on. We'll be in June, and obviously you're aware of that hearing, and your client will be welcome to come with any evidence. So, all right, next is the theme today, revocation hearing on Planning Board File 160075, the Good Time Hotel.
So again, this is Planning Board File Number 16-0075. This is a revocation modification hearing for the Good Time Hotel located at 601 to 685 Washington Avenue. Now, just to note some history on this application, the Planning Board approved this conditional use permit back on July 26th of 2016. It did take several meetings for them to get their approval, and on the initial application, in their presentation before the Planning Board, the Planning Department had recommended denial of their outdoor entertainment component. So I just wanted to get that out there in terms of the history. So this application was last before you as a progress report on March of this year. And since that time, a new violation was issued, which is noted in our staff report on page 36 of the board packages. And this was for audible music heard after 1 a.m. 2 blocks west of Washington Avenue. Now, as part of this modification hearing, we do believe that when the CUP was last modified, which was February 8th of 2023, by changing the requirement that music shall not be audible anywhere west of Washington Avenue to unreasonably loud, excessive, unnecessary, unusual, that this introduced more subjectivity into the review of noise complaints. We are strongly recommending that the CUP be modified to revert substantially back to the prior language, which includes plainly audible. And that plainly audible language is also used as a test where music is audible 100 feet from the structure between 11 p.m. and 7 a.m., and we believe is an objective testing criteria. The issue with having the text unreasonably loud, excessive, unnecessary, or unusual outside of that 11 p.m. to 7 a.m., there's no really definition or requirement to qualify what constitutes that unreasonable, loud, or unnecessary noise. So by changing it to not plainly audible, we think that's a more enforceable condition that's clearly understandable by the applicant, code, and residents. We are also recommending that the DJ hours be modified. Right now, the CUP allows an ambient DJ between 9 a.m. and 11 a.m., and also after 8 p.m. We're recommending that only during the hours when an entertainment level of music is provided, which is between 11 a.m. and 8 p.m., only during that period should a DJ be allowed. These are not small DJs in the back corner. These are headliner DJs that do create a lot of crowd activity. So we do believe that it's warranted to have a DJ only allowed during times when the CUP allows for entertainment level noise. Let's see. I did pass around an updated CUP, modified CUP, highlighting in yellow some minor changes compared to the initial draft that was sent with the board packages. This is just to clarify that we're measuring the 100 feet. We're putting the standard for plainly audible at a point of 100 feet west of the subject property line versus west of Washington Avenue. That's a more defensible clarification in terms of the code. It's substantively the same, but since the Washington Avenue right-of-way is 100 feet, that corresponds with that requirement. So with that, we are recommending the modification in accordance with what I just noted, and I'll turn it over to the applicant for their presentation.
Thank you, Michael.
Good morning, Mr. Chair, members of the board, staff. Mickey Marrero, 200 South Biscayne Boulevard, here on behalf of the Good Time Hotel at 601 Washington Avenue. Before I begin my presentation, I'd like just make a couple of quick clarifications. There have been no violations. In fact, there have been no complaints since the last meeting in March. I checked the system this morning. There was not one complaint in the system. Mr. Belush unfortunately incorrectly mentioned that there was a violation for noise at 1 a.m. I did notice that it was entered as 1 a.m. The pool deck is closed, literally lights off, nothing going on at 1 a.m. So I don't know if that's a typo or if someone entered it into the system from before or what. That's been appealed, but there was nothing going on at 1 a.m. So I don't know. That's just incorrect. But let me go into it. I know that you've all heard a lot of this several times, but because this is a revocation modification hearing and we do have a record, and several board members haven't been here all of the duration of this saga, I'm going to just go into a brief history of how we got here. So the project, as Mr. Belush said, was approved in 2016. That was during the Washington Avenue overlay discussion and the revitalization of Washington Avenue. This project is an absolutely unique project. The goals of this project were to get the intensity and the impacts of operations that were at nighttime operations that were impacting the neighborhood and bring those to the day so that it would be relatively quiet at night. That was successful, obviously. There have been challenges. What this building replaced, this block on Washington Avenue prior to the development of this hotel, was considered one of the most blighted blocks. I mean, what you had was all those things that are now prohibited in the Art Deco and overlay districts were all of what was there. Smoke shops, occult, check cashing, just kind of like the least wanted uses. So the hotel came in, and as I'll explain in more detail in a minute, the way that this hotel operates is critical for its success. So it opened in 2021, and right at the beginning, it was clear that there were some issues. A lot of complaints from residents, a lot of, and these were valid complaints. There was valid noise. The standard, as it was originally published in the CUP, was incorrect. The sound studies done prior to the opening of the hotel was based on that incorrect standard. All of that, we had multiple sound engineers from our side, from the city side. A lot of effort was taken to correct that, and ultimately that led to what you've all heard many times before, the idea of putting a specifically sound engineered wall on the west side of the building to protect for some of that sound. In addition, the entire sound system, speakers, everything that was installed at the development of the hotel as a result of that prior noise standard was ripped out and replaced completely. Changes to the DJ booth, insulating it, all of these things were done, and frankly, the impact was significant. When those changes were implemented, the amount of people impacted, the amount of complaints went down drastically. Again, we know that there are still some challenges. We'll get to that in a second, but there's no question that these changes had a very material impact on the hotel's operation and the impact to the neighbors. I alluded to it before, but I think it's really, really important to say this hotel was developed unique from many other hotels. 40% of the revenue of the hotel is from the pool deck. These are very small rooms. This hotel does not have the typical amenities that most hotels have. As a result, the pool deck operation is absolutely crucial to the success of the hotel. We've talked to ownership, going through this process, and that's why so much has been invested in making this right. So much has been done when it comes to outreach, when it comes to investment, when it comes to physical improvements and studies, because if the pool deck is modified in a way that it can't operate, and frankly, changing the standard, and I'll get to that in a second, it will do that, will likely lead for this hotel to close. I don't know what will come after, but the way this hotel is set up, it really was developed this way. You'll hear from some of our employees in a second, but there are 200 employees at this hotel, most of them beach residents that rely on the hotel. They also are very, very much invested in the success and continued changes in the hotel. It's been mentioned prior hearings and in some of the letters that we've seen that there's issues with the retail spaces. This hotel, by its definition, as I mentioned before, wanted to replace those unwanted retail elements that were pre-existing in Washington Avenue. They have set the goals of the retail on that ground floor to the highest standard. They're not just taking anybody that comes in. So that's why you've seen the retail that is there is of the highest quality, and there are several vacant units. A big reason for the vacant units, in addition to their selectivity, is the fact that everyone that speaks to ownership about coming in is asking about this very process. Is the hotel going to survive? What's going on with the planning board? So everyone's kind of on hold. So there are some vacancies in the retail. We hope that those vacancies are filled with the quality residents that the city deserves and that the hotel is looking for. Recent changes, as you can see from the history, and by the way, yes, there were violations that were issued and were appealed and were not sustained back in November. There was one violation issued, we think incorrectly, back in March. Nothing has been issued. In fact, there hasn't been one complaint, not just complaints that didn't become violations, but there is not one complaint in the system since the last meeting. And as I've said, we know that the wall wasn't installed. The speaker systems were changed. All that made a big difference. But did it solve the problem 100%? No. There's still pockets where the noise does hit some folks, and we know that. And we have continued to make changes. Mr. Chair, you in particular, and I think some others in the board, not only at the last meeting, but the February meeting, implored us, go install a sound monitoring system at these units. How hard can it be? Well, we have a system in place for that. Unfortunately, we have reached out to try to meet with the residents, and that has not been reciprocated. We would like to do that. We have hired a sound engineer to come up with a plan to install sound monitoring in the specific places where the sound is being heard. And we believe that that would go a long way in determining where the problem points are and fixing it. But without the cooperation of the folks in those units, we really can't do that. We can install it on the ground level, but we know that that's not where the problem is. So we have a proposal in place. We would encourage you to require that as a condition, and we would absolutely spend the money, time, and effort with our sound engineer to implement that. We think that would actually be a meaningful way to figure out exactly what decibel points are at issue and where. What we've committed to do and are already doing, which is evidenced by the fact that you have not seen violations, we have brought the sound level to a decibel level of between 88 and 93. We have found that with those numbers, which were done during the plainly audible standard period, we're not getting complaints. Why we want to keep the standard as it is regardless, what we learned, and a lot of you saw going back a couple of years, plainly audible, it means, and it's, again, this unreasonably loud is the standard everywhere else. Plainly audible is unique to the CUP, and what it means is if I can hear anything, and I'm sure Mr. Villar will tell you, if I can hear, because I've met with him on the site on this, if I can hear anything at all where it might be coming from a place, then it's plainly audible. Doesn't mean it's bothering anyone, doesn't mean it's materially problematic, it's just, can you hear a whimper? Can you hear something? And we found that to be incredibly challenging and impossible to comply with, and frankly, we believe would lead to the closure of the hotel because it would just create a lot of issues, every type of possible noise. And when we were dealing with that standard, by the way, and many of you that were at site visits saw this, there was noise coming from cars that was louder than plainly audible from our hotel. There was noise coming from a Latin cafe on the ground level on 7th Street, way louder than what you could hear from the hotel. Yet the violations continued to be issued to the hotel, even at low volumes, because at one point you could hear something. So we think that that is a recipe for, closing this hotel and killing the hotel. Another thing that they have done, they have in recent developments, they've partnered with Marriott. This is now a Tribute portfolio policy, property. If you go on your Bonvoy app, you can book the Good Time Hotel now. That's, again, another change, another improvement to try and diversify this property and give it, another investment that was made to make it successful, and we believe will be a positive change. We commit to continue to keep the programming as we have done. We've learned some of the programming that was done at the very beginning was aggressive, and as a result, triggered a little bit, I want to say, hype, noise, excitement that led to noise issues. We have now, and Mr. Medding here, Thomas Medding is the new GM. He's been in place for a few months now. He has done a different type of vetting of the acts that go on the roof. These are now still DJs, still entertainment, but entertainment that's a little bit more probably what the city expected when this was approved, and it's not creating violations. We believe that is another crucial step in the success of this partnership that we have with the city. And finally, what we would ask is that that you all encourage the neighbors, if they're willing, to help us with this monitoring. We can install monitoring, we'd pay for all of it. We would commit to following the recommendations of that monitoring study at the exact points where we have been advised there are problems. Then we can take that information, make changes if necessary. Maybe they will tell us that the way we're operating today is fine. Maybe they'll suggest a slightly lower decibel number. We don't know. Until we get this equipment installed that we now have ready and the consultant ready, we won't know. We also ask that we be given time for that study to happen, to come back in, let's say, 3 months with the results of that study and hopefully an agreement on how this can proceed going forward. We commit to keep everything at the decibel level that we've been keeping it at over the last month. Again, between 88 and 93 decibels, which we believe has been successful. And we also commit to keeping the programming as we have done it in the over the last couple months, which has been, since Mr. Medding's been involved, a material change in the type of acts that come that are now not generating the same type of noise complaints. We understand that this property is an enigma. It comes up in all these other discussions. We want to not only be the reason for your concern, but a catalyst for doing things the right way going forward. There's no questions that there have been incredible challenges here. I've never been involved with a property that has put so much effort and so much investment in fixing the problems. I know that perspectives on this are varied, but I can tell you that someone that has been doing this for almost 25 years, no property that I've been involved with has made such a degree of commitment on making changes. Some of them have worked, some of them have not worked, some of them have worked to different degrees, but we are absolutely in a better place than we've ever been as to this issue, and we want to continue to be successful. We want to continue to have this hotel operate modified from where we started, but in a way that is successful and can continue to operate. We don't want to close down. We don't want to just go back to the way it used to be. So with that, I would like to reserve some time for rebuttal. I'm sure that'll be necessary, and here to answer any questions that you may have.
All right, thank you. Anyone in chambers here to speak on this item? No one in here?
And Mr. Chairman, since this is a quasi-judicial hearing, do any board members have any disclosures to make? So you don't need to state any emails that you received about this application, as long as those were forwarded to staff. But in addition to those emails, if you've had any ex parte communications, you should disclose them.
All right, well, let's just start with Scott.
Well, this is an issue that's come up in front of the neighborhood, a number of occasions. So over the past few months, years, I've spoken with a lot of people, residents, surrounding residents, and other people about this. I can start running off names, but I
think when you ask for disclosure, it's with the applicant, right?
No, it's with any third party, and all you have to disclose are the names of any individuals you spoke with regarding this modification revocation hearing.
About this hearing today.
Oh, about this particular
Yes,
hearing. I
yes.
know. Just recently, I spoke with our former member Gail, and I'm trying to remember. It may have been even before the last meeting, but I know Gail for certain. I can't think of any other names right now offhand.
Whatever.
But
It's okay. Matthew?
Yeah, I've had conversations with a resident nearby, Charles Fisher, and received an email. I think most of the other my colleagues here from Andrew, who also lives in that same building as Charles.
Donovan?
I did a site visit and I spoke with the manager, Tomas, and there's a sound person there named David and a security person there named David as well.
Just the regular emails I'm sure that everyone else is referencing. Someone from the ownership group tried to reach out to me, but couldn't connect.
Same.
No disclosures.
Elizabeth?
Just Gail. No, I haven't been anywhere, spoken to anybody.
I'm sorry to hear, just Gail?
Yes, just
Okay, you
Gail.
spoke to Gail, okay. All right, again, anyone here to speak on this item? Okay, I'm sure there's people on Zoom.
We do have some people on Zoom. The first one is Johan Moore.
Good morning, Johan. Do you swear that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do. Good morning, planning board. Lest anyone think that the echo is rather disconcerting, sorry. Lest anyone think that we're unhappy about being an hour after hour time certain, quite the contrary. My heart bleeds for West Avenue, and I think much of the testimony given supports our neighborhood's position regarding profit-driven noise. I remain baffled by the bald-facedness of the attorney's articulation of the hotel's rationale, which basically comes down to an arrogation of public oral airspace for the sake of their profits, without offering to share those. Obviously, that's a rhetorical point, with the affected neighbors. I am going to urge that the CUP for the rooftop entertainment be withdrawn. We see that progress has apparently been made, allegedly been made in the past month, but we don't trust them to not revert to their previous practices. Regardless of what the board suggests or decides rather today, I really want to thank West Avenue for its very thoughtful list of reforms of the special master process, and in fact, we'll address that just briefly. Our own ongoing special master issues with the ex-Yasora slum buildings on Jefferson Avenue, we would only be plugged into that. We are only plugged into that by chance because we spotted the notification to the owner that was posted on the building. In one instance, it had fallen off of the rough brick that it was attached to. Once the neighborhood is involved in that process, it's a little easier because then we have the dates for upcoming special master hearings. But it is not easy for residents, in fact, to participate in that. So thank you very much for that. I think we probably have some of the local affected neighbors online if, in fact, the advanced hour has not dissuaded them from testifying. Thank you very much. I've never heard the board be so critical of public nuisance noise, and I thank you very much for your pro-resident perspective. Thank you.
Thank you, and just for the record, Johan, I'm sorry you waited, but we did not have this scheduled at a time certain, so my apologies for your misunderstanding. If we schedule something time certain, I'm pretty good about making sure it takes place at that time, so. All right, next.
We have Mark Antoine.
Good morning, Mark. Do you swear that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do. Good morning to everyone. My name is Marc-Antoine Demido. I live at 635 Euclid Avenue, Unit 109. I'm the president of the HOA here, and I've met with Thomas last week. I keep a channel of communication always open because I do think it is the greatest way of working a problem. Yet, I've got a couple issues from what I hear from West Avenue, from what I hear from the Good Time attorney. First, I see that the unreasonably loud doesn't work. Even if it's a standard, it's a wrong standard. It doesn't work. What we have here is a Good Time Hotel who's been silent, radio silent for like a month. No complaint whatsoever, absolutely silent, perfect. You want to change the programming or how you do things. It's not been over the past months. It's just been over the past 3 or 4 weeks since the last hearing that was a report progress. I met with Thomas. I agree with Andrew Wharton, with Charles Fisher, with all the members and homeowners here at 635. We still, and again, I'm not talking about the past 4 weeks, we still have problems with the Good Time. And I'm more than happy to work again after even 3 years working with you guys. I'm more than happy to work with you furthermore to find a solution, but we need a consequence. The consequence that we can apply is the violations being issued and not got the right legal word for that, but dismissed in special masters hearings. And this is wrong. This is just wrong, because when there's a violation, we need to be able to get a consequence out of that so that everyone is kept in line. This is just disheartening to see how much brain power and also time is wasted on those meetings to go nowhere, to move the needle nowhere. This CUP is like, again, given to a newborn, shooting right and left. They did that when they opened the hotel. And what the attorney just said is that they changed a little bit the music closer, and that's what they want to do now, closer to what the board expected when issuing the CUP 3 years ago. Well, it's about damn time.
And sir, if you could wrap up your 2 minutes.
This is my position. Again, I'm here for an hour, 42 minutes. You know, I've got 2 companies. I run 2 companies. I have 2 four-year-old twins. I have a husband, and this is all, you know, on my free time. You're all paid to be there. We do not have a way to inflict a consequence to the Good Time Hotel, and we're not paid to be here. Yet I keep the channel of communication open despite the very big resentment from the community against the Good Time Hotel.
Thank you.
We have another caller, Chris Renega.
Good morning.
Good morning, Chris.
Good morning. Yes, I'm here.
Go ahead, we hear you.
I'm sorry, Chris, do you swear that the
Oh.
testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You have 2 minutes.
Thank you. So my stance is, again, I reside at 730 Pennsylvania, number 702. I'm on the top floor. I have a direct vantage point to the Good Time Hotel. I could just be there. I don't need to be there in person because I can hear it, whether it's, you know, unreasonable, whether it's audible, whatever it is, I hear it. And unfortunately, I wasted at least 5 days of work with doing the sound trials with the city, with the Good Time, trying to be a good neighbor, hoping for a good outcome, hoping for a positive outcome. And it just hasn't happened. Again, also taking time off from work for these meetings, at a minimum 5 or 6 of them at this point. And it's really frustrating to feel that we're a hamster on a wheel doing the same thing over and over, and we're really with no result. So at this point, to have somebody come here again and install whatever, you know, decibel readers or whatever it is, it's a little bit kind of past that point, honestly, because I am not willing to put more time into this. It's been 3 years, because since day one, since they opened, it was an issue. And I have been I was really trying to be on their side and to reach a compromise, and it just hasn't happened. And I don't see how it's going to, because the wall did nothing but probably make it worse since I'm on the 7th floor. Thank you.
Thank you. Our next caller is Gail Durham.
Hi, Gail. Do you swear that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do. So my speech is really for like the 3 new members, and maybe Melissa, she's only been on there a short time too. When I served on the planning board for 2 years, the Good Time Hotel was on our agenda 18 times. So that's 18 times out of 24 months. It's unfair to the residents, and their complaints fell on deaf ears at the planning board, and that's why it kept getting delayed and on the agenda 18 times. I don't know if anybody wonders why I didn't ask to serve another term on the planning board, but it's because I felt the board did not solve any problems, nor do they create any cups that prevent problems. Maybe today is different. I hope so. I suggest prohibiting entertainment and ambient DJ on the roof of the good time, period. They can have their entertainment inside, but you know, enough is enough. I mean, come on, guys. Thank you.
Thank you.
And that concludes our callers.
Okay, close the public hearing. Questions from the board?
I have a couple.
Okay.
Um,
Mickey, you want to? Oh, I'm sorry. You have someone that.
Just have one of our employees that would want to say a few words.
Good afternoon. My name is Shayna Miller. I am the Director of Operations for the pool at the Good Time Hotel. I've had the pleasure of speaking before you guys once before. For those of you who do not know me, I spoke a little bit about myself and my commitment to my family and this job and what we do here. But I think there's a few things that maybe we can elaborate on to what happens day to day with the decision-making process that we go through, or everybody can speak on it, but I'm the one who's there every day, day in and day out, who feels the stress and anxiety behind the decisions that we make on this property. And there are some modifications that we have made. I know everybody has talked about this last month, not hearing, or having any complaints or noise issues, and that's something that we figured out along this path, right? We technically have our CUP till 8 p.m., but we found that we were getting more complaints later in the evening. Residents are home. We didn't want to impose, so we made the conscious decision to program our talent from 3:30 to 5:30. So that is when our main talent goes on the pool deck, hoping to alleviate, without being asked to, the additional noise complaints that were coming in. I don't have anything scripted here to say to you guys. I just want you to know, the amount of effort that goes into each decision that is made on the property. We're not doing amazing. I'll be open and honest with you guys about that. We're financially not doing amazing. We've made decisions just this week that, could have brought in maybe $150,000 to $200,000 worth of revenue that we turned away due to the restrictions that we have and due to the respect that we're trying to show for the city and its residents. So please take that into consideration, that there's always a conscious effort in programming, in operating at this venue. I have some staff testimony. Celeste, did you want to read the staff testimony? That was sent through that they asked me to speak on their behalf. So I'll just read the last one that came in this morning. We try not to involve them too much in this process, but it is public, so they follow it closely. I have a gentleman, and this is as open, I guess, as anybody else can be from this property. It says, "This statement will not do justice to the magnitude of the gratitude I have for this place and my place of employment with Strawberry Moon and the Good Time Hotel. Long story short, I, along with other coworkers, were in a bad place working nightlife in a new city from Texas. Couldn't catch up on bills, toxic environment, illegal substances, and all the above until I started at Strawberry Moon. Never have I worked with such a strongly tied team, like family, from upper management down the ladder. The word caring is too small for what I have described. This place took me out of poverty, mentally and financially, helped me fight homelessness. I was homeless, living in a car for over 3 months, and yet nobody knew until writing this statement today." So that's the first time that I've heard our story for him. I have a female named Yulia. All of these employees have been with us since its inception. So Yulia stated that she's been working at the Strawberry Moon for a couple of years. She couldn't be more grateful for this job. Firstly, and most importantly, this job gave her the opportunity to help her family in Ukraine. Not only is she able to send them financial help, but the flexibility and the schedule allows me to travel to support my loved ones when they need me the most. Losing this job would have a tremendous impact on me and my family. I have about 10 others, but I'm going to leave them where they are. If anybody would like to hear them, please let me know, and thank you for your time.
Thank you.
We do it before you continue. We do have some more callers now on Zoom. The first, Troy Wright.
Good morning, Troy. Do you swear or affirm the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You have 2 minutes.
You know, the last thing that Washington Avenue or Miami Beach wants is a vacant hotel on 6th and Washington. The Good Time Hotel has done everything possible to keep and to create an environment where locals, tourists, and politicians are happy. Absolutely not. But they have done and exceeded what any other developer or property owner have done in a long time. I don't think it ever will be perfect. But to be in a situation where you hear no noise from an entertainment district is nearly impossible. So we need to be reasonable about our dedication to make it work. It's simply amazing. I don't know, like I said, any other property owner, investor, or developer who would have put up or done as much as the Good Time has done. So again, if you look at the positive impact nationwide that the Good Time has brought to Miami Beach, Washington Avenue, it is exactly what we hear the locals, the tourists, and everyone else talking about what we need on the avenue, what we need on Miami Beach. So if you think, you know, Washington Avenue or Miami Beach would be better with an abandoned hotel building, then yeah, go ahead and move forward with not allowing them to have live music or have music in general. But it won't solve anything. So I think that to require them to reduce the amount of entertainment is positively a huge mistake. So let's get this one right.
I'm
Thank
sorry,
you.
Troy. Who do you work for? I'm sorry, I don't know you. I'm just.
Sorry about that. I should have said something off the top. I'm Troy Wright, the Executive Director of the Washington Avenue Business Improvement District.
Okay, thank you.
Okay, our next caller is Mitch Novick.
Good morning, Mitch. Do you swear or affirm that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes. Good morning, Mitch Novick, 36-year resident and business owner. I own the Sherbrooke Hotel in the Ocean Drive Entertainment District. For the past decade, I've appeared to speak against every conditional use permit which provided for open air entertainment, with exception to the Good Time Hotel, knowing that we would be here again today. I would urge you to revoke and let the property owner figure it out. Residents need to start getting some relief. It's unfortunate. I feel for them, and I urge you to revoke today. Thank you.
With that, that concludes our callers on Zoom. If you want to close the public hearing?
Well, yeah, I mean,
Just a
technically,
couple
I guess
minutes.
Mickey's going to rebut, and then we'll close it.
I'll be very brief, just a couple points. Again, Mickey Marrero, 200 South Biscayne Boulevard. It was said, why wait till now to make, some of the neighbors did acknowledge that what's happening now, today, the last month and change or so, appears to be working. Like, I'm happy to hear that, because we felt the same way. Again, the record shows that. Why wait till now? It's not really a wait. It's been constant changes. The wall was installed in February of '23. The speaker system was upgraded just before that. Shortly after that, in the spring, the sound booth was done. These are changes that have been constantly happening. So it's not like we waited to make a change. This particular recent change was fairly recent. But since that February 23 installation of the wall and change to the speaker system, there were no violations issued for the better part of a year. Things seemed to be working. We felt things were working. Some stuff happened later. So it's not like we were getting violations every week and ignoring them. We weren't getting violations. We made changes. They seemed to be working. We did get violations issued in November, December, 2 weekends, 2 instances. Those 6 that keep getting mentioned were really just 6 days apart during our Basel. Those were the ones that we appealed and the ones that keep getting mentioned. Again, just because it's been mentioned so many times, and I was the lawyer that handled the special magistrate hearing, there were inconsistencies in the record. There were inconsistencies in the standard, plainly audible, unreasonably loud, in the CUP itself, in the violation itself, and in the testimony. That's why they were dismissed. Sometimes lawyers get lucky and the record is there's technicalities in the record. Now, I'm not saying that there, we don't think it was unreasonably loud that day, but the record spoke for itself. There were inconsistencies, they were dismissed. Special magistrate hearings, by the way, there were hearings on this property where neighbors have come. These agendas are public, they're under the city clerk's website. Neighbors do come sometimes, it's not that common. Most of these violations are like window permits, things like that, but they are all available online, and neighbors have come to prior hearings for the good time. Finally, as to the noise monitoring, we were, criticized for suggesting the noise monitoring. That's something that came from you all at prior meetings, suggestions that we heard, and we took to light. We hired someone to implement those suggestions. They're ready to go. We have a report. I think Matt handed some of that out. We just need the cooperation of some folks to just install very, very, small little antennas to carry the noise. We think that would go a long way. It's something that came from this board that we responded to. So we really feel that things are in a good place right now. We really don't want to lose this hotel. You heard from Troy Wright. I didn't know he was going to be speaking, but I'm glad he did. This is an important part of the business district, and if it fails, then other things will fail. These units will remain vacant. We want this hotel to succeed, and right now it's not doing great, but we just want to get it right, and we want Washington Avenue to succeed. And if what happens today doesn't go that way, it's hopefully it won't. It'll be very negative for the area, and we don't want that to happen. With that, I will
So,
rest.
Mickey,
And
quick
yes.
question. Obviously, you saw the city's proposed modified CUP, right?
Yes.
And you have a problem with that?
I do. And let me tell you why. That's the standard that existed before, and there was repeated instances where we were getting violations, and I was standing there with the code officer, with staff, I was standing there with some of you, and it was just not problematic noise, but because there was a whimper that was lower in many instances than 3, 4 other things happening at the same time on the street, violations were still being issued. And it created a huge problem, and we toured the site
Well,
with
hold
many.
on, but what you handed out has plainly audible, but I think what you want is anywhere west of Washington.
No, that's staff's. We want it to remain unreasonably loud. Our handout says maintain unreasonably loud standard.
It does.
Isn't that what you handed out?
When it says note, that's what they want.
Yeah. We're showing you what staff recommended, that's our comment. too.
I got it,
Yeah.
okay.
We're suggesting the added language on that page 6, the second page of the handout, requiring us to do this noise monitoring that you all had suggested the last couple months. We have that ready to go, we just need cooperation. And then we're suggesting that the standards stay unreasonably loud. Again, we know that, we know we're in the principal's office, we know it's been a long road. We think we're in a good place right now, and we'd like to be able to succeed in that place. If it doesn't work, we'll be back here and we know what can happen. But we really feel that after years of tweaking and finding solutions, we're finally at a good place, and to get crushed at this point would be horrible for the hotel and for the area.
Did you see the city's, I guess, insertion of a distance of 100 feet?
Yeah,
Because your edit doesn't include that.
Well, the
I mean,
100 feet.
Your language was working off of a version that didn't have that.
Because
distance in there.
we got a different version from the city
That's
this
what I'm
morning,
saying.
yeah.
So now that they've included 100 feet, is that?
That's
I
the
guess
same.
operationally
It's
make
essentially
it
the same thing. That's what they,
essentially the
yeah,
same thing.
because what that 100 feet is, the noise ordinance, not just in Miami Beach, but in almost all the jurisdictions in South Florida, if you're plainly audible after 11 PM, the idea is you don't want to interrupt sleep, at 100 feet, it's a violation. That standard prior to 11 PM is unreasonably loud. So the only place that it was plainly audible prior to 11 PM was for this hotel.
So-
And it created, so it's different at night, if you can hear something and people can't sleep, it's different than if during the day when there's cars zooming by and other restaurants open. I don't know if you've been there, I don't know if I went there with you or you went with someone else, but several of you were there with me, and we were hearing noise from other venues louder than what you could hear at the plainly audible standard. And code was said, we have to issue a violation. And the 3 or 4 other places that had louder noise were not getting violations. That was, a lot went into getting the standard changed, and we persuaded the board
I'm
at
just
the time.
curious, what other venues are near the good time that could create noise that could be mistaken for the good time?
I give you the most extreme example. This is almost comical because of its absurdity. There's a cafe at the corner of Washington and 7th on the northwest side. Wonderful little cafe, Latin food, not a party, not an entertainment venue. They play music, like Latin music. We were standing multiple places. Their music was not a violation. It was not unreasonably loud per code standards, but it was louder than what we were hearing from the Good Time. Understandably, that was at the ground level, so we're, you know, the thing that we're perfecting now is this elevated noise where we got it all figured out in the ground level. It's no longer being heard on the ground level. There's still this remaining concern on some of the upper units. We think that the changes that we've made now address that. We want to perfect that with the noise monitoring that you all suggested, that we're ready to implement, that our engineers ready to install. So that's what's left. But there's the Moxie, there's the Anglers, there's lots of things that have noise around that aren't violating anything because they don't have this unique condition.
Right.
Our condition, if it goes back to plainly audible, regardless of other places being louder, we get violations. It'll be almost every day, and the hotel will probably close. That's what we've been told.
All right, let's do this. Scott, I'm going to just kind of go around. Scott, why don't I
Thank
start
you.
with you with questions that you may have?
Yeah, I mean, obviously, this has been going on a long time. You know, 3 years, it's been going back and forth. And, you know, I know what Mickey said, but it doesn't seem like there's any progress being made to mitigate the problem, which is noise. So, you know, let me just tell you, I'm inclined to change it so, you know, it's only ambient noise, can't be heard with, you know, past 100 feet, and also to take away the DJ, I guess it's the entertainment part of the CUP. And again, the reason being is we've seen over and over again for 3 years, we've seen, you know, Mickey mentioned it today, they're gonna set up some kind of monitoring things, but, you know, before that it was posting people on, you know, the residents' balconies to listen to noise. It was other kind of monitoring in the street, putting somebody from the Good Time on the corner there, sitting in the chair. It was building the wall, which, you know, we all appreciated. We thought that would solve the problem, but it seemed to exacerbate the problem. You know, it just seems like there's more noise now than before. So it seems like everything that's being done there, it doesn't seem to be working. And it's been 3 years now. And, you know, just putting it off more and just waiting to see if this works. Quite frankly, I have no faith that it's gonna work. Again, you know, if this was a relatively new case, that's one thing. But it's 3 years. It's been going on 3 years. I don't think that we as a board or even the residents can rely on the code compliance special master process to work. Because even if these things, I mean, there were six noise violations since in November and December of last year. Those were valid noise violations according to code. They went to the special master and they were dismissed, but code initially saw them as valid. You know, at what point do we as a board say enough is enough? Do we want to see 6 noise violations and 6 times adjudicated, you know, and then what? Are we gonna take action then? You know, I just think that it's enough, and I think this board has to pick up the slack where the code compliance and special master process is lacking. So at
Right.
this point, that's why I'd be
So
in
just to be
favor.
clear, are you supportive of the city's modified?
More.
More?
That, plus removing the outdoor entertainment.
Okay.
So that's where I am at, and I want to hear from the rest of the board.
You will.
I'm sure I
Matthew.
will.
Yeah, I'm inclined to agree with my colleague. However, what I will say, and there's a lot to unpack here, is that at a minimum, I think some action that we should take today, if we don't choose to go further than what staff is recommending and remove the DJ and the entertainment from the outdoor, is 3:30 to 5:30 p.m. at a minimum. that would be the only time it could be allowed. But, you know, and I thank, for example, the owner's representative saying 40% of the revenue comes from outdoor entertainment. I don't think that is what the intent was when this project was conceived, is that they were going to put basically all of the negative externalities on the public. And this kind of sheds more light on the issue of the micro units. If the indoor portion of this facility can't sustain it, then you know, we have bigger issues with micro units here and micro units proposed other places in the city. The other concern that I have is, while some of the members of the board did suggest noise monitoring and ambient and decibel meters, when I read through the report, it looks like you want to maximize the amount of noise you can make, leaving no margin of error. So even if you were able to install these remote systems elsewhere, you still have the potential for having noise that could impact people if the winds change, if it's a quiet night and there's no clouds in the sky. You know, there's so many variables there. You know, I understand the high threshold for us to make a change here, but I think it's time that this board really look at this and actually take action. So that all being said, you know, I'm in favor of removing or substantially reducing the outdoor entertainment.
Okay, Jonathan?
I'm not in favor of removing the outdoor entertainment, but I am in favor of obviously making significant adjustments. The goal to me is not to shut down the party. It's not to shut down the hotel. The goal to me is to find a solution that the neighbors don't hear a peep. You know, they didn't sign up for this, and they don't deserve to hear a peep. And so, you know, I did a site visit. I appreciate what they're doing and the changes that they're making. You know, I hear mention about no noise complaints in the last month. I don't know if that is including the DJ set from March that did get a violation. In looking at, we were sent, you know, I think everybody on the board was sent videos from online of the parties there. There was nothing, you know, to me that was surprising. I mean, we understand that they're having parties there. That's their business model. But what was surprising to me was the one day where they got the violation of the Martin Garrix concert, where he's a DJ. They had a new DJ booth set up, which is not the normal space for it. It seemed to me like there were new external speakers there, which is expressly prohibited in the CUP. And that to me is a violation. That's, you know, one of the reasons I was asking about to code about the bullet points, because, you know, yes, maybe they turned the music down by the time that code got there, but it's very clear from that video that there's speakers new that they put in just for this performance. That's a violation. And so to say, you know, it's difficult because I see everything that you're doing that's positive in the right direction, and then it's like a simple thing like that that just, to me, just undoes a lot of the hard work that everybody's been doing, and it really is, you know, unfair to the residents who have been coming to these hearings. It's unfair to the planning board who's been listening to this stuff 18 times. It's unfair to the workers who are working for the Good Time Hotel, because by having a concert, a DJ, with a DJ booth that's not your normal DJ booth setup, with new speakers that violate the CUP, you're putting all of your staff at risk. That's on management. You want to read us, you know, a heartfelt letter from your staff. I mean, you made the decision to violate that. I mean, and I don't know if they know that, but that's what bothers me. I don't want to I don't think we should remove entertainment, because it seems to me like there is a way to have entertainment that doesn't bother the neighbors. And so I would think, you know, in my conversations with Tomas, you know, we talked about the different decibel levels, and I appreciate, you know, he showed me a WhatsApp conversation, you know, of like all the staff is involved in making sure the sound is they're doing the right things. And I get it. The problem is that when the decibels are over a certain level, the neighbors hear it. And so I would propose something more nuanced than removing entertainment altogether. Number one, I think the standard should be plainly audible west of Washington. So to start, and then in addition to that, I mean, I think lowering the volume, I think based on the sound study that you guys just passed around, it indicates, you know, we just got this, so I'm skimming through it, but it indicates, you know, anything under 90 decibels really is not going to be heard. Now, I don't know, you know, if that adjusts for wind, but really a lot of these parties are much higher than 90 decibels. And so I would say that the music, you know, I propose that maybe the music be lower, you know, can't be past 90 decibels for now. And look, you know, if there's a solution that we can figure out moving forward, come back to us and we'll change it. I mean, my whole thing is, and I think, you know, I'm in agreement with Mitch Novick on this, which is that I don't care what the party is as long as it's enclosed and nobody outside the premises is hearing it. So, so I don't think we necessarily need to accomplish that. I don't think we necessarily need to remove entertainment because it's possible to have a DJ who's playing like vibey music and they're making money and they're selling bottles and selling drinks and cheeseburgers and whatnot, but the neighbors still don't hear it. So I think that's what I would be in favor of is accepting staff's recommendation. You know, I don't know if necessarily like, I don't know what big of a difference it makes to remove the DJ after a certain time, as long as it, you know, the standard is still, you know, it can't be heard by the residents. I mean, it seems pretty simple. And at the other thing I want to say is that we're in a tough position. You know, you ask for the unreasonably loud, then the unreasonably loud is unclear. Then we go back to the plainly audible, and then that's unclear. And so it's, you know, it's just, it's difficult for us. So that's my position.
I agree with most of what Jonathan said. I just have a few questions for, is he still here?
Mickey.
Yeah. So, number one, there was a gentleman here, I think his name was Charles Fisher, Mr. Fisher. He was probably the most vocal previously. Did you work with him in between last meeting and this meeting? Like, why isn't he here speaking?
No, I don't know why he's not here. We did reach out, our team reached out to him to try and schedule something. He did not reciprocate.
Got it.
I don't know why he's not here.
Actually, so since I spoke with him and I'm friends with him, he had a conflict today with work.
Okay.
Wasn't able to.
But we did try to reach
But we
out.
tried, and we offered, to, you know, we'd like to install a monitoring. His unit seems a problematic unit. We'd love to have that opportunity.
Understood. Main question, just for context here, you know, what happened, I guess? Kind of, obviously we know how the Good Time operation started to the point where all these things had to change. The Good Time was then viewed as, you know, the good apple, right? The ones that were proactively trying to reach out to the residents, fixed a whole bunch of things, invested a tremendous amount of money, got things to a place where there were really no violations, and then things escalated. You know, I think at the planning board, we kind of awarded you all the unreasonably loud threshold, and it was from that point where it was like, okay, they gave it to us, let's see how far we could take things. I think the general concern, not to put words in anyone's mouth, is we've been here before, we let you get to the unreasonably loud, you ran with it, and now we're back here. So
Right.
any type of variance from what the city is suggesting would be foolish, just to be honest.
Well, so let me backtrack a little bit, just to clarify a couple points that were made. We keep hearing 6 noise violations. It was 2 instances. One,
Even
just
if
because.
it's one with merit.
Right.
Okay.
I don't know if any have merit, but there certainly weren't 6. There was 2 instances, 3 noise violations.
say there's
But
one.
that- Sure, and then, so you say, what happened? Again, walls installed in February, March, April, May, June, the summer coming into, there weren't violations. So what happened is we thought it was working. I thought, I'm not going to have to be coming to planning board anymore on this issue. I can move on with my life. But no, things started happening, and these violations were issued in November. Again, nothing after the first week of December. We got through the holidays. We got through, all the peak times in January, February. So it felt like things were okay. We kept hearing about issues, and we kept trying to, speak to folks that were affected. But other than that 1 week, at the end of November into December, no violations were issued. So obviously, we're now addressing new things that have come up in the last couple of months, but it seemed like those improvements were working. Had there been a litany of violations, this hearing would have been happening 5-6 months ago. So it's puzzling to us why we're here. We understand that other people are affected in different ways that weren't affected before. We now understand better. And I think, Jonathan, I'm not sure if you meant, because the report we're looking at is up to 93, but we're trying to keep it in that range. We are keeping it in that range. It's locked. As far as, the monitoring, again, we think that that's a real thing, that if Mr. Fisher's willing to work with us, Mr. Enaga, other folks that are directly impacted, uniquely from others, we can hopefully pinpoint that issue and solve it. But the issue is not what it was when this started. And if we go back to plainly audible, and a violation can be issued for virtually any whimper, the hotel will end up closing. I mean, that's just the reality. We've talked to ownership. We know what the recommendation was. A lot of time is spent getting to this meeting. And for all that has happened, all the positive things that have gotten us to this point, we believe it would be a horrible shame for it to end the way it might end.
Can I ask, though, because in my conversation with Tomas, and maybe I misunderstood, but I thought that he had mentioned that there's a way for them to do well or do okay between 80 and 90, I mean, with a DJ.
The numbers I have are, again, this might be very scientific. I have 88 to 93, which is what they are having now. And again, it's not just those numbers, it's also the types of acts. Tomas has only been there a couple months, but he's been doing vetting the acts in a different way to make sure if they feel something might be problematic, the type of music might travel a different way, they turn it away. They turn away some of the more profitable acts because of concerns. But again, we're at a place where we keep fixing things, but now it seems to be working, and for it to be taken away at this point, it seems to be, in my view, counterintuitive, obviously, but that's the answer. So you would say, what happened? We weren't getting violations. If you're not getting violations, then you're doing okay. It just seems like things are going the right way. So it's just these recent instances that we've now addressed, and we're here, and we heard from some of the neighbors, what's going on now is fine, but we don't trust going forward. But we are where we are.
What happened in March with the Martin Garrix?
That was very weird to us because first of all, I was out of town, but I got the information that it happened. There was a noise warning, not a violation, and the violation that was actually issued was issued at 1 a.m., which I think was just written at that time, I have to assume, but it was for a CUP violation. You get a CUP violation if you violate the noise ordinance, but a noise ordinance wasn't issued. Obviously, I don't know.
Because a warning was issued, and then the report said that if there's a warning issued, that's a violation of the CUP.
But the language changed a couple. Either way, that was obviously an isolated incident. We're still trying to figure out exactly what happened. But what you saw in those online videos that were sent to you, those are Instagram posts. The music on the video, on these Instagram videos, doesn't even match what's happening. These are marketing videos. So they're not.
I mean, you have to admit, though, that there was a new DJ booth that's not your typical DJ booth set up in the middle of the pool deck, right?
It seemed that way to me. I didn't
and there were
hyper-analyze that
around,
video.
There were speakers around that DJ booth that were set up.
Yeah. Again, I can check with them. I'm not entirely sure what.
Well, you saw the video, so weren't there speakers set up around that DJ booth?
I trust you. I don't recall that. I'm not saying there weren't. I trust that you saw that. I skimmed. I saw it this morning. I skimmed very quickly, so I don't want to say that I saw something. But maybe there were. Very well could be the case.
Okay. I don't want to be redundant. I think Jonathan pretty much echoed my thoughts. I want to mention something. Gail and some other people keep mentioning this 3 years, and that's true. But the reason is, as you pointed out, the company and the hotel has gone through great lengths to try. And that's why it's been 3 years, because, the toughest part for a planning board, and I always say this, is balancing the business side with the quality of life for the residents. We don't want the hotel to go out of business. Washington was blighted, and I personally thought this was a great addition. That being said, you know, after 3 years, if we continue to hear residents saying their quality of life is being impacted, as much as you're trying and as much time as we're trying to give you to try, because again, we want that balance for you to succeed and yet have the residents have quality of life, there gets a point where, you know, at some point, we have to say, okay, we've given you umpteen, you know, months of attempts. And again, I applaud the hotel for all the efforts they've done, because I've been on the planning board a while, and I do agree that they seemingly have done more than most venues to try to rectify their problems. That being said, and again, I don't want to be redundant. I think Jonathan echoed my feelings. I am inclined to go with what staff's recommending. I have to believe, Mickey, and I've told you this many times, there's got to be a way that people can enjoy music at the pool deck without it being blasted out to the residents. So I don't want to be redundant. That's my feeling. And again, I do applaud, and I'm sensitive to the hotel staying in business and the employees having their jobs, but it can't be at the expense of the residents. So that's my feeling. I'm going to walk out. You guys keep going. I have to deal with something.
Can I say one other thing? Sorry.
Go ahead.
So when I was there, I did notice, you know, there's a city garage next door that previously had some sort of vegetation on the side that appeared to be stripped down. You know, the vegetation was removed. And so, you know, maybe, you know, in talking to the staff there, I mean, it's possible that made a change in the acoustics of everything. And so it perhaps, and then the other thing I noticed was that there were some speakers, built-in speakers, that I imagine were pre-approved or part of the engineering plan that were facing west, you know, the direction of the neighbors. And so, you know, I'm not a sound engineer. I don't know whether has anything to do with the sound that's traveled, but it seems common sense that the speakers should be arranged away from the neighbors. And maybe now that vegetation wall is not there, the sound is bouncing in a way that is affecting the neighbors more. So perhaps including a new sound study, or having a new sound study with that, you know, that change, structural change, might be included in the recommendations as well.
So a couple comments, but first I just had a question for you, Mickey. When you talk about the remote sound level monitoring system be set up and make the changes necessary based on some of these results, what changes are we talking about? So if you know, if you have these remote sound monitors, just clarify, like, what is this going to serve?
Well, so it's, at this point, would be forensic, trying to determine what is causing noise to be heard differently in certain locations than everywhere else. So what we've done is we have hired the sound engineer to come up with a plan, which we've shared with you, to install this equipment in the points that we're hearing noises being heard differently, and then based on that data, come up with solutions to make sure that noise doesn't reach those places in some way. That's what this goal is.
All right, so because what happens is if you guys get a level of sound that's unreasonable for one neighborhood or beyond, and this is you know, an area where it's a problem, we can't go through months and months of analyzing of what new wall we got to put. You know, at this point, it's a clear fix. The sound needs to go down, and so the problem is all these residents are dealing with these issues, and then there's these time lapse of just trying to find a solution. When at this point, it has to be a direct consequence of just bringing the sound level down immediately. So I think you guys it has been an incredible sort of learning experience for us to be working with you guys, because you guys have been out there trying to find solutions. And I think it's been helpful, it's gonna be helpful for other business in understanding, you know, how to conduct themselves. And we do wanna see you guys succeed. But going through what the residents are going through for this, you know, is really, really an excruciating process to keep going through these complaints. And I don't want to see you guys close your outdoor entertainment, so I'm against, I think we can find a solution, but at this point, you guys have ran out of chances, and so when we changed the plainly audible levels to, remind me of the wording, we went from plainly audible to.
Unreasonably loud.
All right, so I think you guys took that and ran with it and started, pushing a little further when what we were expecting is your behavior to continue as it was with, plainly audible. So personally, I don't want to take away the rights of the outdoor entertainment. We can try to modify. I want to see your business succeed. I think we as the board need to really understand what the city, plainly audible is well, and I think even in a neighborhood like mine where there's no businesses, it's not even a reasonable request. I mean, I was dealing with code compliance a couple of weeks ago, and we have a house that gets rented out for parties. And at the end of the day, we are told that as long, if I can be in my house and hearing the noise at any time of the day, I can make a complaint, but stepping out of my yard is a whole different thing. So I don't think it's reasonable for a neighborhood like this to be expecting to be any sound to be a possible complaint, just like you have some businesses that are well-intended and some are not. You have also some residents who mostly are well-intended, but you have some that will complain at anything. And so we just have to be a little bit more clear in what this means for us to be making these judgments. So
just a little out of order, but Mr. Medding, the GM, just came up to me. Well, after everyone speaks, before you make a motion, based on what you all have said, he's like to share with me something he'd like to propose as a potential compromise. If you can give us just a few minutes to step outside before you make a final motion, and maybe something entertaining, maybe it isn't. I still don't know what it is, but I'd like to give him that chance to share that after you all deliberate.
All right, so I'm done with the comments. So overall, the recommendation of the cities I agree with, but I don't think we should go back to plainly audible.
Okay. I mostly agree with all of you, especially you, Jonathan. First of all, a hotel's business model is not our responsibility. That is the hotel's responsibility. It is heads and beds. It's not a poolside party. That said, I do recognize that we live in South Beach and there's a reasonable expectation of some sort of noise, but it is not continuous to the neighbors. I also think that the Instagram posts are posted on the Good Time Hotels page. I mean, those speak for themselves. I mean, if you don't want to promote the poolside party and the Steve Aokoys and the big DJs, then why is that there? I want to go back to September 21. Larkin said, the Good Time Hotel will suffer greatly if it's not able to have outdoor entertainment on our pool deck. It will cause our hotel to shut down. We heard that again today. Larkin said the hotel's operators are adding soundproof equipment and no longer headlining DJs. That's not accurate at all. They are headlining DJs, and the evidence speaks for itself. Also, I'd like to understand why when I asked about, at the last meeting, the speaker location, if they were raised off the floor, I was told absolutely not. There was nothing projected out into the atmosphere, and that is also not accurate. I gotta say that at what point, it's sort of like you have a kid at the dinner table and they've got their phone, they're texting and all that kind of stuff, and you've told them over and over again not to have their phone and not to text. At some point, you take the phone away. So at what point does the phone get taken away? I don't know the answer, but I know that I don't want this hotel to close. I don't think it's gonna close, personally. If it was going to, the same argument wouldn't have been had over and over again. We're constantly doing the same thing. It's not fair to the residents. I would vote for ambient and not anything. And honestly, I'll tell you one more thing. I was at Casadonna on Saturday. That's ambient noise. That is also a good example of what this could be. And I feel like when this opened, everybody had really high expectations of it being a good business model, and it's not. It's extremely loud. I've heard it, everybody's heard it, and I don't, at one point, do we just say, come on. I mean, I would go with ambient, no DJ, because that was what was told in 21, but yet here we are again. It's at what point are we just, it's really frustrating. And I know the residents are frustrated.
All right, Mickey.
Yeah, no, I asked for an opportunity
Yeah,
to
go ahead.
deliberate with my client, if I could do that.
Go ahead.
Okay.
So I just want to note, I think that if the board is going to make any modifications to the CUP, I would reference the neighborhood impact review guidelines. For example, in terms of the criteria, there's several that the board reviews in reviewing a conditional use permit, including criteria number 7, a noise attenuation plan, which addresses how noise will be controlled to meet the requirements of the noise ordinance, as well as, it sounds like, most importantly, condition number 8, which is the proximity of the proposed establishment to residential uses. And it seems like that it's the residential uses that's really driving the factor of the need to modify the CUP because of the proximity of residential uses and the impact on those residents.
Let me ask you to address Melissa's comment to you about plainly audible.
So for me, that means is, do I hear the words? Can I recognize the music? And there shouldn't be any confusion in terms of where it's coming from. What would happen is code would be looking at or listening to the noise. They'd be going to the property as well. They would be ensuring that this is the same audio that's coming from the establishment, not something confused with coming from another establishment.
Mr. Chair,
There should be some
just
consistency perhaps in a
One second.
neighborhood like this for every business to have also too the same sort of, because you can't have one that has plainly audible and then it has to be
Brian,
kind of consistent.
while they're out,
I
just
agree
in
with you.
fairness to them, I think we should, they're outside deliberating, and so to have this conversation while they're not present, I just want to make sure that.
Well, I'm just getting clarification.
No, I know,
I hear
but,
what
you
you're
know,
saying.
I don't want that to be an issue, you know.
Well, that's why I could just speak a second on the issue of unreasonably loud or unusual noise. That's only defined when it occurs after 11 p.m. So right now, by having that condition in there, and that being, it's hard to enforce that after 11 p.m., there's no criteria, there's no definition for how or what's considered unreasonably loud or unusual outside of those hours. So that's why that's why I believe that the prior complaints were dismissed as special master, because there is no real standard that defines that outside of those hours.
So that's a separate issue.
So we would, putting a limit on the hours for the.
You could, right,
right.
you could, I don't know if you want- you could say,
If we ended
these
up at
requirements
5:30.
Apply except for between 3:30 and 5:30 p.m. So you could do that as well.
Okay.
And just to go back for some prior information, when this application was first approved by the planning board, the requirement was not plainly audible on the balconies of the Arcadia House, which was the closest residential property, to the establishment. However, that required code to go to the balcony. That really wasn't feasible. And then it was later changed to plainly audible on the west side of Washington Avenue.
Hi. So what we'd like to offer is some compromise, reducing the hours to something like 12:30, 1 p.m. to 6:30, where we can have the outdoor entertainment on a probationary period. Again, I heard everything that's been said. I'm trying to save this operation, save this hotel. Maybe it's 30 or 60 days on a probationary period, allowing us to keep the operation as it's been going for this time where we seem to have figured it out. Whether you all want us to do the monitoring or not, we're still open to it. The hours currently allow 11 to 8 p.m. We would reduce that to a much more narrow time of 12:31 to 6:30, which would still allow us a good portion of the time, but a lot less than what's permitted today. If that doesn't work, we'll be back and we can do what I think you were inclined to do now. But if that does work and things are okay, maybe we can continue operating in a reasonable way. That's something we'd like to proffer. If that's something you all would entertain at all, we'd appreciate it. Thank you.
You're saying, and that's, in order to agree to that, you would keep the unreasonably loud standard?
Yes, because again, we know what will happen with the other standard. It's just not, it's not going to be reasonable for us to operate because a violation can be issued for virtually anything. And it doesn't have to be a problem. And we would keep it at the decibel level that you discussed, you know, what the report says between 88 and 93 should not cause problems. Again, we're learning, every couple of months we learn new information. We're better at doing this now than we were 6 months ago, certainly more than we were a year, 3 years ago. So we'd like to take advantage of all that knowledge and all that time.
I mean, I guess here's the thing, is that it's, I think everybody's sort of in agreement. I mean, I don't think anybody is going to be keeping, or seems to want to keep the unreasonably loud. The question is whether we allow you to keep the entertainment or not. You know, the problem is if we do that, the burden's more on the residents to keep calling in these noise complaints in order to be able to notify us that it's still a problem. What I think the solution should be is cut it down for now, keep it, you know, put it plainly audible. That gives, you know, even if you have to bring it way down in the meantime, but you guys need to do a new sound engineering study. That was 2 years ago that one was done. You know, environments change, and figure out. I mean, I've seen these speakers. You know, the CUP says small directional speakers. I mean, the ones that I see, I saw there. I mean, there's some big speakers, and so something's got to change on that pool deck, and I just think that in the meantime, the music needs to be. I mean, I don't care about the party. I've said that already. It's more about the volume of the music needs to be taken down until you guys figure out a way to turn it up and blast it so that in a way that the neighbors don't hear it. You know.
All right, but so why don't you take
So
a stab
I mean,
at the motion?
I'll make a motion to accept staff's recommendations, which is to replace the unreasonably loud standard with.
Well, it's just, you can make it easier.
As-
Unless you have changes to this, it would be to adopt the modified CUP.
I have changes.
I
Hold on, but
don't
he's
have.
making a motion.
I'm making the motion to accept staff's recommendations in addition to requiring a new sound study or review of the current speakers, you know, so that staff can make further recommendations, or sound engineers can make further recommendations.
Okay, is there a second?
Sorry, Jonathan, can you repeat, please? I just want to make sure I understood properly.
Accepting this staff's
Yeah,
recommendations.
with any changes?
With a request, a requirement that they do a new sound study on the speakers.
And Jonathan, just so I understand your
We just got
motion,
one.
if you would require a new sound study, I think that also means, so that the board could impose additional conditions, I think you would be modifying the CUP, but also continuing this hearing, right, to a later date to allow you to make further
Yes.
changes? Okay.
Yeah, because listen, yes, so the answer is
Okay.
yes. The idea is that if there's a new sound study with a new layout of speakers where they can, you know, I guess it really doesn't matter, as they can do whatever they need to do, as long as it's not plainly audible. So,
Understood.
Yeah.
It's not reasonable. I'm still really pushing for, I know, I understand that we've had a bad experience since we changed it from plainly audible, where we've seen some changes that you guys took some chances that didn't go down well. But I do think it's unreasonable for the business to be, you know, given back plainly audible. I just think it opens up complaints that are not necessarily, you know, necessarily founded. So I think that if we're gonna give them another sort of chance, we gotta give them something to actually.
What standard do you think?
I keep
Good.
think we keep it to the same. I think we don't change it back to plainly audible. I think we modify their hours, we modify some of the, you know, the way they do entertainment, but I think if the moment you say plainly audible, you have, anyone can complain about anything. And then it's hard for us then to have a judgment of what is an actual true problem. And so I think there's other ways of going to it where it would give us much more clarity and allow them to know the way they're supposed to be operating.
Mr. Chair, could I ask a question of Michael? So how many, because this is before my time on the planning board and I didn't follow this as closely as some others, how many sustained violations were there when the standard was plainly audible?
I don't know if, I don't have that record on me right now. I just do believe, based upon the opposite, when the standard was put in for unreasonably loud and unusual, I don't believe that there were any that were issued during the daytime hours.
But were there any issued during daytime or nighttime hours when it was plainly audible?
I don't have that information right now.
But I mean, we've seen from in the past, 4 months or so, we've seen body cam videos from code enforcement that shows, I mean, in these people's, rooftop, where they have a jacuzzi up there, from their balconies inside somebody's unit, you can actually, even on these like little, the dinky body cameras, you can still hear the thumping of it. And I don't think there was any dispute at that point that that was from the Good Time Hotel. At a special master hearing, for whatever reason, it gets dismissed. I mean, I don't think that that's for us to be thinking about. I mean, I'm just thinking about trying to strike a balance between the business and the residents, so that the residents don't lose the value of their homes, and then the business can also find ways of being creative to continue operating. But the way that I see it is that this business, they're having new DJ parties on March 25th, right before that they know they're coming up for a revocation hearing, with new speakers and a new DJ booth that's like set up in the middle, that it's clearly going to upset the residents. So at this point, like, if there's something else that can be done, if you want to, Melissa, if you want to propose something in terms of the hours or the entertainment, I personally think that that's handcuffing them even more by removing entertainment and removing their hours. So I don't want to do that to them.
I have a question. Is plainly audible not code standard?
Plainly audible is the standard in our noise ordinance so if noise is plainly audible at a distance of 100 feet after 11 o'clock at night, that is it's a prima facie case of a violation of our noise ordinance. So in essence, what the board is discussing is adopting that standard round the clock.
Okay. I just wanted to make sure that is code standard. It's not.
It's in the code.
It's not,
yes.
Okay. Thank you.
So right, but the plainly audible here in this revised is not just for after 11.
Correct. No. My
I was
point was
just
just to
making a
say
code clarification, that's all.
that this is a measurable standard that code is used to enforcing.
I was just making a clarification.
So what do you think of Melissa's concerns? Do you think this is just going to create a situation where there's complaints every day because it's a really...
I mean, I couldn't answer that. I think ultimately...
About reducing hours. I would be for reducing hours as well, to have it during, what was it you suggested? Something about from like 1 in the afternoon to 5 in the afternoon, something like that?
What I said was 12:30 or 1. We have 11 to 8 now, okay?
Yeah, that's...
And I'm suggesting, again, in the probationary period, because I want to offer something meaningful as well, in addition we've already offered, 12:30 to 6:30. If you want to modify that, we're open for discussion.
And you'd come
But
back within 3 months for a progress report or something?
Of course.
That would be,
Yeah,
we're trying, listen, we're
I
trying so
appreciate it.
hard here, and it's
I
just
understand that.
unfair to the residents. It's awful.
But to answer your question and to follow on what Nick said, plainly audible, is the standard after 11 p.m. Things are generally quieter in the environment at night. So usually you can tell that listen, I've called noise complaints. I live in a very residential neighborhood. There's no commercial stuff in my neighborhood. When I hear noise at 12:30, my kids can't sleep. I've made a phone call. And it's, you know where it's coming from. It's
Do you
one
agree
place.
that plainly audible should be the standard after 11?
Yeah, I think so. Absolutely. That's what it is in Miami and in Miami-Dade County and in Miami Beach. The problem is during the day, there's a lot of environmental noise.
But that's why, Mickey, that's what we have. That's the problem with the decibel system, is that can identify the noise. But with a person can identify where the noise is coming from.
Well, the sound monitoring we're proposing will, it's going to try and pinpoint it.
Well, first, I would caution on, it's fine that they submitted a report, but I would say that should be reviewed as part of what was suggested by continuing this, for that to be reviewed by our peer reviewer and the speaker.
We would be
plan.
happy
So
to do
I'm
that
fine
as
with
well.
that. So I
And
wouldn't-
Mr. Chair, also, we've
Well,
requested...
hold on, just
these-
finish your thought. So,
Like I said, I wouldn't include reference to that sound study or decibels until that's been reviewed by our peer reviewer.
That's fair. And just to your point,
Hold
I
on.
think-
Sorry, I
I'm
interrupted
sorry.
Melissa. I'm sorry,
I just, these are things that we requested over the years, and we keep getting the same types of reports, and I'm not quite sure why we keep having to go back and do this over and over again. It seems that, you know, solve the problem, find the volume control, turn it down, and just, come on. I mean, this is, like I said, I'm gonna take the phone away. It's just not, it's just.
And to answer your question, I appreciate that. I know you're being sincere. I appreciate it. The problem used to be a wave. It was everywhere. Think we solve it, and then it's like, you know, a little bit of whack-a-mole, but I
What
think we've won whack-a-mole almost right now.
Have you ever heard of Acoustifence?
Acoustifence? I have not heard of it.
Acoustifence is a noise baffling system that is used in a lot of tennis courts and things like that, and it actually reverbs but the speakers are up.
Yeah.
I mean, we've got.
So I think we're happy to look into that further. I think our sound wall does that. It does reverb the sound. That's what it, you know, I'm telling you, it was way worse before. But we're open to reducing hours.
Okay, there's two things.
Yeah,
we,
yeah.
we need the hours. We do need the hours reduced. There has to be like a end to this for the residents in the neighborhood. And the hours that you guys are allowed, it has to be not disturbing to the residents. So it's not that complicated of a problem. We have two issues here. It has to end at some point, and it has to be while it's going, and it has to be much lower and much more tame. So it's not that complicated. If you guys can't accomplish that, then we're moving on, and we can't keep doing this.
I can commit to that. I mean, the hours, we suggested something. If you guys have something else, we're open to it. And we can commit, again, I know that decibels are not an absolutely exact thing, but we have a number that has been being used for the last 4 weeks that seems to be working, 88 to 93. We'll commit to keep it to that.
I think it's important to find out, which we can do by doing field testing, is go and establish on the west side of Washington Avenue at that level, what decibel level is created, what reduction in decibel levels is needed to have it not plainly audible on the west side of Washington Avenue. What does that equate to on the pool deck? So
Yeah.
we can have a
And we're
baseline.
happy to do that as well, and I think, what are you telling me? Did you want to jump in?
Yeah, Matt Amster, the same firm. The 93 decibel level was done exactly that way, with monitoring at just ground level in the neighborhood when playing music at different levels on the pool deck. And that was where the 93 was determined. So that the same will happen, and if we can do it, you know, ground level is one aspect, but this rooftop area is the extra piece that needs to be addressed. So, but it would definitely happen that same way. We would get the monitoring, propose, you know, write up a report with our data and then suggestions, submit it for the peer review, and then come back to you all.
And I think, did you say the hours?
Yeah, one.
What's the time?
So
What would be the timeline on that?
It'd have to be
Just-
2 months. We need 2 months for it to be reviewed.
And I think we just got confirmation. I just wanted to make it, you know, very meaningful. 1 to 6, not 12, 13, 1 to 6 would be the entertainment, would be the unreasonably loud. Not, that takes away 2 hours from 6 to 8, that takes away 11 to 1. So really, it's a lot less time. And again, we don't think we're gonna get complaints because we think we figured it out. We really feel that way, and that's why we're really trying here. But if the hours are meaningful, I would commit to that as well.
The problem is, I mean, early on when this first kind of got re-brought up again, I think Mr. Fisher was saying that it's not, the hours are the hours, but it's the fact that it's like every single Saturday, and, you know, he wouldn't mind like one Saturday a month or something like that. But that's why I have an issue with the hours, because yes, thank you for shortening the hours. That's a start. But having it every single day, and certainly every Saturday for the residents in the meantime, while we figure this stuff out, I would just propose, and you know, it's not to me, like, if we can cut down the noise, I don't care if you have it at the standard is unreasonably loud, and we come up with a solution. So it's not about finding a way to violate you guys or have a noise violation. So, you know, if it's about doing another sound study, coming back in 30 or 60 days, I'm fine with that, and I don't need to change the unreasonably loud. However, I do think in the meantime, the residents shouldn't have to wait another 60 days before the music is turned down. You know what I'm saying? So as long as the music is turned down, and for the next 60 days, you know, the residents aren't hearing it, you know, I don't, we can kick the can down the road a little bit
We-
more.
And we commit to keep, again, what you've had for the last month at least, because again, it's not like, why wait till now? The changes are always happening. We feel we're in a good place now. We're committed to keep it at that level that we've had it for these 60 days.
But you haven't been at a good level. I mean, there've been complaints.
There hasn't been one complaint since the last planning board meeting, not one.
Well, March 25th.
I know, but I'm
It's
just telling
a
you.
few
the-
days,
But,
you know.
but since that day, there has not been one complaint.
Look, we're getting back into where we've been the past 3 years. Sound
Right.
studies, decibel levels, and all these, and I said it last time, it's like playing games. It's just, in my opinion, it's a delaying tactic. That's all it is. I understand we're probably not going to get to the point today where we're going to take away the entertainment license. I count numbers, I see that. Plainly audible is, you know, if that's the best we can do today as a board, I'd make that motion. But, you know, I don't, we're doing what we've done the past 3 years, I guess, the last 18 meetings. Sound studies, posting people, talking about what the level should be, decibel levels. It's just round and round and round. And meanwhile, residents are complaining. I don't think that if we changed it to plainly audible, we're going to have a lot of unnecessary or invalid code compliance complaints. We may have more, but that's where code compliance comes in. If they
And
go
it
out
could be
there.
100
and
feet from a building, the closest building, which I think would
It
be
should be
more-
anywhere west of, on the west side of
yep.
Washington
Mhm.
Avenue.
Was it better
If-
sorry.
I was just going to say, if code compliance goes out there and they hear noise, they'll have to determine where it's coming from. If it's not coming from the good time, they won't get a violation.
But what I will tell you, and again, I think some of you that were there recognize this, there were, during the time that we were plainly audible, there were times where we were out there with, I don't know if you were there, Manny, but with code, I was there with code officers, myself. On the weekends, I went multiple times. We would hear a noise, 2 or 3 places discernibly louder than anything heard from our hotel. Yet we were the one getting the violation,
And you were
not
there
the
with
other
code
hotel.
at that point?
Yes.
And they determined it was coming from your property and not the other place?
They said, I can hear, and again, I'm just telling you what I was there, and I don't think it was you, but there was other that I was with, and our manager at the time. I was told multiple times that because your standard is different, even though I'm hearing that, and that louder than you, they're not in violation, you are. I have no choice. I know it's not fair, but I have to give you a violation.
And you're using
And
a
that happened.
decibel level,
That-
right? You're using decibels?
This was not decibel, this was a plainly audible standard. We were given violations when other people were louder during these hours.
I would suggest that we modify as was suggested and to continue the revocation modification hearing for 30 days to allow some comment. In the meantime, we're planning on having the sound study submitted, peer-reviewed, and then reviewed further in 2 months. But it would allow you and the board to review any sort of complaints that come in. In the meantime, if the board changes the standard to plainly audible between now and the next month's meeting.
Would you be able to have a speaker study as well to see that it
Well, that's what they'd be doing as part of the.
No, that it conforms to the same layout that was originally submitted in the
That's going to be
plan.
all done as part of the sound
Okay.
study.
All right,
yes.
all right, we're going to move on. Jonathan, will you restate your motion, which I think is in line with what Mr. Belush suggests? And we're going to vote.
It's a motion to accept the staff's recommendation and to leave the modification revocation hearing open for 60 days.
I would suggest 30 days to allow us to hear input on any sort of complaints that occur between now and next month due to the change in the audio standard.
Okay, for 30 days. And do I need to mention the sound study?
Yes.
So in addition, there would be a sound study and peer review of that sound study with recommendations.
Right, and then the board could make any modifications as they deem are necessary next month or the following month.
Okay. All right, do we have a second?
Just real quick, remember that study can't happen in 30 days.
No,
There's no way.
No, we're saying,
Oh,
right,
they're
we're
not.
not saying that. We're saying that the board is going to review any noise complaints that happen between now and next month.
Sure.
So they can see how this standard is working. But in the meantime, the idea is planning on having the sound study submitted, peer-reviewed, with recommendations in 60 days.
And you are modifying hours, is that correct?
No, not based upon,
Are you modifying hours, Jonathan?
no.
Well, in the staff's recommendation, it's just after
Oh.
8 PM is ambient only.
Right, we're modifying only as we had recommended, which is the The DJ is only permitted between 11 a.m. and 8 p.m. But we're keeping the standard, we're changing the standard to plainly audible.
All right, that's the motion. Let's move on. Do we have a second?
I'll second it.
Good, okay. Let's vote.
All in favor?
Well, let's just do we'll vote. Roll call.
Ms. Beebe?
No.
Ms. Lafone?
No.
Mr. Clement?
No.
Mr. Goldman?
No.
Mr. Elias?
Yes.
Mr. Frieden?
Yes.
Mr. Edelman?
Yes.
The motion
Wait, hang on. I want to change. Well, it needs 5 votes, doesn't it?
Yes, it needs 5 votes.
Okay, that's fine.
So the motion fails 4 to 3.
Okay, so please articulate your opposition, or do you want to make a new motion?
My opposition is due to the fact that, while I agree on merit with what Jonathan said, I think we're going to end up in the same place in a month from now.
Right, but what?
Unless we can get to a place where code, city agrees, we can objectively identify that it's coming from the good time or not, we're just going to end up in the same place. That's my issue with it. In my
Right,
opinion,
but-
the motion as stated
Right.
is essentially just saying, okay, you're going to get another.
Okay, what could the motion add that would satisfy you?
It-
Because it sounds to me like we're not going to pass any motion today, and it's going to sit where it is.
So what, again, I don't know if there's an appetite from the board from this, but I would like to see a major restriction on hours and possibly frequency for their DJ, time slots, while still keeping the sound level to being unreasonably loud. So I
Okay,
don't know
well,
if
why don't
there's-
you make a motion, and we'll see if it passes? Because I know that's Melissa's concern, so.
Well, just to get some additional input, I think you also had the same type of feedback, so what would you suggest, and I can include
I would
it?
support that. I would support the 1 o'clock to, what was it, Melissa? 5:30?
They were suggesting 1 to
You
6.
guys suggested 1 to 6. I would go to 5:30 since it's dinner time and people are trying to come home, but it is, are you restricting it only on the weekends? Is it during every day? What are
Well,
you?
so what I would like to see, and again, this is
I want you to please make a motion. No, I'm serious, we got it.
All right, I'll
crystallize
make-
It's a
and
pretty
move
big
on.
deal.
I know, but I want him to make a motion, and then we'll hash it out.
All right.
I just want to say that the reason this took so long to come back is because the Good Time Hotel couldn't agree on what unreasonably loud meant. So can you tell us that if a resident can hear the music from the Good Time Hotel at any time, from their balcony, that's from the Arcadia House or any of the other complainants, from their balcony, if they can hear that, is that unreasonably loud?
Isn't that a
Well,
code
that's
compliance
also plainly
question?
audible, too. It's the same.
I think if they can hear it inside their unit and with the windows closed, that's probably unreasonably loud. That's up to code to decide, but probably yes. But if someone's outside and they're a block away, that kind of goes towards plainly audible. If I'm outside and I can hear a little bit, that's probably not unreasonably loud. If it's blooming and you're outside,
Right, where it's
maybe.
plainly audible.
And that's the problem. You're never going to have another violation with them again, and there's nothing, residents are going to call, they're going to say, I want to have my windows open. I hear the umsa constantly. It's only 1 to 6 now, but it's every single day, and we're going to get it again. But
isn't that the whole, the whole noise level, isn't that part what we're dealing with right now with all this decibel stuff, is to make sure that it's not that kind of loud, They should be able to hear, to put on some music, and I should be able to go on my balcony out there and it not be disturbing. I could maybe hear it in the background, but not be disturbing. And I'm not a sound technician, but there's somewhere between these that there's not an exaggeration.
I believe, and I think the last month has shown, because that's when we've, found this sweet spot with the decibel levels that we are now at. And, again, the hours, I recognize that really hasn't been the issue, but we're willing to do, to limit potential exposure. With the decibel and the hours, I think it's gonna go an incredibly long way.
That's also not true. The hours have been the issue, and I think the frequency has been the issue.
No, understood. I mean, I was just saying, he was saying that that's not been the main problem, but we think combination of it is part of the problem, and a combination of all those things will go a long way to addressing this and getting it where it should be.
All right, so I'll take a crack at it. Actually, but before I do that, I have an operational question. How often do these parties happen? I know what Mr. Fisher was saying is that it's every, I'm just using him because he had the videos. He was incredibly thoughtful about this. I wish he was here. How often were they happening?
Friday, Saturday, Sunday is when the events
Every
are.
Friday, Saturday, Sunday.
Basically, yeah.
And not
Saturday seems to
Thursdays.
be when, whatever reason, most of the violations happen.
When?
Friday and Sunday, it's a little bit less.
Saturday? I think he said Saturday.
That's
think-
when we
right,
have
that's
seen
what
more
Mr.
violations.
That's what
More
Mr. Fisher kept on
complaints.
referencing. I think it was every
But-
Saturday.
But
Right.
these events do happen Friday, Saturday, Sunday.
And you're not
There is
gonna have
music.
these
There is
big-
music during the week, but there's less people, so it's less problematic.
Yeah.
Yes,
Yeah.
go ahead.
All right, so I'd make a motion to accept what staff recommended, except for modifying the following hours.
What section are you?
Section 10.3.
Okay,
So, number one, the level for audible, it should be in not unreasonably loud, with hour restrictions 1 to 6:30 p.m. Instead of Friday, Saturday, Sunday, I would say that it should be Saturday and Sunday. And it should happen no more than twice a month. And that's what I would try and proffer.
Now, the applicant said 1 to 6. Are you okay with that, or do you want to go, because you said 1 to 6:30?
Oh, sorry, originally I think they said 1 to 6:30, yes, 1 to 6.
So 1 to 6 is allowed for the DJ and entertainment level, Saturdays and Sundays, 2 times a month,
And
2 weekends a month.
Correct, and specifically, the volume shall not exceed, was it the 90 or 93 decibels?
You can't, that's impossible to do that. They just said it.
Impossible.
We shouldn't place any
Okay.
decibel.
All right,
all right, and the sound study that we previously.
and the
had.
sound study that we previously
Okay,
suggested.
do we have a second?
Can I make an amendment? Can I offer an amendment? We were gonna come back in 30 days, but I would also include in there the 90 days as well. Like a 90-day, leaving it open for 90 days, because I mean.
I agree.
Okay.
And this is plainly audible, or it's
No.
plainly audible?
This is unreasonably loud, so
With
we're
these
cutting down
modified
the
hours.
frequency, we're cutting down the hours. And again, I don't even know if it's okay with the applicant, but just trying to find some middle ground for everybody.
All right, is there a second?
Can I ask a question before you vote? I know we're going back and forth again. I believe Michael stated that plainly audible means that you can understand the exact song, you can hear words.
You can hear words, you can recognize that it's not just some sort of fuzziness in the background. It's recognizable, yes.
So it's not just hearing the bass in the background, that's not
Well,
plainly audible.
That could be something that if it's something that's really thumping, that could, I believe.
Is plainly audible also conversational, or, I mean, I'm sorry to keep doing this,
No,
but
I understand.
But
I-
I'm just.
But the last, we just tried to do plainly audible and it didn't pass.
No, the
so-
conversational, that's ambient versus entertainment. So ambient noise is low music in the background that doesn't interfere with a normal conversation. Entertainment is louder than that.
I think going this direction, I mean, it allows us, it gives them some room to again, improvement, and again, it allows for the neighborhood to have some expectations of things getting better. But I mean, there's always a chance of if you guys,
All right,
don't
guys,
follow it,
we've
we go back.
discussed this to death. There's a
So-
motion. Do we have a second?
I'll second the motion. I'll
Let's
second the
vote.
motion.
No, we have a lot more to do today.
Mhm.
We gotta move on.
Okay, I'll do a roll call. Ms. Latone? Mr. Goldnoff?
Yes.
Mr. Elias?
Yes.
Mr. Frieden?
Yes.
Mr. Needleman?
Just because I don't think it goes far enough, I'm voting no.
And Mr. Cement?
Yes.
That motion passes 6-1.
Okay, where's Mickey?
And now if we can have,
Matt, you got all the, you got all the details? Oh, there
I
it is.
just have
I
one
thought you walked
clarification.
out.
So I appreciate everyone trying to find a solution here. So it's unreasonably loud, 2 weekends per month only, only on Saturdays, Sundays. I understand that, but.
And 1 to 6.
Right,
And
right.
don't come
Got
back.
that.
We don't want to do this again, because
I-
honestly.
we're gonna,
We
we have
have
separate
to.
motion.
Well, I
now.
mean, I'm just.
Hold on.
But
Now we
the only
need
thing I
a-
want to clarify
Now we
on-
need a separate motion. What?
So it's 2 weekends per month, but on the other weekends, we can still have it, just it's ambient, is that my
Correct.
understanding?
On
So
the other weekends, it's
just not
ambient
unreasonably
only.
loud?
Correct.
Okay, so it's not like it's closed?
Correct.
Okay.
Correct.
Understood. And you wanna-
And now if I can get a motion to continue.
Melissa, wait,
do we-
Elizabeth, we need you for a second motion. Sorry. We
If
need
I
a
can
second
just get
motion to bring them
A
back.
motion, right, a motion to continue the revocation modification hearing to the May 28th meeting.
I thought we said it with 90 days. So.
I thought you were doing both.
Yeah, I
I
thought
thought you
we
were
were
doing
doing
both.
both.
Sorry. All right, so moved.
Can we
Second.
do them both in one motion?
We might as well.
All right.
yeah.
Second.
All right, we have a second. Anyone opposed? All in favor? Yes. Anyone opposed? Okay.
Okay, thank you.
No problem. We're going to take
think we're gonna
a
take
half
a
an hour
break
break
for
for
lunch.
lunch anyway. No, don't worry.
30 and 90.
39, right.
Please take your seats. The meeting is about to begin. Please stand by. We are going on air in 5, 4, 3, 2, 1.
Okay, everybody, welcome back to the continuation of the April 25, 2024 Planning Board meeting. I have a question. Is the people that are here for the lot split, are they here? Yeah. That's you? Yeah. All right, okay, we're gonna go forward with that. I was gonna move it out of line, but we'll go forward. So we're on Planning Board File 230647, single-family home lot split subdivision on 920 South Bay Shore, actually 900, 910, 920 South Shore Drive.
And this should hopefully be much quicker than the items earlier this morning.
Can you promise?
Yes, I promise.
I promise too.
So this application's been filed requesting a division of land lot split to divide the existing site comprised of 3 platted lots into 3 individual buildable parcels. And this staff report begins on page 83 of the board packages. As noted in the report, this site comprises 3 platted lots with a total area of 33,367 square feet. The property is zoned RS3. The minimum lot size for the RS3 zoning district is a lot area of 10,000 square feet and a lot width of 50 feet. After divided, each lot will consist of between 10,954 square feet to 11,308 square feet for the corner lot. And they will each exceed the minimum lot width of 50 feet by between 68 feet to 69 feet. So if you look at the analysis provided on page 90 of the board packages, you can see how this lot really is an anomaly and that all the other lots that we looked at in this area consist of individual platted lots. This is the largest lot, which is comprised of 3 lots. So as split as proposed, it would actually be consistent with the remainder of the lots along this area.
So actually more consistent.
More consistent, yes.
Okay.
Right now it is out of character, as it is too large. So we do an analysis of the square footage of the surrounding neighborhood, in this case, these waterfront parcels. We know that the average unit size is about 30%. Now, the planning board, as part of their discretion in approving a lot split, they can place restrictions on the sites or future development on the sites. Typically, the board will place a condition saying that the homes do require going to the DRB, Design Review Board, for approval, and the board will typically say that they shall not request any variances or waivers. Also, the board can take a look at the size of the home and lot coverage and can recommend changes to the unit size and lot coverage compared to what the code allows if this was not a lot split application. So as part of our recommendation and review and analysis of the surrounding area, we are recommending that that the unit size be capped at 45% versus the 50% that's normally allowed. We don't have an objection to them going to the maximum 30% for lot coverage for a 2-story home, but we are recommending that they reduce the overall unit size for each of the new homes down to 45%. And that's included in our conditions.
And is that for consistency with the other?
That's typically what the board has done in the past. If the neighborhood character has a unit size of around 30%, which is typical, there are some instances, for example, on Palm or Hibiscus Islands, where we have had cases where the DRB in the past allowed a unit size of up to 70%. When you do analysis of certain neighborhoods, you'll find that the established character is more towards that 50% requirement. In that case, staff and the board has not recommended, lowering the unit size. But we feel in this case, a unit size cap of 45% would be more consistent. It's still much larger than what's there right now, but when you're factoring, additions to the existing homes, we feel that's appropriate to cap the unit size at 45%. That'll turn it over to the applicant for their presentation.
It's all yours.
Good afternoon, Mr. Chair, members of the board, staff, Michael and Nick. Happy to be here and cozy with you all in this tighter room. Nicholas Rodriguez, Burke, Howard, Del Fernandez, Larkin, and Tapinas, 200 South Biscayne Boulevard, representing the Luis Jose Moya Revocable Trust. That's Mr. Moya's property. And I'm joined by Julian Legajard. He's our designer. Mr. Moya should be on Zoom if he made it through this morning's hearings. And my colleague, Mickey Marrero. We do have a digital presentation, if we could just call that up. So I think staff summarized the area and the lot split pretty well, so we'll just get into it. As you can see from the aerial, the lot is completely incongruent with what's surrounding it. We're a waterfront lot on the north side of Normandy Isle, and we're a corner lot at the intersection of Jones Street, so we don't have a neighbor on our east side, and we have a neighbor on our west side. That home's currently under construction, and you'll see the plans for that shortly. So just to summarize the proposed lot split, the current lot is 33,367 square feet. It's by far the largest lot in this neighborhood. I think it's the largest lot on all of the Normandy Isles. We've done a few other lot splits in the area. This is bigger than those. The three proposed lots are around 11,000 square feet. Two of them are 10,954. The one at the corner is slightly larger. And what I call the standard lot in this area is 10,200 square feet. And it's basically what a typical one square lot would be. Some of them are a little bit larger because they're along the curve, but a typical lot is 10,200 square feet. So we're slightly over that. We're actually pretty significantly over the minimum in the neighborhood. So getting into the proposed homes, and Julian will give a brief design presentation shortly, but there's just a couple things I wanted to point out, that they're high quality designed homes. They're unique in that they're not designed exactly the same, each one. And the front setback, which we're looking at the rear of the property here, but the front setback of the second story, we're providing a 40-foot setback rather than a 35-foot setback to try to mitigate any adverse impacts of the larger sized homes. We are proposing homes that are at the 50% unit size, consistent with the underlying zoning district regulations. And what the code says is that we try to mitigate any adverse impacts. We're trying to mitigate any adverse impacts by setting back that second story and not looming over the street. You can also see from the design that the massing of the home is kind of broken up, consistent with what the code requires. And the homes are currently designed in a manner that does not request any variances or waivers.
Are these spec homes?
So one of the homes is for the owner to live in, and then he plans to sell the other two, yes.
So they're spec. They're not custom homes for buyers. They're
Well, these have been, we're presenting a design that has actually been pretty well fleshed out. Eventually a buyer will come and they could propose to change things.
Yeah. Got it, go ahead.
So we did do neighborhood outreach. We prepared a letter. Julian actually lives in the house. He hand delivered the letter to the neighbors with plans and our proposal. So far, we did not receive any objections. We didn't receive any response at all. So we're interpreting that as we're not aware of any objections to this lot size or our proposed unit size of 50%. As staff mentioned, they did conduct an area analysis. I think it's pretty clear, it jumps out at you from the aerial how incongruent this lot is compared to the rest of them. And this neighborhood in particular, most of the lots are single lots. Some neighborhoods, they're double lots along the waterfront or 1.5 times lots along the waterfront. Most of the lots here are single platted lots, consistent with what we're doing. We're following the existing underlying platted lot lines. So we're really restoring what the condition should be and what the condition is in the rest of the neighborhood. With respect to unit size, we are pushing back on staff's recommendation of 45%. When you look at the raw numbers of what the unit sizes in the neighborhood are, you see that any home that's been built in the last 60 years has been built over 45% unit size. Typically, people aren't building newer homes at below 45% unit size, and that's because the needs for new homes has changed. Modern homes are typically larger. It's possibly because kids are staying in their homes longer, living with their parents longer, things are less affordable, so they need more space to accommodate sometimes adult roommates, as I like to call them. But we are proposing homes at 50%, and we wanted to point out that there are 3 homes just within the same neighborhood that are at 50% and another home that's at 47%. And we're gonna go kind of go through those. So the home that's right to our east, our immediately adjacent neighbor, just is finishing or completing a renovation. And this property was noted as vacant on staff's analysis because it's under construction, it's not completed. It's about to be completed. The unit size is actually 54%. It's greater than the 50%, our immediate adjacent neighbor. So we can't impact them with a 50% unit size home if they've actually got a bigger home than we're proposing. I believe they got that 54% because it was a renovation of an existing home. When you look at the plans, it's essentially a new home. Similarly, the home at 860 South Shore Drive, it's a modern style home proposed at 47% unit size. It's actually the second largest lot in the neighborhood, less than half the size of our lot. So the unit size isn't all the way at 50%, but still greater than the 45% that staff is proposing to limit our property. And just down the street at 770 South Shore Drive, it's a 10,200 square foot lot, one of those standard lot sizes that I mentioned earlier, and they're at exactly their 50% limit. These are all within, within the area analysis, within the same street of the property, and they're all homes that have been developed since 2021 in the recent trend. Any other home in the area has not, it is, I think the last home was from 1960, so more than 60 years old. So with that, I will turn it over to Julian to give a brief design presentation. And here you can see the renderings of the homes in context. I just wanted to point out the home at 930 South Shore Drive, our immediate neighbor, that's at 54%. You see the photo there. And then you see 860 South Shore Drive at the top of the screen, the top of the image. So these homes really, even at their 50% proposed size, are not out of context with what's existing. And in fact, staff's report expressly said that the homes were not incompatible. So we were a little bit surprised to see the 45% proposed unit size restriction. So, Julian.
Good afternoon. I'm Julian Lejard from Lejard Studio, and I'm the designer for the three house. So as Nick mentioned, this is the second time actually we live on the island. We're currently actually with my wife. We just moved to 900 South Shore. We love the island, and we fell in love actually with a lot because there is a lot, it's an oasis. So our goal through the design was to really respect the integrity of the lot and capture the vegetation and the landscape. So for us, our approach was focusing on designing homes that also resonate with human scale. Because as you know, we have one gigantic lot right now. It could be built, at a 15,000 square feet, but no, we prefer something that is more human scale. Jose, the owner, is going to live on the right-hand side, and we want to have 3 different houses that respect the environment but are not the same. Even it's like we're going to design it. We have 3 different approach for each of these house, so we can break kind of this repeat process where you always see the same type of house. So our goal and our approach is to have a lot of vegetation, create an oasis, and have different type of architecture for each of those lots. So our goal is, I'm sorry, our goal is to create something, as I've said, that is human scale. Each of these houses will receive personal attention to ensure that every square footage is purposeful and conducive to comfortable living. And our aim is to create residencies that seamlessly blend with the natural surrounding, utilizing a lot of natural materials and preserving as much greenery as currently present on the lot.
These are the 2 renderings of the homes from the front and from the rear. And then this would be our proposed modified condition of approval. And one thing we just wanted to point out is just, previously the maximum unit size was 70%. It was brought down to 50% some years ago. So there are homes in the city, larger, much larger than 50%. And what we're asking for here is just to be able to develop these lots consistent with what anybody else would be able to do with a vacant lot. This property owner actually owned 2 of the lots, purchased the 3rd lot. It's a vacant lot, essentially next to the house. You can see it on the aerial. And if he would have never unified the site, he would never be facing a potential limitation on the unit size. And if we just think about the logical outcome of a future homeowner here, what we're going to do is limit the value of someone's future home that they will eventually sell, or maybe multiple owners down the road. Their value is going to be limited over a 5% difference in unit size, which really amounts to 500 or so square feet, which is imperceptible from the street, and actually makes a big difference for an architect who's trying to design a home. That's an extra bedroom, that's larger closet sizes. These are things that are valuable to homeowners and have 0 impact to anybody who's standing on the street. They cannot tell whether a home is 500 square feet larger or 500 square feet smaller. So with that, we respectfully request approval of the lot split with this modified condition to allow for a 50% unit size. And we're available for any questions. Thank you.
Okay, thank you. Anyone else in chambers speak on this? Anyone on Zoom?
There's nobody on Zoom. There's actually one person on Zoom, David Alschuler.
Hi, David. Do you swear that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You have 2 minutes.
Thank you.
I live at 955 South Shore Drive, across the street, a couple houses over. I've actually lived in Miami Beach since 1971. I've lived in my current residence since 1991. I'm not opposed to the splitting of the lot into 3 lots. I do have some quality of life concerns. The first is that there's not supposed to be any demolition or construction before 8 a.m. I walk my dog between 6:45 and 7:30 every morning, and just about every project, the construction and demolition starts way before that. I hope the city's going to enforce the 8 o'clock rule, and I hope the owner will too. Every construction project on this island causes ridiculous parking problems. The trucks, vehicles all park in the street. There's a lot of speeding, stop sign running. There's no enforcement by the police. And that parking situation is a little bit of a curve. It's going to cause a hazard, a dangerous condition. I hope that the city and the owner and the builder is going to take the proper precautions to prevent any accidents. The building department has caused unnecessary flooding in the 800 block by the way they allowed driveways to be built. And I certainly hope that on the 900 block where I live, the city is not going to allow the driveways to be built in a way that will cause flooding. And the last thing I want to say is that there's a project next door to this proposed development, and it's taken at least 4 years. It's still under construction. It appears that every time they run out of money, they stop working on the house. It's taking forever. And I hope that this project, the 900, 910, 920, will be done in a sufficient amount of time and not go on and on and on forever. That's what I wanted to say, and I hope the city's going to enforce their rules.
Thank you, Charles. Is there any, do we need to put a condition about the time of construction?
No, because that's regulated by the building department.
Okay.
As well as there's a requirement for a construction and parking management plan. That's something that's added as a condition of the DRB approval, as well as it's
All right,
required by
so
the
that'll
building
be
department.
addressed.
Right.
Okay.
And there's no other speakers, if I could just provide some comments to what's been stated in
I'm sorry,
terms
you
of the
said there
unit
are
size.
no other speakers?
No other speakers.
Oh, great. Then I'm going to close the public hearing. Go ahead.
Thanks. So just to clarify, the city's never had an as-of-right increase of 70% unit size. The code was 50%. It did allow, through design review board approval, you could make an application to DRB and have the DRB could approve up to 70% unit size. That ended about 10 years ago. And from my recollection, no properties on this island received approval to go above 50%. They were all approved for areas and on the islands, the Venetian Islands, Palm Hibiscus. Those are the areas where the DRB did grant a higher unit size. Regards to the property next door, they cannot go above, there's been no approval to go above 50%. I'm not sure where the numbers come from.
It's from the building permit plans, Michael.
Show above 50%
Yes,
building?
it's an architecturally significant home. I think they
Okay,
took
so yeah,
advantage of those.
so there is a provision where for the renovation of architecturally significant home, as a incentive to retain that home, then administratively, staff can approve a unit size of up to 60% and lot coverage of up to 40%. And then lastly, regarding the.
But as a matter of right, Michael, they can go to 50%?
Who, the applicant?
So you're recommending 45%?
Right.
They want 50?
There's no as of right because it's a lot split. So the board can institute any additional requirements they wish in terms of the.
Right, but remind me why if existing homes were allowed to go up to 50%, why you're suggesting 45?
Because that's to be more in line with the established character of the neighborhood. One of the criteria that the board looks at in terms of reviewing lot split applications is to review the massing studies and review the
Right.
That's why we provide the overall average and mean unit size for the neighborhood, so the board can determine
Right.
whether or not the applicant's proposal is in line or maybe out of character with the neighborhood. Our typical recommendation is if the average unit size in the context area is the typical average citywide, which is 30%, then we feel a 50% bump in that is appropriate up to 45%.
Okay.
And then lastly, just to clarify in the setbacks, You mentioned that there was an additional setback provided for the second floor. That's a code requirement. So the code allows you to have a garage or a single-story structure at a setback of 20 feet, and then any second floor portion has to be set back 40 feet. So that's something that is a code requirement.
Okay.
And Mr. Chair, just on that one issue, we agree with everything Michael said, essentially, that 70%, again, it wasn't as of right. You had to go to DRB, but before Nick was a lawyer, I had to do that many, many times for DRB applications, and oftentimes we would get 68, 67%, maybe not in this neighborhood, but everywhere. And what the city commission did in 2014, they said, okay, no more of these increases. We want everything at 50%. I recognize when you do these analysis to see if there's a compatibility issue, but really what we found is that every home that's been built in the 2000s is more consistent with the 50%. If you look at the average, yeah, there's homes from the 50s and 60s in this neighborhood that are in the 30, 35% range, but that's not the current trend. So these lots are actually slightly bigger than the average lot size in the neighborhood. So we really see no reason why these 3 lots should be different from everybody
But
else.
I think what Michael is saying is that you may be right that the more current homes are, but he's saying in the context of the existing neighborhood.
Yeah, but these are going to be, every new home that's been built is in the 50% range, and there's one that's more. We just want, there's really no reason, that I see,
Is that
for these
true?
3
All
lots
the-
to be
every-
different.
Every new home that's been built?
Yes.
That typically, when people come in to build a brand new house, they're pushing the limits and going to almost the maximum.
Well, yeah, so if there wasn't a lot split issue, if someone just bought a lot in there.
Right.
Would they be able
They
to go
could
to
do it to
50%?
They can go to 50%.
All right, so it's only because they're seeking a split that we can, okay.
Can I ask the designer, what would be the impact of the 5%? So like from your opinion?
It's really about the usage of the house because, we're always struggling upstairs, to put like an extra bigger closet, like, the size of the rooms. And what we realize, we're always short by, a couple hundred square feet. So while from the outside, these 500 square feet are not really noticeable, I guarantee you when I meet with Mrs. and I tell her, hey, you have to shorter your closet, she's telling me like, no, I want a bigger closet so I have a smaller room. So it's more about the pragmatic approach of the interior of the architecture. So those 500 square feet for the usage of the house are very important.
So I guess from the outside perspective, it's like 500 square feet.
Yeah, it's barely noticeable, and that's why I agree with Michael. It's the code. We respect the code, so all the setbacks are respected. We're going to enclose that with a lot of landscape. So really, from the neighborhood perspective, you're not going to notice it. But living inside the house, when you arrive to a staircase, you have a nice hallway, a good-sized closet. It's not only just a resale value. It's about like living in the house where those 500 square feet you can enjoy them,
And so the lot split procedure does give you the ability to restrict certain things. One of the restrictions with lot splits, every home that's a subject of a lot split, like these 3, will have to go to the design review board. So it's an extra layer of design requirements and eyes on these buildings that wouldn't exist for everyone else. But basically, you would have 3 lots in this whole neighborhood, that 45%, and every other lot of the same size is at 50, and we just don't think that makes sense.
But it's not every other lot at that size. It's
No, the
ones
ability.
recently built.
But when they get redeveloped, that's what they have. They're all permitted to go to 50%, except these 3 only. This doesn't make sense.
I get it. I totally sympathize with it. I guess my catch up is, I guess there's a lot of homes in that neighborhood where people have been living there since the 90s, since probably the 80s, and maybe even before that. Doing 3 monster houses, not monster houses, but big houses at once at the 50s, that's my, I guess, hold up. And I guess by doing, and I guess just talking out loud here, or thinking out loud, that 5%, does that really make a huge difference? I don't know, maybe to the neighborhood, if you're adding 3 at the same time, it does. So, I'm wondering whether I guess I'll hear from everybody else what they're thinking.
I think we had a case similar to this a few months ago, right, where there was a lot split 3 and same thing, and they did the same thing where it was recommended 45%, they wanted 50, and we ended up approving 50. So with consistency with what we've done before, and based on what you just said and what Mickey was explaining, is at the end of the day, it doesn't really change much as far as nothing as far as setbacks or visual for people in the neighborhood, right? It's a difference of 500-600 square feet for the people living in the house. And to me, as a personal taste, I much rather see big lots with, you know, a smaller proportion being occupied by a house and having big green space. But at this point, when we're looking at something like this, it really doesn't do much of a difference in the visual of the impact in the neighborhood. You're still going to have as much construction, as much going on. It's really just for the living space of the people. And they're not asking for something that's not allowed. It's what
Right.
people are doing right now.
That's my point. If every other home, just because they weren't split, is entitled to 50%, you know, and if I have to accept the architect's statement that from the outside, you don't notice it, it's really inside, that's kind of where I'm leaning, but.
Yeah, and then the other one, there were neighbors who were having issues with it. This one doesn't seem like we have that issue.
I have a question. Are all of these houses going to be constructed at the same time?
Currently, that's not the plan. The plan would be to construct the owners first, and like I said, the other two would be for
And do you know
sale.
the timing of that?
Julian, do we have a timeline?
I mean, I don't want to subject them to, you know, the neighbors to, like
Three
you
at
were
the same
saying,
time, yeah.
you know, 10 years of.
I would just say, look, they all have to go to DRB first. So after we get through today, the first one, my guess is Julian is going to focus on Mr. Moy's home. That's going to get DRB first. And I can't tell you today exactly the timeline, but there definitely will be one first. Then he'll have to focus his efforts on after the building permit plans and the building permit is submitted for that one home. The second one will go to DRB. So we're probably talking about a good year, year and a half between them.
So
they
you're not
won't
going
be
to take
exactly
all
at the
of
same
them to
time.
DRB at the same time?
No, that's not the plan.
Okay. One more question. Your side setbacks in between the homes, tell me about those. No, I'm not interested in I'm interested in the lot line.
I think it's 10 feet. The code requires
10
That's
feet, the
what I
code
was
requirement,
saying.
yeah.
That's
And there's some outside yards too that would have to apply as well.
Right, there's some, and then the,
not a lot.
The corner lot has larger setbacks because it's a corner lot.
right, and, but there's the notch cut out of the home, right? So only a portion of the home is set back 10 feet.
Do we
Right.
have, I know in the past we've talked about it, and I know we just mentioned that it's about enforcement for the time of constructions, but is there any way for us to include in our approval, like, either a stipulation or agreement that they will not start construction until 8 AM? You know, I don't know if that's part of this sort of.
That's what I asked, but he
I
said
think
that's
it's-
enforced.
I think that's really subject to the
Building.
hours of the building code. So I wouldn't get involved in that.
Okay.
Planning board level.
Look, I understand that the neighbor had no concerns with our application, but just things in the neighborhood. If they violate, if anybody building a home violates those times, the code can come in and give a violation.
Sure, but
So we
but I'm
would
just,
follow
not-
that.
in the last one that you were talking about, Melissa, didn't we require like high vegetation on one side and so that it would block the view for the neighbor?
I
and-
think we kind of discussed with them at the time, the parking plan, their situation was different as there was one lot that was left wide open, that they were going to use that to be, you know, putting all their construction workers. I mean, in this case, I'm assuming they have a side street, that might be part of the way they're going to solving it, or I see in our neighborhood happens all the time, there's a construction site, and if there's somewhere nearby where there's an open lot, they will rent out that lot for it to do. So, but again, to Michael's point, that's not for us necessarily to be worrying so much, it's for the code compliance already has rules in place for that, where there's parking plans that are to be followed when they apply for all these licenses for these houses.
Right,
They
I
need
guess
to be-
if there's a way to make it easier for the resident
To not
who's
have
got
to
an
consider-
issue
Sure.
to not be chasing after the
Are you
building
demoing
department.
the houses at the same time?
There's only one there now.
Oh, there's only
And
one.
it
So
would-
they can
right.
use that other lot to park and whatever construction, you're going to fence that off and nobody's going to hear anything and.
We'll submit a construction manager plan to Public Works as
Okay.
required. I just want to reiterate, because it's very important, because it's not what we had last time. We did reach out to all of our immediate neighbors. We did mention 50% in that reach out, and not one person objected. I
Okay.
think that's.
That was
I'll-
my
I'll make
next
a
question.
motion.
Wait,
All right.
may I ask one more question? Why have you only reached out to your neighbors once? And you didn't get any response, but did you try again, or?
We sent a letter to them and
You gotta speak in the mic. You gotta speak in the
I
mic.
can't hear.
I'm sorry. Yeah, we live in the neighborhood. We meet actually our neighbors all the time, and we tell them the plan. We told them we brought a letter, so I mean, I don't know if there's anything else more.
And they
that
get
we could do.
notice of this hearing, right?
Yeah.
and the
That's
DRB
correct,
as
yes.
well.
I just,
So-
I mean, the neighbors.
Scott?
Okay.
Yeah, I mean, I understand where the city's coming from, in terms of trying to limit it to keep the, you know, the kind of the design of the neighborhood all to get together. I mean, but we see all around the city that, you know, the homes going that are just seem out of place. But, you know, as you mentioned, you can take every home around them, and if they decided to tear their home down and rebuild, they'll go to 50%. So I don't have an issue with that. But because of that, I know you mentioned that, right now, there's no variances proposed in the design. I would add to this approval, no variances at all are permitted.
We have that as a condition, so.
Okay,
That's fine.
okay, I didn't
We're
see
fine with
that.
that.
That's in
Okay,
there.
okay.
Matthew? We're good? Okay, Jonathan, go ahead and move it.
I would make a motion to approve staff's recommendation with the exception of the 45 to bump it to 50.
Second.
Okay, roll
All
call.
in favor?
Yes.
All in favor? Anyone opposed? Okay.
Motion passes 7-0.
I never know when we can do a.
I think as long as we have a sense that there's no opposition.
Okay, great.
Then I don't do a roll call.
Okay.
Thank you very much. Have a
You're
good night.
welcome.
And, Mr. Chair, you can always request a roll call, but otherwise a voice vote should be fine.
Okay. All right, next is Planning Board File PB 230625, 1515 Washington Avenue and 1500 Washington Avenue New, 1500 Collins Avenue New Hotel.
This application is requesting a conditional use approval for a neighborhood impact structure for a new 7-story hotel exceeding 50,000 square feet, and a neighborhood impact establishment that includes an alcoholic beverage establishment or restaurant located on the top floor of a building, which is located within 200 feet of a property containing a residential unit.
Now, if you note on page 107 of the board packages, staff has outlined the uses, including the hours of operation and occupancy and number of seats for each use. Staff is supportive of the application, however, as indicated in our report, the applicant has indicated they are not proposing any outdoor entertainment or entertainment on the property. However, their sound study mentions a decibel level for ambient music, which our peer reviewer believes is too high. And that's something that will be evaluated at the time of a on-site sound study. So we just wanted to note that based upon the applicant's sound study that they prepared, we believe they're going to have to lower the volume slightly to make sure they comply with the requirement that music not interfere with normal conversation. And that's something that will be reviewed at the time of the sound study, where the applicant, their consultant, our peer reviewer, and staff will be reviewing. With that, we are supportive of the application. I'll turn it over to the applicant for the presentation.
Good afternoon, Emily Balter, Burkhardel, Fernandez, Larkin, and Tappanez, offices at 200 South Biscayne Boulevard. I'm here today on behalf of the developer of 1509 and 1515 Washington Avenue. With me is ownership, Mr. Jimmy Resnick, as well as the developers, Zaver Kreichbaum and Gavin Crescenzo, who is a resident just down the street at 10th and Meridian. Our project architects, Starchitects from Architectonica, Bernardo Forbrescia and Ulysses Izquierdo. We have our traffic engineer, Joaquin Vargas, as well as our sound engineer, Andy Swerdlow, who's on Zoom. Some preliminary stuff to get out of the way. We can pull up our presentation. So this project is part of a unified development site with the property located at 1500 Collins Avenue. We've included, and my colleague Nicholas passed out a letter of support for our half of the development site, and we've submitted into the record a disclosure of support pursuant to section 2.1.1 of the Resiliency Code. We're here today respectfully requesting, consistent with staff's recommendations, approval of a conditional use permit for new construction greater than 50,000 square feet, as well as a neighborhood impact establishment for a project based on the number of seats, as well as our rooftop restaurant proximity to residential uses. The flag for this project is Cloud One. It's a European operator. They're not a party operator, and we're also going before the Historic Preservation Board for a special certificate of appropriateness, which includes a waiver for on-street loading in this historic district, and a variance for a architectural projection. The rest of the project is consistent with the Resiliency Code. I will now pass the presentation to Bernardo Forbrescia to go over the site, the context, and just briefly walk you through the project. And then I will go through some of the operational conditions and conclude. Thank you.
Okay, right before you start, and my bad, any disclosures to make, Scott?
I think in that same conversation, I spoke with Gail about this as well.
Okay.
No disclosures.
I think just the emails.
Emails and spoke with ownership.
Sorry?
Spoke with ownership previously about the project.
Okay, I spoke with the owner of the property. Okay, thank you. Go ahead, Bernardo. Nice to see you.
Good to see everybody. Good afternoon. You see on the image the location of the site. I think you described the...
Bernardo, if you don't mind, will you just pull the mic up? Yeah.
Oh, sorry.
There you go.
Yeah. The site is a red L-shaped parcel that you see there. It's one of the unusual aspects. It doesn't have an alley in the back, so it has to be serviced from the front. But there are other properties in South Beach that have that condition. We are part of a larger piece of property, but this has been already settled on the legal side. You see the existing building today. The existing building has been tampered with because, as you see, that turquoise band is over what used to be the original building had a travertine. And there's a second building that you see on the lower left that is also travertine. One of the issues on this site is that this the road is going to be raised, so is the sidewalk. So in light of that, we're going to rebuild those two facades as they are. And the second one, not as they are, because we're going to build it as the original, without that unfortunate aspect of adding that turquoise band in front. It is, you can see here the original building, and here you can see the proposed plan. In yellow is the public spaces of the hotel that are corresponding to the smaller building that you saw there, the sort of articulated in and out angular building that is in the travertine as well. And everything you see in pink is the second building, the linear building, that will be part of the restaurant. And you see, whoops, yeah, there we go. You can see here the upper levels of the building. They follow quite strictly the rules of how the building is, has a planar break, has all the components that are required in their setback, so that the original buildings are remaining looking like one story. They were. So it's not just a facade and then something rising from top of it. It's actually a second building somewhere in the distance in the back, with a pool on the south side, of course, where we want to catch the sun. And you can see here the rest of the levels until you get to the top floor, where you see the all-day restaurant of the hotel. There's breakfast, lunch, and dinner in that restaurant, with a terrace facing east and a terrace facing south and views in all directions. I think that's, in essence, the arrangement of the plans. These are the loading requirements. This is the loading, the designated loading the city has assigned for this area, how we would load into the building. And these are some of the aspects of where the pedestrians will be able to enter into the building. And all of them have been discussed with the planning department and are workable. And if there's anything that is important here that I need to point out is that at the first part of the building, at the beginning of the building, there will be these steps that you see there and ramps because we have to prepare for the eventual raising of the sidewalk another 18 inches. And eventually the road rises and the building will be as it used to be at the level of the new sidewalk. You saw the difference between the previous, and then you see how the gray rises and meets the building itself. The building has this sort of feature of these series of frames that are in the stone, and we pick up on that and create a more modern version of it that you will see in a second, as I'm going to take you through the renderings, because they show you the three-dimensional aspect of the building. But you see the facade wraps equally front and back. It's seen equally from all directions. From the garden, from the front, from the back, it's all like a front facade. And but I'll take you here. There we go. You can see here the building. You see how we picked up on the frames that are part of the original design below and actually floated them and intersected them in all 90 degrees to each other, and they cross paths past each other to create the sort of play of the different frames. And but you see there, of course, the original building restored with active use, the entire length of the block. Everything is the restaurant, the little gallery, the lobby, everything is activated along the street. You can see here when it raises, of course, we have the renderings both ways. You can see here the low and then the high once the building is elevated. And it is, here you can see the view of the restored building in the same limestone with the same zigzagging facade that it has. And that is the entrance to the hotel, that it marks the entrance that is different than the entrance to the frontage of the restaurant. So it's truthful to the original boundary of the two buildings. And I think that gives you a summary. You can see it from a little bit further away. And I think that's about it, right? Thank you.
Thank you, Bernardo.
So I will try to use the rest of the 4 minutes to briefly walk you through the operations of this site. One unique aspect of this European operator is that they've focused on non-entertainment amenities for their guests. Here you can see they've included in their lobby, which is not very large, they've included co-working space and lounge space. They've also included a theater and a library, and further to the east of the site, cut off from this photo, there's also a yoga lawn amenity space for the guests. The lounge lobby area connects internally and from Washington Avenue to the ground floor restaurant. The ground floor restaurant operator will be a third party operator that has not been selected, but we are building into this CUP their maximum seat count, their hours of operation, as well as the agreement that we are not proposing any entertainment. So when they do go to find a third party operator, we will have those conditions already in place with this approval. The
Can
pool
I
deck.
interrupt you? The significance of this support, is that because he's the property owner that's part of this parcel?
Correct.
Okay.
And the consideration, I know it was for him, for his support.
Correct.
What was like the background of that?
So these two property owners are unified by a covenant in lieu of unity of title, as well as an easement agreement. The easement agreement has certain conditions, such as views over the property, which is part of the reason why our pool is located on the south side of the property. Our project also includes certain floor area from what would be available floor area for their project. So for all those reasons and an abundance of caution, we included the disclosure consistent with the resiliency code.
So I guess you're getting extra FAR for this because you're taking it from that side of the property?
Correct. Well, for zoning purposes, they're all considered one property.
Right.
So if the properties were separated, then it would be considered a transfer, but Miami Beach doesn't have a mechanism for transfer. It's viewed as one property, and that's how we achieve the floor area.
Were they unified before?
Correct. They were unified in 2017.
Okay.
And we're complying with those agreements. And because we've had negotiations and conversations, and we received a letter of support, in an abundance of caution, there is that disclosure of support requirement in the code, and we just wanted to comply.
That's what I thought. I just wanted to make sure I understood. Thank you.
Yeah, covering all our bases just in case. Pool deck is only open to hotel guests, as well as the seating area on the pool deck. The rooftop restaurant is
What floor is the pool deck on?
above the ground floor. It's on the second floor.
Okay. And it's how many, what's the total stories? How many stories?
7 stories.
Okay.
So on the 7th story, there are additional hotel units, as well as a restaurant that will be operated by the hotel. This is meant for their breakfast accommodations. It will be closed to the public until 5 p.m. After 5 p.m. for dinner service. It will be open to the public. Again, we're not proposing any entertainment at all. Quickly, I wanted to add, because I think it's important, we do not have on-site parking. We do anticipate 65 employees. The applicant has agreed to provide every employee a county public transit pass, and we also have ample bicycle parking within the project. The trigger for our neighborhood impact establishment portion of our request is also because of the number of seats for this project. The way that the project is analyzed, although we have 2 separate venues that will be operated separately, the number of seats are the combined number of seats, so we do trigger the NIE above for a non-entertainment establishment. That concludes our presentation. Our whole team is available either here or on Zoom to answer any questions, and I'll reserve time for rebuttal. Thank you.
Okay. Anyone in chambers to speak on this? Alfredo?
Good afternoon. Alfredo Gonzalez, for the record. I represent Interama USA, which is the property owner you have been asking about. As part of this unified development site, there are parcel 1, 2, and 3, Haddon Hall and the old Campton Apartments. So we do have an agreement where FAR is transferred. There is nothing being proposed at this hotel, the hall that's currently operating. Your proposal today is just for the Washington site that Emily went through. So.
And if I can just also add a clarification that I discussed with Alfredo, because our draft CUP includes the entire property, we want to amend that to exclude the Hayden Hall and the parcel that Alfredo has mentioned, since that's not part of the development. So we would modify on page 113 of the board packages to remove in Verma USA Corporation from the CUP, and then in the legal description on page 118 and 119, we're going to remove the legal description that applies to the parcel that Alfredo is representing, and only apply it to 1509 and 1515 Washington Avenue, which is where the subject new development is proposed to take place.
Okay, any issue with that?
No, we're involved.
Okay. Great. Thanks, Alfredo.
Thank you.
Anyone else in chambers? Anyone on Zoom?
Real quick, Alfredo, what's in the Alvaramo space now?
It's a hotel, the Axel Hotel.
Oh, okay, got it.
So.
Thanks.
Anybody on Zoom? Michael?
Yes, we have a couple of speakers on Zoom. The first is Steph V.
Hi, Steph. Do you swear that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You have 2 minutes.
Okay. I've been a restaurant owner there for 24 years.
Steph, sorry, can you say where you're located, where your residence is, or your business?
Well, I'm actually a business owner. It's 1505 Washington Avenue.
Okay, thanks.
And we've been there 24 years. And I just am trying to get some clarity because as a restaurant owner, you know, you look to selling your business one day to retire, and I haven't been able to do that because I haven't been able to get a lease since 2013. So since then, I've been trying to grow my business on my own to see where else we can go. And there's just been no clarity. Like, are we getting kicked out? You know, recently I heard the tenants, like the new landlord wants to know who the better tenants are. And our name was given because our section of that building is only being remodeled. It's not being demolished, you know, so there's just a lot of, I just need to know, you know, this is my livelihood and my employees' livelihood. And I just need some clarity. Like, is 1505 getting torn down, or are we able to stay in there? Are we able to get a new lease? Can we have first right of refusal? Because we've been a tenant there for so long. Like, I want clarity. I think it's fair.
All right.
That's a question for the applicant.
Okay. Ma'am, did you hear that question?
Would you like us to respond during rebuttal, or you'd like me to respond now?
Yeah, I want you to respond now,
So
while
as-
she's on the Zoom call.
Of course. So
And speaking to the mic, if you don't mind. Thanks. Thank you.
The structure of this application is that we represent the developer. The owner is here today. After the approval of these applications, my understanding is that is when the applicant will close on the property and become the owner, and that, you know, they're available and willing to speak with her about a future lease agreement.
Okay.
But it will be sold at the conclusion of
Yeah,
this
I don't know how
application.
you have guarantees. I guess to the extent you can tell her that she'll be considered
Correct.
for the space. Okay. All right.
We have another caller, Troy Wright.
Hi, Troy, you remain
Hi, this
under
is
oath.
Troy
Wait,
Wright.
you have 2 minutes.
Yeah, thank you. Troy Wright, Executive Director of the Washington Avenue Business Improvement District. I guess it goes without saying that Washington Avenue is in need of beautification. Although we've made tremendous strides over the last many years, we still have a long ways to go. But it also goes without saying that in order to do what we need and to go where we want to go, we need something like this. We need an amazing new hotel that can help reshape the look and the feel of the avenue. So if you look very carefully at the location intended for this hotel, I believe, or we believe, it would immediately enhance the avenue and add a physical and mental transformation that the community, and I would dare say politicians and tourists have been waiting for some time to attract new clientele to the area. So the urban infill project with the, I believe, 268 hotel rooms will keep Washington Avenue and Miami Beach active, and equally important and really difficult to find in common times is an eager developer that really wants to support the district and do what's best for Miami Beach, Washington Avenue. So we 100% advocate for this project. Thank you.
Thank you. Next.
That concludes our callers on Zoom.
Okay. All right, we'll close the public hearing. Any questions from the board? If not, someone want to move it?
I have questions.
Oh, I'm sorry.
Discussion.
Okay.
Discussion.
Oh, sorry.
I got
To me,
excited.
questions, discussion.
Discussion.
Okay.
I feel like, and I feel like I'm looking at a future Good Time Hotel. 200 square foot rooms, rooftop, no entertainment now, could come back, want rooftop entertainment. I'm uncomfortable, and I don't know how to get comfortable with that. I don't know how to get comfortable with 200 square foot micro units. I'm
Okay.
Scott?
Scott, we'll start. We'll
Okay.
do an orderly fashion. Go ahead.
I have property on the block from this property, so I know kind of what the condition Washington Avenue is in there, and I would tell you that any development there is, or I don't want to say any development, but any kind of progress there is a good direction. I'm not so convinced that we need another hotel in the city. I'd love to see something else go there. But I understand they can, it's zoned for hotel, they can put a hotel there. However, looking and knowing the neighborhood and looking at the, what they're proposing, I see two rather large issues with that, it may take some maneuvering, but I think they can be addressed. One is something that Elizabeth just mentioned, noise. When I first looked at this, that's the first thing that came to my mind. I understand there's no entertainment, but there's still speakers on a pool deck. And as we know, you can turn the volume up on speakers. So to me, entertainment's just a DJ, but speakers it's crazy. It's something that, obviously we've seen today. The city has a lot of trouble controlling. So I don't know what you can do other than agree not to have speakers on that pool deck. Maybe you could suggest something else, but I would not want to see that happening there. Right next door to you, or I guess it's technically part of the parcel in Haddon Hall, they have an outdoor courtyard there. They're not loud a lot, but when they are, that could be heard blocks away. It happens, but not often. And my fear is that's going to be the new norm. So that's a huge concern of mine. The other one is that you have no, and this is where it gets a little tricky, no off-street loading facilities. It's not a small hotel, and you have a lot of uses in there. I drive down Washington Avenue quite a bit, and I'd say 9 times out of 10 going south on Washington. I make a right turn on 15th Street, but I have to get in the left lane and then kind of go back in the right toward the end of the block because the hotel across the street has their valet there, and there are constantly cars being loading, unloading, people being dropped off. I see that same thing happening for this hotel. Also, you have, again, it's not a small hotel. You have deliveries, you have, people coming and going, trash, and I see all of that happening on Washington Avenue. So that's something that to get my support, needs to be addressed. You have, again, it's technically one development site. I know city doesn't like doing this, but, maybe a curb cut there would alleviate some of that, and you work something out with that little courtyard there, and maybe you can have a little sort of an alleyway off of Washington Avenue to take some of that traffic off the street. So, other than those two issues, I'm somewhat torn. I'd like to see something happen there because that's a rough stretch of Washington Avenue. But I don't want to trade one negative for another. So those are my two issues that I think, can be resolved, but to get my full support, they need to be.
Through the chair, would you like me to respond?
Sure.
Per board member? So, one thing I will add about the unit sizes, in order to make these projects viable, we're actually not going down to what we could at 175. We are keeping it at 200, and we're using as much square footage as we can to maximize the amenity space. We hope that this is going to attract a more laid-back, older European crowd who will hopefully spend their time in the theater, in the library, in the yoga lawn. And we can't offer those spaces if we make their rooms larger. So there is a give and take in that aspect. I will also add that we are including a no entertainment, no special events condition in our order, and I think that responds to both.
In perpetuity?
It is recorded and will run with the land. If it ever has to change, we would have to come before this board. It would have to be.
Why can't you go shorter? Why can't you go shorter and have larger rooms?
Shorter, I'm sorry.
A smaller building, shorter in height.
So in order to make the pro forma work, to have a viable product for this site,
But the land's
we need the
free and
square.
clear.
Well, we're not maximizing our square footage. Actually, we're actually leaving about 10,000 square feet of floor area. We are keeping our south setback set in where our pool is proposed over the ground floor to make sure there is light and air through to the Haddon Hall site. So we've actually made it somewhat thinner and more towards the north of our property so that the Haddon Hall, our neighbor, gets as much breathing room as possible. So that is some of the give and take with our massing.
I mean, I'm all for seeing Washington Avenue bloom and blossom and do really great things. I have.
You've been
I have
burned.
stage fright.
No, you
So-
feel like you've been burned. And I'm another project. This is earlier you mentioned beds and heads. This is a beds and heads operator. Cloud One is a European flag. They've never
have
been
one in
here
New York
before.
City.
Right. There's one in New York. They're all
Doesn't have
throughout
very
Europe.
good reviews.
Well, hopefully the Miami one will be better as the developer's living down the street. As far as the loading goes, we understand your concern. This is a concern throughout Washington Avenue. We worked closely with the parking department. Where we're proposing our on-street loading was actually 3 parking spaces, 3 loading spaces, my apologies. And we, through reviewing of the site and a site visit and timing of how long the loading trucks are there, they've agreed to increase the loading from 3 spaces to 4 spaces, which will hopefully accommodate much larger trucks and keep trucks out of the right-of-way and into that space. That's one of the things we worked, very hard to get the parking department to agree to. It is a condition of this street. We do not have rear access to the site. It's how it operates today. What we have done is strategically located our FPL, our trash area, all of our internal back of house areas where they would be all, as the name states, back of house. We've located them to the southern property line, so they're concentrated away from, as far away as from possible as the lobby. And that's just as the district is. And as I said, our conditions include no entertainment, no special events. There is nothing more strict that we can do to make you all more comfortable from that perspective.
Matthew?
Okay, thank you. Mr. Chair, just a suggestion. I think when we have the back and forth between us and the applicant, it kind of makes that discussion that we're having amongst ourselves difficult. So obviously, it's your meeting here, but I just want to share my feelings.
You'd rather her not address each
I'd rather
comment?
her not address each individual comment then, just because we can't really have a conversation
Okay.
amongst ourselves. That all being said, I mean, I agree this is a nice looking project and something is needed there. So it's over 50,000 square feet. I'm looking at the front page of the packet we have here. I think that's why they're here. It's a conditional use. So yes, they can build a hotel there by right, but not over 50,000 square feet. So we shouldn't be under necessarily that presumption that it could be done and that we're just merely a pit stop on the way. I went by this morning, and perhaps I should have disclosed that, so I'll disclose that now. I went by this morning, paid a site visit, because I reviewed the criteria that we're all supposed to do, and one of the comments that were made was about the sidewalk width in front. And I'm going to find that exact. Well, let's see. Okay, it's page 115. Actually, that's the. I'm sorry, that's the order. Let me see here. I can't find it, so I'm sorry,
I
unless
think
you.
you're referring to condition 9 on page 101.
Okay, it's
about
basically.
the pedestrian friendliness on the sidewalk.
Yes, the encroachment of the stairs onto the sidewalk. So I measured with my feet, which are roughly about 1 foot per foot, and it's about 8 feet wide, the clear path today. And on the plans here, I think it's what the staff were referencing to, it's at most 5 feet, I think is what the clear pedestrian path would be. I have concerns. When I was there, it was 9 o'clock in the morning, and a group of people could barely walk by, 2 by 2. This is a busy urban area of our city. A lot of people are walking, and while the street may be raised in the future, I think we've all seen the difficulty with all these projects around our city. It may be decades from now, so we should really be looking at what it is today. So my point that I'm trying to make here is that rather than waiting for HP board to maybe or maybe not consider this, we as the planning board need to look at it and see if the sidewalk clear path should be wider than it is today. So that's point number one. Number two, I echo what my colleague, Ms. Latone, said about the size. I was just having flashbacks to the Good Time Hotel, and while there may not be entertainment proposed here, it seems like a very similar program in terms of small micro units, 270 rooms. That's a lot of people every single night. The goal is, obviously, the goal is to maximize the number of people in the room. So that's going to tax our infrastructure, our water system, our sewers, our streets. There's just a lot of things here that a hotel on this location may not be the most appropriate. So I have concerns with even just the use as proposed. And then to the loading and the transportation part, I echo concerns Scott raised here. The trucks on Washington Avenue, they're double parked. So if this does proceed, I would suggest a condition that, similar to what I've seen in others, that the size of the trucks be limited to the SU30. And what that basically means is it's a single axle truck, it's not a tractor trailer, It's not super long. It will fit in these loading zone spaces that they've identified on their site plan. And then, lastly is the usage on the ground level. The person didn't identify themselves, but I'm guessing since I went there and I saw the places that are on the ground level, there's a Cheeseburger Baby. I think that might have been Cheeseburger Baby, the owner that was speaking this morning. There's a bakery, there's an Italian restaurant, there's a cell phone shop and a smoke shop that I saw there. Oh, and also a food market. And a food market. But my point is that there's a diversity of retail uses along there. And what's proposed is a really large restaurant. And, we've seen a lot of those approved by the board in recent years. We've seen how they come and go. It's not an easy business to succeed in. And what that means is that we might have a vacant space for some time if the business doesn't succeed. It may not be active during the day. So I have concerns there as well. And, I would raise these to my colleagues here, and see where we all land here. But I'm not inclined to support 200 square foot hotel units, I think it was 278 units. I have some concerns there.
Good.
I equally have concerns. We're the planning board. We're responsible for planning the future of our city. I don't think that, in my opinion, micro units in this location with no parking, and very little other contributions to the nearby neighboring area. I don't think that that's what I think the future of this area should look like. I know that we received an email from the Art Deco Neighborhood Association. They're against this. And in talking to the Good Time people, I'm not worried about the entertainment or the noise. I don't see that as part of the business model, but I see these rooms are actually smaller than the rooms that this same hotel has in New York City, and I don't know if there's really an appetite from the locals, from the residents here for that. And in talking to the Good Time Hotel, they mentioned to me the biggest complaint by their hotel guests is not the noise, it's the size of the rooms. I mean, they're tiny. And so I share all of your concerns as well, the no parking, the micro units. The neighbors don't seem to support this, and so that's my concerns.
Driving down Washington Avenue, I think hopefully everyone can agree that any type of progress is progress. I thought something similar about the Good Time Hotel in terms of the size of their rooms before I actually went inside and looked at the rooms. And when you compare a lot of the issues that we've seen in the entertainment districts, it's these very large rooms where people are packing the rooms with a lot of people, way more than they should be, which kind of creates, I think, just an issue with just generally the hotel kind of quality of rooms. So I like the smaller rooms. On the residential side, like we've been involved with building, again, smaller units, which has been very helpful for getting people into buildings and kind of getting them out into the city, really experiencing the city. So hopefully, if anything, that could help with activating the street. My only comment is, instead of having that very large kind of restaurant on the ground floor, I wish it could be split up into different retail bays to try and accommodate a more diverse offering. But yeah, I don't know what's feasible for the project and what they can or cannot do. But generally, I'm supportive for any type of progress, because right now Washington Avenue can really use as much help as it can get.
I'm good.
Not to repeat, but the same thing. It's not seeing projects coming onto Washington as a bonus at this point. We just need some attraction to some better businesses coming on Washington. The biggest concern is the logistics working around it with the parking, and as my colleagues have voiced those concerns, the question becomes, is there anything Washington can be attracting that we won't have those kinds of issues? And so I just, you know, and part of the planning of the city, if we're looking for a neighborhood like this to be, you know, revamped, you know, what is it we're trying to attract? And obviously, you know, it tends to be sometimes some big projects that change the neighborhood. I'm not saying this project is perfect, but I just am curious, so if not this, what is it that we're looking to do to make big changes to that neighborhood?
Residential, full-time residential,
Full-time
non-waterfront housing.
Could you consider increasing the room size or converting the business model to residential?
So one thing I will through the chair, now is a good time. Now's a good time through the chair. We are following the city's vision. They had a mayor's blue ribbon panel before they implemented the Washington Avenue overlay, which allowed the 175 square foot rooms. We're not at the minimum, we're keeping it to 200. This is a European flag. In these European hotels, they're even smaller. We're trying to incentivize not having, you know, parties in the room or a lot of people in the room. We want people heads in beds to sleep and maximize the amenity space. If we make the rooms bigger, it's a give and take. Then now we're gonna have 4 to 6 people in a room where really we would have maybe 1 or 2 coming in, and then being able to use the remaining floor area. I don't think it makes sense for their brand. It's not consistent. And it's also not consistent with the vision of Washington Avenue. I will also add, as far as the sidewalk width, 5 feet is a normal sidewalk width in an urban environment. We are keeping, you know, the sidewalk width as proposed in our plans. We met, I would say, 4 to 5 times with the Public Works Department before submitting this proposal to you all today to make sure that this would work and that the harmonization that we're proposing between the current elevation and our proposed elevation, we don't want people coming up to a wall. We have to balance the current street level with our minimum design flood elevation, and including the steps, although, you know, maybe not some preferences, it does create that walkable environment. People can go up and take advantage of the active frontages. If there is, you know, we're leaving the ground floor space open. If there is an appetite where 2 tenants come in, they can split the space. We don't have to come before you all. What we're doing right now is locking in the seat count and the fact that any future tenant cannot do entertainment here. That's what we're proposing with this.
How deep is the retail space?
How deep?
I didn't see that. I may have
can tell
missed
you
it.
that it's 4,000 square feet.
And the depth? From the street to the back?
Well, we include the kitchen area, the bathrooms, and all of that.
So the depth for seating?
I don't know that I have a dimension for that, but the property is approximately,
I'm trying to determine if it's actually usable space.
Right, well,
Because
the-
we see a lot of that that's actually not.
right, well, the property is about 100 feet in depth. We have 6 feet of the frontage porch area, and then another 6 feet of the rear strip in the back, so 20 feet. If you just subtract 20 feet from 100 feet,
Okay.
it's about that much. But we're keeping it, as part of this application, we're trying to keep the occupancy to 294, and the square footage to 442, 4,420, and we're open to multiple tenants. That
Okay.
wouldn't be an issue.
Nick, wasn't there something just recently
40,
passed
okay.
by the commission that was something about a Washington overlay that eliminated, was it co-living?
I think you're referring to what we have on the agenda today,
No, it was
which is
something
for
else.
co-living units.
It was something else. It was Washington.
There was the Washington Avenue overlay
Yeah.
before the co-living amendments. Is that what you're referring to?
It
That
may-
it was the
maybe
height.
that-
It was a height increase for.
No,
It was the result of the master plan, right, Michael?
Something on-
We're talking about very recently?
Yeah, it was, I think it was, or maybe it's.
An FAR
Wendy.
bonus, wasn't it?
I thought so.
0.5 incentive, but didn't we discuss that last month?
No, this is the commission. It's okay. I'll figure it out. It's okay.
Sure.
Forgive me, I have like an ear infection. I'm a little drugged up, so I'm just going to say my name is Jimmy Resnick. I've been in the city, we came from Cuba in 1960, so I've been here approximately 64 years. I remember my favorite place as I was growing up here in Miami Beach was...
Hey, Jimmy, hold on one second.
I'm sorry. I'm sorry.
And just raise it a little bit for him, PJ. Raise it a little
Was
bit.
the area where
There you
the
go.
Sagamore, the National Surf Club, Surf Comer, that area. The Delano. Those places were shut down for how many years? 10 years? 11 years? Now the rally, they're all coming back right now. But for 10 or 11 years, those places were shut down. Why? Because anybody tried to develop, it was HP board, planning board, design review board. This project, I tried, I had it sold, we had it sold to a prospective buyer with smaller units before COVID. COVID came and that backed out. And then we had it sold for even smaller units. This is a beautiful project. If you walk down where these retail places are, Cheeseburger, it's dumpy, it's seedy, they're falling apart. Of course, I can't give leases because a new buyer needs to empty out the building. And even I spoke to Stephanie, who's been my tenant for 24 years. If they have retail, they'd be glad to talk to her about maybe coming back, whatever. They'll talk about that. But if you turn this down, this is going to stay the same way. You can't. This is some beautiful project that's going to really make it nice. And you're always going to find faults with it. But overall, it's a beautiful project. There's no opposition. There's nobody that spoke against it. The whole city's looking forward. The Washington Avenue's looking forward. Just let it go. Let it happen. And then if you have to make some minor changes with the HP board, do it. But don't stop this because this might be another 10, 12, 20 years before nothing happens here. This building is falling apart. It's really, and these tenants, a smoke shop and these are not the type of tenants that you want there. But I have to rent it out to somebody that will pay me rent, whatever, while I'm trying to sell the property. Of course, you're going to find faults. Of course, it's going to be. But the project is available. This is what that you can build there. They're not doing something that they're asking for variances or anything like that. They can build that. Now, if you don't like it, the size of it, that's your opinion. I understand that. But this is going to beautify this. It's ugly over there. It's going to beautify that place. That's all I have to say.
Thank you, Jimmy.
If I can add one note, so this is scheduled to be reviewed by the Historic Preservation Board on May 14th, I believe, and that's when the board is going to discuss the variance for the on-street loading and the long frontage standards and the sidewalk widths. So as long as the planning board has reviewed the project today, which they have, the applicant can move forward with the Historic Preservation Board application. I don't know if the board wants to review, provide comments, and continue this application to the next month's meeting to allow them to go to the Historic Preservation Board, come back with the input from the Historic Preservation Board, since this does include sort of the recreation of an historic, facade along the frontage. And as has been mentioned, there is, unfortunately, this property does not have an alley. So we feel that by putting a curb cut in and all the area needed to provide loading facilities, that in itself could also provide more disruption onto Washington Avenue, because you're going to have to back in or back out. There's no way unless you take out the entire ground floor to provide loading on the property. So we do think that, sorry, go ahead.
I was just going to, again, can we find out how Haddon Hall does their deliveries, trash, and again, it's a unified development site. Maybe part of the deal they have to make is with them to maybe share that, or possibly use part of their property. But I just think I see that problem coming with backups on Washington Avenue. A lot of deliveries, and not only the deliveries, but people being dropped off. That's what I see with the hotel across the street. So it's something that can be figured out. It may take a little bit of effort, but it can be figured out.
So Michael, if we had approved today with them to come back after design review board, we would get to make our suggestions today, and they would come back with some
Yeah,
proposals.
I mean, you
of
can
that,
make any
right?
recommendations and ask them to come back and look at some information, and they can review that and come back next month. In the meantime, they still can go forward with their application to the Historic Preservation Board.
I would make that motion to continue this hearing till after the Historic Preservation Board has considered those issues.
Some of the recommendations of what we would like to.
And, you know,
I was going to say, if you guys want to be specific in terms of what issues or what changes you would like to see them to explore or come back with.
So why can we try, I mean, for whatever concerns people have, we can make a motion that the Historic Preservation Board, I guess, I mean, a lot of those items are out of our purview. So if there's a concern about loading, whatever it is, first of all, was there a second on yours? Because if
Well,
not,
this-
I'll try for it.
Could I say something?
Yeah,
I'm sorry.
sure.
I mean, it's with all due respect, but I feel like we're being blackmailed by the landlord. He's telling us that he owns the building and that it's a dump, and that if we don't approve it today, it's going to be a dump for another 10 years. I mean,
Well, but that's,
I
I mean,
didn't
that's.
take it
Through
that
the
way.
I did, though.
No, but at
Through the-
the end of the day, it's economics. Hey, hold on.
Stop, Jimmy, don't worry.
No, hold on, Jimmy, just 1 second. Just, no, but it costs money to do these things, right? The developers, the real estate owners aren't always the big bad guys for holding cities hostages. I mean, everything costs money. So it's not easy to just say, hey, an owner or developer is gonna put in a ton of money to fix something up if the rents that people are commanding on the street don't warrant that, or if, there could be a million different things.
But I don't think that, Jimmy made his comments and stuff, but I think before that even came up, I mean, we all recognize that Washington is in a, dire state, that something needs to happen, so.
You could speak to
But-
50
but-
landlords on Washington.
But I think, listen, I think I have my motion. Part of it is
Yep.
the neighboring neighborhood association is against this. They've sent us all an email saying they're against this. So it's incumbent upon us to consider it carefully, thinking about these issues that came before, that were raised by different people. And so I think the best thing to do, part of those issues may be addressed at the Historic Preservation hearing or review. So I think we should continue it until after that review.
I would second that.
They want to let it go to HPB, see their thoughts and comments and bring it back.
Through the chair, are there any other additional specific recommendations from this board that we can go through?
Well, I'm in
Because some
favor
of
of it
them-
with some minor revisions, but I think Scott told you that the primary concern is loading, correct? Well, I'll let you speak, go ahead. But what noise are you talking about if
I
there,
think that's a simple.
Removal of any outdoor speaker?
Or even timing.
Sorry, go ahead.
I was going to say, rather than having the speakers, turned down at all hours, that whatever the venue's open, you can limit the speakers to certain hours.
Or eliminate
No outdoor speakers at all.
Wasn't the pool area enclosed?
well, you got to talk to the operator and see what
Is one side open?
compromises they can make.
Right, I just,
I mean, these are just
for example, if
suggestions
the
and-
recommendation is
So
add
wait,
parking.
everyone, wait, stop. Yeah, everyone's got to stop talking one at a time. Sorry, go ahead. Okay.
They answered my question.
All right, what I was saying is, you've heard communication from the board, what some of their concerns are. Obviously, you're gonna have to go back to the operator.
Correct.
And tell them what the concerns are and see what modifications or sacrifices, if any, they wanna make. Go to HPB, and then it'll come back. But I think his concern is noise and the deliveries. I know Matt's kind of against the whole project.
But I will say that the sidewalk part is really important, and 5 feet is not a standard sidewalk width in an urban area, so that would be the number one concern.
Okay.
Room size, parking, ingress, egress with Ubers and whatnot, and just,
Those are my concerns as well.
So I would suggest that the board continue this till May to get an update from what happened at the Historic Preservation Board. That's not going to allow, maybe in the meantime, you can also provide some suggested modifications, but we're going to need those by next Monday. if the board is going to take action on those on May 28th. So I think if you want to wait till after Historic Preservation Board, come back to the planning board on May 28th with sort of a verbal update, and have the board then continue it to the June meeting to give you time to make any tangible changes to the application for the board to review and for us to provide a staff report for the June meeting. I think that may be the best course of action.
I guess just a question of process for us. What would HPB tell us that would change, I guess, what we incorporate here? Meaning, if there's a concern about sound, then we can include that in our.
Well, I see the Historic Preservation Board is not going to comment on the sound. They're going to comment more on the loading operations.
Well, sure, but my point is that, I guess we could give guidance to HPB. We could say we're generally, or we're in support, but we want to see that loading occurs, you know.
We can
I think what
also-
you're asking, will the HPB, will they be briefed on our concerns?
Yes, I'll brief Debbie Tackett, our Historic Preservation Officer, let her know the concerns that were expressed by the planning board. She can relay that to the Historic Preservation Board members when this application comes up on May 14th.
Okay.
So I'll second Jonathan's motion.
Okay.
Elizabeth already seconded it.
Oh.
So
No, missed that.
we get a motion, this is to continue to the May
All right,
28th meeting.
so just so everyone understands, we've made recommendations for the HPB to consider. You're going to go to HPB, and then you're going to come back.
Correct.
Okay, that's the motion.
All in favor?
Yes.
Aye.
Any opposed?
Okay,
Motion passes. It's continued to the May 28th meeting.
Thank you.
okay. Thank you. Okay, next is Planning Board File 230636, 1100 Fifth Street, new office project.
Oh, yeah, I would suggest keep your packages, or if you want to leave them here for us when you walk away, so we can send them to you next month.
All right, sorry, one question also about process. So why would it have come to us prior to HPV versus HPV prior to?
So the code does require for a 50,000 plus square foot projects that the first review has to be at the planning board.
Got it. So we've reviewed it. It could now go to
Correct.
HPB, and then it comes back to us.
Right,
That's all
right.
normal.
It cannot go directly to the Historic Preservation
Got
Board
it.
without the planning board having a substantive discussion. Alejandro's going to read
Okay.
into the record the
Um,
next application.
This application has been filed requesting a conditional use approval for a neighborhood impact structure for a new 5-story mixed-use development exceeding 50,000 square feet, and a neighborhood impact establishment, a restaurant, including a mechanical parking garage.
So staff noted that this is largely a more simpler project. It's largely an office use, mechanical parking, and a ground floor restaurant. Due to the size of the ground floor restaurant, it does constitute a neighborhood impact establishment. However, since the applicant has not provided a tenant and operational conditions regarding that operation, we are recommending that the board review and approve the office component along with the conditions we've included in our staff report, and that the applicant come back to the planning board when they do have a tenant and can outline all the operational details for that tenant. The applicant is going to be providing some suggesting modifications to the conditions that we had indicated in our draft final order for approval. I believe the latest update, we are supportive of all their changes. Paula is going to pass them out and go over those
I'm
changes.
sorry, Michael, staff is supportive?
We are supportive, yes.
Okay, of their suggested changes?
Right, with
And
the
are those-
understanding that the ground floor restaurant's going to come back to the board in the
Right,
future.
are those in a revised
I
order?
think, yes, Paul's going to pass them out shortly.
Right. Thank you. And so staff has reviewed all these? Okay.
That's correct, yes.
And it's just for our edification, the differences are the highlights in yellow?
Correct.
Okay.
So, sorry, before they can, like, who suggested these?
This is from the applicant.
So you had a concern. They came back with these suggestions?
No, they were concerned with some of our conditions.
Uh-huh.
There's been some back and forth regarding what they
I'm just saying,
initially
I feel like
proposed.
detail for the previous one would have, you know, something like this would have helped also.
We didn't have that back and forth, that the applicant, that's why they've done this, to sort of shorten the time of review.
No, it's helpful. You finished?
Yes.
Okay.
Thank you so much, Michael, and good afternoon, Chair and Madam Vice Chair and the rest of the board members. My name is Paul Savage with law offices at 200 South Biscayne Boulevard with the Burkow Riddell Law Firm. I'm here proudly and with a lot of excitement, really, with a large team. We've been working for months and months on a beautiful project. It's item number 9 on your agenda, and it is a 5-story office building at 1100 Alton Road, also on the corner, I'm sorry, at 1100 Fifth Street on the corner of Alton Road, a site that we all know very well. We have a very large team and a presentation. I'm going to do my very best to go through it very quickly. And so first, I'd like to introduce our team. The applicant itself is the Alton Venture LLC. It's my client. The principals are here. Amit Khurana and Saif Sumaida is here. Also, Xinyi Wang from their firm is also here. The ownership co-applicant is with us today, the Nisis family and the Weiss Properties family. Personally is Robert Weiss, Miriam Weiss, his wife, and their 2 sons, Alex and Mark, are also in attendance. It's my pleasure to be joined by the Siskovich architecture firm. Surya Yafar is our architect who's going to go through the site with you and the plans. She's joined by Daniel Bush, who's also an excellent member of the Siskovich team. Finally, I have the urban robot landscape architect, Justine Velez, together with Adrian Debkowski, who's our traffic engineer you all know very well at Kimley Horn, together with Carlos Florian, who's also at Kimley Horn on Zoom, in case there's any civil engineering or drainage questions. Now, with that, I'm going to give a quick intro to the site and then turn it over to Amit, and then Surya will go through the plan sheets very quickly. Thank you so much. So, well, the first is our beautiful elevation fronting Fifth. The entrance is to the left with an open courtyard with ample landscaping, and then also an open area on the corner. As you can see, it's a 5-story structure with, if you look carefully at the floor plates and the columns, they narrow as they go up to give sort of this elevation, light, and that feel, and ample glazing also gives this beautiful feel. It will be an entrance to our city. This is the location you know well when you come over the bridge. It's on the right. The existing condition has the now defunct Pier 1 retail site on the one end, and then to the east is the Burger King site that's still in operation on the other end at the corner of 5th Street and Lenox. Just to give you a quick overview of the building, this is an aerial rendering looking at the Icon condominium on the right-hand side, looking toward the east. You can see that the structure is nestled on the corner with a setback and landscaping. The roof is landscaped as well. Also, I want to point out that the principal height in commercial activity is fronting Fifth, and then with a step down appropriately to the residential and civic uses to the south. It's a 100,000 square foot building. We do have a proposed restaurant in the bottom, but as Michael Belush, instructed you, and he instructed me at the time, that we don't have a tenant, so we were not technically competent at that time to provide the details as necessary. So we agree with staff's recommendation. We are not seeking the neighborhood impact establishment. That's being continued. But we are seeking together with a favorable staff recommendation on the neighborhood impact structure, the structure itself and the office component. And with that, I'd like to turn it over quickly to Amit, who has a comment about our vision for the site, and then Surya will go through some of the renderings and the plans. Thank you.
Good afternoon, Chair, Vice Chair, and members of the Planning Board. My name is Amit Khurana, and alongside my partner, Saif Sumaida, and our colleague, Xinyi Wang, our firm, Sumaida & Khurana, is the developer of this project. In partnership with Roslyn and Norton Nisis, Robert and Miriam Weiss of Weiss Properties, and Aaron Butler of Avenue Real Estate Partners. Due to our site location, we are fortunate to have a singular opportunity to develop a gateway building, the first to be seen driving into the city. The mandate here is simply to develop one of the most architecturally significant buildings in the United States. Given this requirement, we commissioned the Pritzker Prize-winning master architect, Eduardo Soto de Mora, to design the building. Eduardo is largely viewed as one of the most important architects of our generation and will be his first building in the Americas. The building is being designed in collaboration with renowned architects Bernard Ziskovich and Surya Jaffer of Ziskovich, and distinguished landscape architect Justine Velez of Urban Robot. The architecture reflects an objective to create a timeless and elegant building that stands the test of time. The type of building defined by its subtlety, detailing, and craft. With a similar intention in mind, we are also developing the fifth, an office building currently under construction at 5th Street and Michigan Avenue, designed by master architect Alberto Campo Baeza. With both projects, our goals have been to make a profound impact on the built environment and to create architecture that is aligned with the sophistication that defines Miami Beach in the south of 5th neighborhood. We do hope that you will appreciate the thought and care that has gone into the design of this building, and we would be very grateful for your support and consideration. Thank you so much.
I'm Surya Jafar with Ziskovich Architects. I'll try to go as fast as I can. This is the view, as it was mentioned just now. It's a modest building, but its presence in the way that the building is articulated, you would see that it's trying to really be the gateway entrance into South Beach. The way it's nested is a good neighbor. It doesn't need to come down from 5 stories to 2 stories as it approaches 4th in the south neighborhood, but it is done as an attempt to be, a design statement, but also a good neighbor. The design is really a play on a harmonious a brise soleil facade that we have. It's kind of almost musical in nature. And the building, when it gets to the corner, it sculpts that corner in order to make that statement as you approach the city from the highway. There is a beautiful play at the ground floor where landscape is introduced. So there's this dialogue going on back and forth with the architecture and the landscape throughout the entirety of the building. You can see this is the view on the corner where the play of the volumes and the slabs begin to create that modularity and sculpture to really make the point of arrival, the arrival sequence of the project. As you can see in this view, the brise soleil wraps the entirety of the building, and on the ground floor, it opens up in order to make a statement of entrance at the corner of 5th and Lenox. This view shows the facade stepping down into a 2-story. And you can see the second floor has proposes to have mechanical parking lifts so that we could reduce the volumetric of the parking and emphasize the other elements that are office and the ground floor uses. The plan here indicates we are actually removing 2 out of the 3 curb cuts that exist, and we are keeping and relocating 1 on Lenox as the main entrance. You can see the corner. The building doesn't touch the edge of 5th and Lenox to make an entrance plaza into the lobby space. From the main arrival sequence of the porte cochere, you also have a garden entrance into the restaurant from that other side. So basically all the frontages of the building are rightly frontages, treated as such, and activated. On the south, we have proposed a mobility bike hub. so that we can continue to support the efforts that the city has been building for bike circulation throughout. You have both long-term and short-term parking in that corner. This is a typical parking office floor. You can see the cores, but also that wraparound terrace that is part of the Brise Soleil, that at this point are decorative elements, not structural elements. We'll be happy to take any questions you might have.
Thank you, Surya, and through the chair, if I could just have a small extension just to conclude the presentation. I wanted to just make sure that, let's see, where did I wanted to make sure and again reiterate that we're here with a favorable staff recommendation. I do want to thank Michael, his entire office, and the staff for working with us. We've had many meetings to go over this over the last few months. There's a favorable staff recommendation, and again, we're only seeking the approval of the office as a neighborhood impact structure, and we are continuing and not seeking the restaurant at this time. The conditions that were handed out, reflect that there's no entertainment allowed south of Fifth. There's nothing will be permitted under this entitlement or vote today. It will be continued. Anything with the restaurant or its impacts will be continued to be totally fleshed out by the board at that time. I did also want to emphasize the mobility hub, which is over 1,600 square feet, that is dedicated to bicycle parking, encouraging pedestrian experience, encouraging bicycle use, and to keep the cars off the road to the maximum extent possible. We think that this is a fantastic transition and fits in this spot just right. The office use is a less intense use than other uses. We think this is going to be a beautiful high-end product for people to work near where they live. And lastly, I wanted to also say that we have been diligently reaching out to our neighbors and community groups. We've met with Sofna. We've met with the Icon condominium across the street, who had a lot of strong input on our landscaping plans. And this slide here, I wanted to quickly show. They wanted us to be sure and match their landscaping, which is a Brazilian beauty leaf tree that looks very beautiful with a dark leaf. And so we're gonna match what they have, and also we're gonna try and work with the City of Miami Parking Department and close some of the on-street parking that is not used on Alton to make a wider, landscaped, pedestrian-friendly, and greener area that will match what they have on the Icon side, and also support the beauty on our side, and then make sort of a unified, beautiful entrance. So with that, we respectfully request your favorable action together with your favorable staff recommendation on this beautiful project. And we're here. I have a huge team here of any particular questions. We thank you again. And I reserve time for any rebuttal or any questions.
All right, thanks, Paul.
Thank you.
Before we continue, any disclosures to be made? Anyone have communications, ex parte communications?
Yes, I met with the applicant and their team.
Okay, anybody else? I did. I met with Paul as well. Okay. All right, so yeah, you could have a softball team here, but is anyone in here not part of the team that wants to speak? Nobody. Okay, anybody on Zoom?
No, sir.
No one on Zoom? All right, we'll close the public hearing. Scott?
Yeah, I mean, I think it's a nice-looking building. I really don't see any issues with anything proposed as far as operations, things like that. Just one question, because the one condition you put in about removing the three parking spaces, the neighbors were asking for that?
Well, our friends at the Icon condominium wanted that. They were telling us that only they noticed some repair trucks once in a while will park there, and it doesn't make a nice visual, and so they would like for us to beautify that lane to the maximum extent possible. We are not in control of that activity, This board is not in control of that activity, so that last term is for us to use good faith, best efforts to do our best to facilitate that, which we will
Yeah,
do
it
and
happens.
pay
You
for.
know, like Casa Tua did it for their valet. I mean, it happens. So you
Yeah.
got to seek approval from the city.
Yeah.
Yes, sir.
No, I would just say, again, I don't, if they're
Yeah.
not that, used that often, I just wonder if, because you have parking in your building, is your parking open to the public? Or let's say someone's visiting an office in your building?
Well, by regulation, and whenever you have the mechanical parking, it's 100% valet.
Oh, so it's,
So it is, it's not, open for anyone to come and park but the tenants and their visitors, their invitees could certainly come and use that.
Okay, all right, good.
Matthew?
I love this project. I
Oh,
really-
my God, you're in good shape.
We do have one speaker now, Matthew Pender.
Okay. All right, I closed it, but I'm going to reopen it for one speaker. Go ahead.
Thank
Matthew,
you,
are
I
you there?
appreciate that.
Go ahead,
Um,
Matthew. I
and
guess you got to be
look-
sworn in. Hold on one sec.
Okay.
Matthew, do you swear affirm the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You have 2 minutes.
Okay. So first of all, really quickly, let me just say thank you to everybody. I know these are long days, and I appreciate everything everyone's doing here for the city. It's very important. I know some of you, you may know me. My name's Matt Pender. I live south of 5th. I've been the president of the Friends of South Point Elementary, known as FOSB. I'm now a board member, not the president anymore, but I just wanted to acknowledge, this building is right across the street from the school, and we've built a lot of relationships over the years with developers who have helped the school, knowing that Miami-Dade County Public Schools, it's one of the lower funding districts in the country in terms of public school funding per student. And so the developers that have been in the neighborhood have been good partners to us, especially this one here. We worked with them on their Michigan Ave project, and they helped us put in a field, put in a theater, and they've been one of the biggest currencies that we see as good neighbors is transparency. And they've let us know that this is coming for a long time, showed us plans, and have shown a real willingness to help the school, not just build a building there that's going to help Class A space, but help the students at the school, which roughly 50% of the kids at South Point Elementary are in the free or reduced lunch program. And one of the things that we discussed with the developer is they have a keen interest in potentially building teacher housing. There's a teacher shortage. It's tough being a teacher these days in terms of finding affordable housing in Miami Beach like any other resident, but given their salaries, it becomes particularly tricky. So that's something that we're actively talking to the developer about, but I just wanted to lend my support. And we've in the past seen some people move into the neighborhood, like FPL, who's done it quietly and hasn't necessarily been so open in terms of plans, but this has been incredibly transparent. We've had open discussions, not only about the Michigan Ave project, but this one, and this relationship has been over the course of a couple years. They've been excellent neighbors to us, great to the kids in the community, and we're fully supportive of having them as a long-term neighbor in South of 5th. So thank you.
Thank you, Matt.
All right, and thank you, Matt, as well. My children also attend South Point Elementary, which is right across the street from this project. So the sensitivity to the site is also appreciated. Kind of lost my train of thought there for a moment, but
You said you love the project.
oh yes, I still love it. In fact, this is one of those things where you talked about being the gateway to the city. Right now, you come across the MacArthur Causeway and you see a different gateway. It's 519 feet tall. This is one of those buildings, though, where an extra floor or two, would even enhance it even more, perhaps. But that all being said, I agree with the neighbors across the street who mentioned expanding that landscape area. It's important not just for the visual appeal, but the sidewalk that goes along Alton Road is 8 to 10 feet the entire length from 5th Street down to South Point Drive, except for where those 3 parking spaces are. And it's, you know, there's a lot of bus stops nearby, a lot of people who work south of 5th and live south of 5th walk on those sidewalks to get towards 5th Street and the Publix and whatnot. So it's extremely important, anything this board can do to support that, whether it's, you know, a condition in there that they'll do everything possible to work with the city, and we, you know, we make a motion supporting this as well. I think it's really important for the project. One question I have, though, is the short-term bike parking. So I think the mobility hub that you mentioned is really great. There's extensive long-term parking and short-term parking. And I saw on the plans a little bit of short-term parking along Lenox. The question, the ask, the concern, a lot of times short-term parking, best practice is to put it as close as possible to the entrance. So if it's possible to put some short-term parking by the entrance, the lobby of the office building, I know there's a really extensive like plaza area in the front because of the geometry of the roadway. I'm sure you can find some way to do that, but that would be the only ask there. And then lastly, I'll mention, I did, when I met with the applicant and their team, we talked about the driveway width for their loading area along Lenox, and they're gonna do everything possible to minimize what the effective crossing distance is for people walking along the site on Lenox Avenue. So, very supportive.
Thanks, Matt. John?
Beautiful project. Love it. I think it's great. Looking forward to it. Do you have a picture of how the valet, the car entry area is going to look like? Because I didn't see a lot of that, and I guess that's my concern, is the backup of traffic when cars are queuing in the morning. I don't know if there are photos of that, because I saw there's a lot of the other sides, but.
Right, so we have a few depictions of this. Let's see. This is this is an artistic rendering, okay? So this has maybe a beautiful Porsche or Maserati with no traffic. But that is the elevation, right? So to get more into details, this is a site plan that shows the entrance and the valet, which will all be internal to the site. All of this activity, the valet drop-off there comes off of Lenox and will be handled in that curb cut in that area that's there. And then we'll have to, part of our traffic analysis is a valet study. And we have also put a condition, I think Michael Baluch put a condition that there's verbiage in those conditions that the stacking that is generated from valet must be contained within the site.
Yeah, I guess so. I guess one concern I have is when people are getting dropped off by Uber, are they really going to be going around to Lenox? And is there a easy pull-in on Lenox? Perfect. Okay, that's what I didn't see in the drawing, so that's what I was. Okay, good. That answers my question. The other thing about the valet, I see in the mornings there's a minimum of 7 valet runners, and then in the evenings, the peak hours in the evenings, 11 valet runners. It seems like a lot to me, but I imagine you need that to make sure that there's no backup with the robots, but the mechanical lifts. But then there's the provision that you're looking to add in terms of basically removing that requirement if you feel the need that there's not as much need for that for 7 and 11. And I guess my only question is more for staff. Is there a way that they can just submit a request to you? You confirm that there hasn't been any issues, and you approve that?
Yeah, because I think the concern, or the primary concern has been mentioned. They need to have the appropriate valet runners, so there's no backup onto or queuing onto the street. So if as long as they're satisfying that condition, this amendment addresses that. Because otherwise, they have to have those minimum number of valet runners, or if they're addressing it by a lower number and not having queuing on the street, then that also satisfies the condition.
Well, but where did the 7 and 11 numbers come from?
That came from their study,
Okay,
the traffic study.
okay.
So I've seen cases where it's indicated, dozens of valet runners, and then we come back to the planning board and find out that they don't need near that number. It's just put in at the very beginning, and I think as part of the progress report, so I think 90 days after operation, they're gonna come back to the board for a progress report. At that time, they'll update the board in terms of the, how the operation has been working and the actual number of attendants that they've needed.
Yeah, I mean, I guess just the sentence that they're looking to put in sort of just guts the 7 and 11 and leaves it to their discretion. I mean, it's for the right reason. I mean, if they don't need it, they shouldn't have to have it. My only concern is that in 90 days, if they have half capacity or occupancy, that 90 days isn't going to be a real.
That's true.
But I guess as long as you're not, it was the 7 and 11 was proposed by them. I think as long as we're saying that there's sufficient valet, then I think it's fine.
So Adrian Dubkowski with Kimley Horn, offices at 2 Alhambra Plaza in Coral Gables. When we start off with the valet analysis, we prepare trip generation calculations, and those trip generation calculations take into account multimodal. So in this part of the city, the multimodal rate is actually 54%, but the city only allows us to cap that at 20%. So the calculations are conservative. So then it feeds into needing X amount of valet attendance, which then we always caveat with if the actual trip generation is less, you're not going to need all of those valet attendants to be on the site.
Okay. And is staff okay with the change in the delivery hours?
Yeah, our concern was to make sure that since they're using the same area for valet, that they use the area for loading. Our concern was that as long as they're not using the valet area during times of peak operation, which is the peak hours and afternoon hours, the before 8 or after 7 works with an occasional, midday loading, as long as it does not disrupt the valet operation.
Well, I guess in terms of neighborhood, because it's going to be within that area, I don't think it's not going to impact the neighbors.
Yeah, I think on this side is okay. If it was
Right.
Alton Road, it'd be a different case.
Right. Okay, thanks.
Beautiful project. Thank you, everyone. A few questions. Will there be enough on-site parking to service all of the tenants?
Yeah, so there's
While
a,
you're at that, just as a
Yeah.
follow-up.
Yes, sir.
Is a tenant are these one-off units, or is it like one company? Like, just to kind of give a background about the office tenants.
Well, so it's.
Burko Rodell is moving there.
Yes, no, that would be fantastic, wouldn't it? What a beautiful building. Yes. So it is not going to be a single, it's not going to be Apple that takes all 5 floors. That's not contemplated.
Yet.
However, as you can see, this is a very, very high-end product. So we are going to have, there could be family offices, there could be financial services, things like that we anticipate to have a very high degree of finishing and a low degree of impacts. The opposite of a lot of small units with a lot of impacts that were discussed in other matters today. This is going to be a very high-end product with not a lot of not a lot of numbers, right, in terms of the population of the tenants and their employees. And we're under a very rigorous parking calculation, that Adrian and Michael worked through under the code, that we have to have a certain amount of
So there's
parking.
enough to service all tenants and guests.
And the interior build-out will be after you determine what tenants are coming in? Is that how it works? Okay.
All right, so that was 1. 2, the only thing that's being removed are on-street parking spots, correct?
That's correct.
Got it.
That's correct.
The actual curb cut isn't being removed. It's not like you're removing a turn lane or anything like that. It's just parking spots.
No, now there are existing curb cuts that we are proudly, that we think are not well, the site right now is not well circulated. We are happy to discontinue some of these curb cuts.
Great.
And have this one entry with all of this regulation.
And then last question for the development team. just for my own curiosity, because it's something that we've spoken about here, you have a really nice floor plate. What led you to kind of consider this office use versus residential use, or?
Sure, so I can share. So, you know, we came to South of Fifth in Miami Beach a couple of years ago, and we're very active developers actually in Manhattan in New York. And what had happened was we started to get a lot of calls from our clients and people who had purchased in our buildings in New York, and you know, investment partners and so on and so forth. And the complaint was there was a lack of office product here. I think we had a number of people that we knew quite well that had moved here during COVID, and they didn't want to be at 830 Brickell. They wanted to be able to, you know, very easily get to the office. And I think we kind of, our strategy was to really focus in on buildings that met that need. And I think we've found that it's been quite effective, and I think it fills kind of a gap, and I think it also allows for a very high profile type of tenant base, which I think is certainly of great benefit. We've had success on our other project, thank God, and hopefully we'll have the same here.
Thank you.
Thank you.
Anything else? All right, I think it's a beautiful project. What really got my support is when I saw Aaron Butler on your team. He's a superstar. Old friend. And no, it's a great project, so congrats. Go ahead.
Wonderful project. Congratulations. Yeah, that's it. There's nothing to say. It's beautiful.
It's stunning. Congratulations, it's beautiful. I just had one question. Tell me about the mechanical parking. I know we have 2 that are in South Beach now, and they're not functional because of the salt. How will you remedy that?
So they, I think we have the vendor in our listed in our operations plan. We've used them in other projects, and those are highly regulated mechanisms. The public are not allowed to operate them. Yeah.
Your mechanical parking is just
Actually,
stackers?
it's stackers, not automated parking.
That's what I was,
Yeah,
okay, thank you.
absolutely.
That's all I was, thank you. Beautiful, congratulations.
If I could add one more comment we forgot to include as a condition, I just want to add that 24-hour on-site security shall be required.
Now, is that going to be a numerical
And
addition?
we're
or-
going to add that as a condition, yeah.
Okay.
Okay, and staff is okay with the applicant's
The
recommendation?
last, yes.
Yeah.
mhm.
With generally, okay. Motion?
Go ahead, Yechiel.
Oh, I'd like to move
Please.
it, but I'd like to
I'd be
add.
honored.
I'd like to add one condition, which is some short-term bike parking will be located near the lobby. And then the other is on number 40, just to add in there, not just the wider swell, but also the wider sidewalk as well in there, because it will be also slightly widened.
Okay,
You
so-
can,
so-
I'm sure Michael can get the verbiage
Yeah,
correct.
we
correct
can
on
add
that.
those in, yep.
Okay.
Yep.
All right, so that's the motion.
All right, could I
Along
have a
with staff.
second?
I'll
staff-
second.
Second.
Excuse me, along with staff and applicant draft order. The
Sorry?
change- The
Oh, yeah, yeah,
changes as the applicant
Right,
has
right,
also
right, right.
proposed.
Okay, I think
good.
Elizabeth got the second
Efficient.
first.
Fine.
Right.
As
All in,
efficient.
sorry, all in favor?
Efficient.
Aye. Anyone
Any
opposed?
opposed?
Thank you all.
Congratulations,
Really
motion
impressive.
passes.
Thank you so much. I do appreciate this
Thank
board
you.
a lot. Thank you.
We're going to be really lonely now.
Yes, right.
It's a big team.
Thank you, thank you.
Okay, moving on to comprehensive plan code amendments. Planning board file PB 240650. Are
Give me just a
10
minute.
and 11 companion, Michael?
Yes, we're going to
Okay,
take the
Okay.
next 2 items together.
All right, so the first is development regulations, creating the Normandy Isle Overlay District for certain CD1 zone properties, and Normandy Isle Overlay District Workforce Housing Comprehensive Plan Amendment.
Sure, and we're going to discuss, I guess we'll just give a minute for the room to clear.
Yeah.
I'm gonna get some water too, actually.
All right, we're going to take a 2-minute break.
Okay.
Please take your seats. The meeting is about to begin. Please stand by. We are going on air in 5, 4, 3, 2, 1.
Okay, welcome back, everyone. We are on to comprehensive plan code amendments. As I mentioned before, we're going to move on to items 10 and 11, which are companion items. Planning Board File 240650, Development Regulations Creating the Normandy Isle Overlay District for certain CD1 zone properties, and Planning Board File 240651, Normandy Isle Overlay District Workforce Housing Comprehensive Plan Amendment.
Thank you, Mr. Chairman. I'll give an overview of the applications and outline the process that the applicant's going to go through in terms of the required steps. So the applicant is proposing amendments to the comprehensive plan and land development regulations in order to enable the construction of an 8-story, 120-unit workforce housing development, including approximately 5,000 square feet of ground floor retail space located at 1960 Normandy Drive. Under the current city code requirements for this CD1 zone parcel, the maximum height is 40 feet and the maximum FAR is 1.25. The applicant previously received design review board approval for the construction of a new 4-story building with 60 workforce housing units on the subject site on September 6th of 2022. I'm going to just go through briefly the proposed amendments that are part of this overlay district. One is to increase the floor area ratio, and this is also can be found on the handout that we provided that was emailed you last week. The applicant's proposing as part of the LDR amendments to increase the floor area ratio from 1.25 to 3.5, increase the height from 40 feet to 75 feet, reduce the parking requirements to 0 for ground floor commercial uses, and increase the density allowed under the comp plan in order to allow for the construction of up to 120 workforce housing units. As part of the FAR increase, the applicant has included some impact analysis, including for the proposed FAR increase, which would raise the maximum square footage from approximately 32,000 square feet to 90,000 square feet. They provided an infrastructure analysis as well as massing studies. We did also provide a memo from the Transportation and Mobility Department as part of this review, as well as a memo from Hazen and Sawyer, who reviewed the impacts on the additional demands to the city and the city's water and sewer system. Now, as noted in our zoning map, the subject site is within the CD1 portion at the western end of Normandy Isle. Now, although the CD1 does limit the height to 40 feet, this is surrounded by the RM1 district, which allows a height of 55 feet. So really, in comparison, this request is for an additional 20 feet beyond what would be allowed for the RM1 district. Now, in terms of the process, this is the first step in a 6-part process. Any sort of FAR increase, which this includes, requires first a preliminary review by the planning board. After this meeting, there's a public workshop before the third meeting, which would be at the planning board potentially now for June, where the planning board would transmit the recommendation to the city commission. At the city commission level, the same process happens. The city commission reviews this preliminarily with the planning board's recommendation. There's a public workshop, and then a final public hearing meeting on the application. So we are recommending that the board review this application and, in accordance with the requirements outlined for FAR increases, continue this application to the June 25th meeting in order to allow the workshop to happen between now and the June meeting. Then I'll turn it over to the applicant.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the board. Nicholas Rodriguez from Burkow, Riddell, Fernandez, Larkin, and Tapanez, representing Jackie Hill LLC. I'm joined by our architect, Adam Fons, our traffic engineer, Tom Hall, our civil engineer, Max Kaplan, and the principal, Alan Wasserstein, are available via Zoom. Not quite as large of a team as the last application, but we still have our team as well, and they're present virtually. So this proposal is contrary to kind of what's been reported. It's not a Live Local Act project. We wouldn't need to be here if it was a Live Local Act project. And what it is a realistic proposal to create feasible workforce housing in North Beach. Many proposals and legislation have been proposed. Some have gone forward. A couple of examples of incentives for workforce housing that exist in the code today are the unit size of 400 square feet and an 80% density bonus when you propose workforce housing. despite those incentives, we don't see many workforce housing projects going forward, let alone almost no projects that are 100% workforce housing projects like this one is. The issue has really reached a boiling point recently when the state took this extraordinary step of preempting local government zoning through the Live Local Act to create more affordable and workforce housing. We're not proceeding that way. We're proceeding with another version of a proposal that should bring a 100% workforce housing project to North Beach, and we're excited to share that with you. So with that, we'll pull up our presentation. And so this is just a roadmap of what we'll be seeing today. I know Michael just went through it, but it's a pretty complicated new FAR amendment process, so we'll go through it again. The proposed legislation, which is a comprehensive plan text amendment and map amendment and a resiliency code amendment. Because we're touching density and floor area, we have to have a companion comprehensive plan amendment item. We'll go through the proposed project plans, which are pretty well developed, and we'll show you the infrastructure analysis that we've done to ensure that there is adequate infrastructure to support the larger project. And then at the end, we'll talk a little bit about the affordability. So just to touch on the FAR amendment process, Michael called it a 6-step process, kind of combined some of the steps here, but we are in step 1, and one of the good things of the new process, even though it's very long, is that the planning board is involved in this process very early on. This is the first hearing, the legislation was drafted, we're getting feedback from you, we're gonna get feedback from the community, and then we're gonna come back to you, potentially with modifications, depending on the feedback that we receive, and then come back for a transmittal to the city commission. We'll then review it, have another community meeting, and then consider adoption. So we're kind of, the sausage is being made, and we're very, very early on in the sausage making process, so to speak. So just to summarize the proposed legislation, it's only applies to the CD1 district for projects that apply all of the units, 100% of the units as workforce housing. I don't believe there's any other project other than maybe the Miami City Ballet project that's providing housing for the ballet dancers that provides 100% workforce housing, definitely not on private land. So we're increasing the density from 60 units to 120 units an acre, and we're preserving the ability to seek that 80% density bonus that already exists in the code. We're increasing the height from 40 feet to 75 feet. We're increasing the floor area from 1.25 to 3.5, which amounts to from 32,000 square feet to about 92,000 or 90,100 square feet. We're eliminating the parking requirement for ground floor commercial uses, and we're prohibiting, based on staff's recommendation, nuisance retail, which is something that's happened pretty much citywide in commercial districts, the occult science establishments, smoke and vape shops, the type of commercial that the city really doesn't want to see proliferating.
I'm going to ask you one question because
Yeah.
it's like really curious. Why wouldn't, I'm happy to see this, but why wouldn't you be going under Live Live Local?
Why wouldn't we
in order
be?
Since you're doing
Yeah.
100%, that only requires 40%.
Right.
I'm really happy you are, but I'm just curious. Like,
So we could pivot to the Live Local. Under the Live Local would be permitted the highest density in the jurisdiction, which is 150 units an acre, but we
Right.
wouldn't get the bonus. So that would yield probably less than what we're proposing.
Got
I
it.
think probably
Okay.
like 90
Makes
units.
sense.
So we're proposing more units than what the Live Local. So this is the applicable map. I'm sure you've seen it in your package. It's the CD1 district at the western edge of Normandy Isles. It's a small CD1 district, and then within that, the overlay would apply to the property at 1960 Normandy Drive. As staff pointed out, we're surrounded by an RM1 district. So although our height limit is 40 feet, we're surrounded by a district that permits 55 feet. And in fact, we're across the street and next door, not directly next door, but one property over, there are 5-story buildings. So what we're asking for is 2 more stories, a 7-story building for a project that provides 100% workforce affordable housing. So this is the actual text. I know it's quite dense, just to show you what the actual text looks like. But it's density, 60 units an acre. It was provided in the summary, workforce housing, 3.5 floor for FAR ratio, and commercial uses listed there that are being prohibited. Again, this is the zoning code text. We added the red text in this version from what staff has seen in response to the next item that was continued, because we received the item which I call the Live Local Act down zoning. It's proposing modified setbacks for projects that would be proposing residential and commercial or industrial districts. At this point, we're going to have to work with staff to figure out how to reconcile conflicts between this ordinance and that ordinance, because if both of these move forward at the same time, we won't be able to build this project applying the setbacks that's being proposed in the new ordinance. I know that ordinance was deferred, so as that gets developed, we'll have to work with staff. And again, we're very early on in the process, so we're happy to do that and try to figure out a way to reconcile both of them. For now, this is what we came up with as a way to do that. But
And remind me, and
yeah.
I know we've been through this, my apologies, but workforce versus affordable, remind me the workforce to qualify to be workforce?
So workforce housing is defined in Chapter 58 of the code as anything between 65% and 140% of area median income. An area median income in Miami-Dade County is $77,900.
All right, so 65 and 100, what'd you say?
It's 140 is the max.
Okay.
Mr.
And
Chair,
currently
could-
it's 70,000?
Yeah, 77,900.
Okay. Mr. Chair, could I ask a question
Sure.
now? Okay. Can you explain the bonus? Because I didn't understand your answer to his question about why you're not doing Live Local, which I also was thinking the same thing.
Okay.
So you're already asking to go from 60 to 120 dwelling units per acre.
Right.
Right, and you're maxing out your new proposed FAR with that, but you still want to reserve the right for an 80% bonus on top of 120?
So we're
Units.
proposing 120 units. The site is a little over half an acre. So we couldn't get 120 units on
Live Local.
on the property with the current zoning with the bonus or the Live Local Act, just the density you get to the Live Local. The way we achieve the density
Okay.
is with the 120 units per acre plus the 80% bonus,
Okay.
which is it's a significant density bump, but it is for only applicable for a 100% workforce housing project.
And then just one follow-up question. The AMI at 140%, I mean, that's a pretty high, I don't know how to say, pretty high level, right? You're getting like, I think a fact sheet was sent to us, you're getting at like $140,000 for a family of four. Is that in the right ballpark?
I have the chart in our slides, and
Okay.
we can review it. It's at the end, but
I'll stop
no, it's
there.
fine. It's just that the answer to the question is that the workforce housing is defined in the code,
Okay.
right? So that's we're
And
doing.
and
yeah.
if you wanted to fill it entirely up with the 140%, you could, right? There's no
That's
requirement.
Right, theoretically,
to-
under the definition of workforce
Right.
housing in the code today, we could fill it with 140,
Right.
everybody
Okay.
at 140%.
If I could just add one point, that under the workforce housing ordinance, it does require the city commission to set the rental rates each year, which they haven't done yet, because we haven't had any projects.
Right, but my question is, could you allot a percentage to lower income as opposed to all at the top? But anyway.
It's certainly feedback that,
Go ahead.
we're not expecting, but it's,
What if you did that, might make the project kind of financially unfeasible? Because they're not doing this, I assume they're not doing this any type of tax credits.
right, we don't get the ad valorem tax credits
Right.
that the Live Local Act gets, and we don't
Right.
get tax
So
credits.
you're saying the commission would set the rental rates and then whoever applies at those rates applies?
Right, based
Okay.
upon, and I imagine those rates would be set based upon the size of the
Right,
unit. It's not going to be.
Right, okay.
Right,
Sorry,
and
go ahead.
Since we're on the topic, I was going to get to it later, but I'll get to it now, is one of the benefits of the workforce housing is we're under a declaration of restrictive covenants, and it's set at those amounts for 30 years, right? So no matter what happens in North Beach when all this development in Town Center happens, when the buildings around us are redeveloped, rents skyrocket for whatever reason, there's consistency. And what a lot of people experience in a housing crisis is rents going up from one year to the next, a significant amount, and that can't happen with workforce. So it's not just the initial amount, it's the
Right.
future amount, it's the amount that it can increase per year, which is really one of the strong benefits.
And on that note, aren't there also like very significant restrictions on short-term rentals?
Right, we're not proposing any short-term
No,
rentals.
I know, but just in terms of like future use.
I believe,
Well, you can't do short-term rentals as part of workforce housing.
right.
No, that's what I'm saying, there's.
Right.
Yeah.
Correct. They're mutually exclusive.
I believe that's correct. I hadn't read that exactly, but thanks, Michael, for the clarification. So, all right, so just back to the site context, it's 1960 Normandy Drive. I'll turn it over to Adon to show you the project that we're proposing. And
So the site's on Normandy. and
I'm
we got
sorry, I know
Vernon
it's a
Court.
formality, but just introduce yourself and your
Sorry,
affiliation.
and thank
Sorry.
you for having me here. Adam Fons, architect, design architecture consultants, the firm. So our site is, like mentioned, a little bit more than half an acre. We're on Normandy, and we have Vernon Court, and then the alley on the opposite side. We're looking at the idea of the project is obviously the workforce housing is the main point, but we also want to activate the street. We want to make it a pedestrian-friendly area, and what we've done here is that we've lined the bottom floor with the retail, and that would also hide the garage structure. And the idea is to have wider sidewalks to promote activity on the outside. The workforce housing, we've included balconies which overlook the street. We think that's also part of the the trend for eyes on the street, which makes it for more pedestrian friendly as well. This is the corner of Burnham Court, which enters the Walgreen area, and then also on Normandy. So we'd want to line the entire street. We also, our retail is also structured so it's smaller spaces. It's 5,000 feet, but they're broken up into about 6-7 units. That also, we think it'll promote growth for small shops and from the neighborhood, more entrepreneurial, we think. Here you can see an elevation or a 3D perspective from the rear. We wanted the building to make sure it is 75 feet high, so we wanted to make sure all sides had a facade that had a presence so you could see it. And we articulated the facade with stucco lines and white, and we entered the colors, the palette on the upper floors is a little bit more neutral and more with the deco and the palette, the lighter tones. And then we wanted the bottom floor to kind of pop out a little bit, so that's kind of more the active space. We also looked at the traffic and the parking, and we wanted to be sensitive to that. So what we ended up doing is off Normandy, we have one entrance, which is to our second floor garage, and then off the garage, we have the other entrance, which is to our first floor parking spaces. That way we would have like kind of the traffic a little bit more spread out. We have 30 plus spaces on the second floor and 30 plus spaces on the first floor. So there shouldn't be a lot of traffic. And our exit's off Vernon Court, which is also where kind of Walgreens entrance is.
So, sorry, what's happening at Everglades Court? Is that just parking spots, ground floor parking?
Yeah, those are ground floor, and that's off of the alley, the Everglades Court alley. And then we have additional parking space on the inside. So you kind of come in on.
The full Normandy frontage are retail spots?
Yeah, we lined the Normandy side with all the retail, and then we wrapped it around Vernon Court, because Walgreens kind of has their entrance also, their parking side on that side. So we wanted to kind of promote like at least the activity for walking on the ground floor.
Thank you.
Second floor, we've also introduced bicycle storage. We think that the workforce housing benefits from local trips. That's also part of the retail, while it was structured to be a little bit smaller. So by having bicycle storage, you want to introduce some scooter storage. We think that the users of the workforce housing will be able to go by mass transit or by public transit, let's say, and then use bikes and scooters, which is also trends for sustainable designs. Here we have three of the units. We have an A and a B, which is the reverse, and we also introduced 2-bedroom units, which we think is part of natural progression. If you're in a 1-bedroom, you're a young professional, or you're one of the in the service industry, service staff like waiters. You kind of, if you have a small family, you can go to the 2-bedroom. We think that's kind of also a need. And then I'll turn it over to Amigos here for the rest. Thank you.
So we do have Tom Hall if any traffic questions come up. He's on Zoom, but just want to summarize, we did submit a complete traffic analysis for the project. We did get comments back from the Transportation and Mobility Department. We're, again, early on in the process, we know what we need to do, revise our study, look at the plans, and make sure that we are addressing those comments. The traffic study did find that we're not impacting the roadway links around the projects any more than typical development that's permitted today would be allowed, and the existing transit routes will service the project, and we're proposing TDM measures like ample bike parking, posting transit information within the site, and given it's on Normandy Drive, we have access to transit We also did an infrastructure analysis of our water and sewer demand for the commercial, the residential, fire, and the sewer demand for all of it. We did get feedback from I think it's Hazen and Sawyer as the consultant, that the water demand can be met and upgrades may be required for the sewer system. They didn't really elaborate much on what those upgrades will be. So between now and the next planning board meeting, we plan to try to meet with them and figure out what those upgrades would need to be in order to make the project possible and make sure we don't bust our sewer demand. And with that, I was going to touch on the affordability. We talked about it already, so I'm sure we'll talk about it some more now. We're asking to be continued to June so that we could come back and move this forward.
Okay. Anyone in here to speak other than whoever? Okay. Anyone on Zoom?
There's nobody on Zoom with their hand raised.
Okay. Close the public hearing. Questions? Any questions? Go ahead.
No, you, please. Order, please. Left to right.
So look, we don't discuss design really here, and we're like way early in the process, but I saw some of the renderings that are in here, and what sticks out to me, by the way, first, I think workforce housing, greatly needed in this city. I'm supportive of this moving forward. Of course, we're the first step in a really long process here. And thank you for explaining why the Miami Herald article was not correct. I was a little perplexed reading it. I was like, I didn't know there was, why are we reviewing this? I didn't know there was even a project.
It's a little confusing.
But my comment, though, again, I'm getting ahead of ourselves here, but to see the garage open to an open air garage courtyard where people are going to be living and have windows and doors, again, way ahead of myself here, but that concerns me, the noise of cars coming and going and whatnot. The other kind of transportation-related question is, again, we're way ahead of ourselves here, but I didn't see any short-term bike parking on the ground level near the retail, and I would suggest that, as you kind of bake this further in, if it moves forward. Again, we kind of talked about this briefly, but the big range in AMIs that are allowed for this, again, I think you mentioned that you don't set the rate or the rent. I guess the city sets the maximum rent that you can charge. And so, again, that's 140% of AMI is a really big number. And maybe that does capture some of the workforce, but if it was only tailored to that at one point, it would leave out a lot of other people who are in need.
Thank you for your comments. We take them into heart, and we'll come back in a couple months with hopefully some changes.
I know that we'll be able to discuss this once we have more community feedback, but in the meantime, I'd love to see if there was some capability from the developer to introduce or include micromobility, whether that, just electric scooters or even offering kind of bikes on site, kind of on demand. I think that would be really helpful, especially for that, Normandy area.
Kind of like hotels offer their own city bike type thing.
Exactly.
Yeah.
Yeah.
Okay. Understood.
But love the project, love workforce housing. I think there should be a model for the rest of the city.
Great.
I had the same concern, but go ahead.
Just, again, the project is very welcome, so thank you.
Right. Thank you.
I had a question about unit sizes. What is the 1-bedroom, 2-bedroom?
The 1-bedrooms are 412 square feet, and the 2 bedrooms I think are 790 or 690,
right under 700 feet.
One bedroom at 412 or a studio?
And
we don't have studios; they're just 1 bedrooms. Right?
400?
412, yeah.
And a 2-bedroom is what?
700.
It's 690.
Would you consider reducing the number of units and increasing the sizes? I feel like for a family in 600 square feet is a little tight. Maybe I think it's tight.
Yeah. We're getting the feedback today. It's a little bit weird.
That's
We're
why
not going to agree today,
right? And then, but are those Juliet balconies, or are they full-size balconies?
No, we had full-size.
full-size balconies? Okay, I mean, I like the project, so, I mean, and I live around there, so.
And we can look at the square footage and see how we can adjust.
Okay.
We were, just in response to that comment, we were looking at kind of what's available in the area, and there are similarly sized 420 square foot units
This
in the
is
area.
different. It's workforce. It's not really developed in the 1960s, which we have a lot of around. And I know that we have a lot of short-term rentals that well, let's just say we have a lot. And I really want this to work. I think, anyway.
Got it, I understand.
So the request is that it get deferred till June,
Right, so we need a motion to
Okay.
continue this
That's
to
it.
the June 25th meeting.
Motion to continue to the June. planning
Yeah,
board
to
meeting.
continue both, so just for the record, this is to continue both PB 24.
PB 24-0650, PB 24-0651 to the June meeting.
First, second? Alyssa, second. All in favor? Aye. All opposed? Okay. Thank you.
Thank you all, have a great
Thank you.
afternoon.
Okay, planning board filed, item 12, planning board filed 24-06663, repeal of CD2 co-living incentives and reduction of TCC co-living maximum units.
And this report can be found on page, starting on page 181 of the board packages. So currently, co-living units are only permitted along limited portions of Washington Avenue and in the North Beach Town Center TCC district. Co-living units are only permitted on the west side of Washington Avenue between 6th Street and 15th Street. And in North Beach, co-living is only permitted in the TCC district with a cap of 550 co-living units. Now, the only previously approved project that received approval for co-living units is a project that was reviewed by the planning board several years ago at 1234 Washington Avenue. Now, although a demolition permit was issued and demolition commenced, they have not received a full building permit for that application. However, their approvals are still active under the allowance for state extensions. In the North Beach Town Center area, the total number of units that have been permitted compared to the maximum is 529. So the proposed ordinance removes the ability for any future co-living units along Washington Avenue and repeals all references to co-living within the Washington Avenue corridor and within the TCC district in North Beach. It lowers the cap to from 550 to 529. So we're recommending that the planning board transmit this to the city commission with a favorable recommendation.
Anyone on Zoom?
There's nobody on Zoom.
I
and
didn't think so.
Our audience is empty.
Can you clarify the?
Miriam?
Yeah.
Want to speak?
Anything to say?
Can you clarify, you said there was an application previously filed, there was something.
Approved, yeah, for
Approved.
1234 Washington. That was the project that initiated the code amendments to allow co-living units.
So on the slight chance that I read somewhere it's going to auction, whoever buys that wants to continue with the project
It
as
can be
is, they
approved
could
in
do
accordance
that.
with the code at that time, yes.
Okay.
It hasn't
other-
expired.
What was the, sorry, Matthew,
Any other questions?
Jonathan?
No
I have a
questions.
question. What was the impetus for removing the co-living allowance?
I think the idea is that wanting to create more long-term housing instead of sort of facilitating these smaller units that are really, more like hotel rooms versus, permanent living facilities.
Actually, I do have a question. What is the size of a co-living unit? Or the average or minimum?
I think it can be down to as little as 200. It's a
Okay.
combination of, it does require that you have shared spaces. So typically you would have a common kitchen area, a living area, and then have a separate bedroom that's part of that. And it also requires a certain percentage of amenity spaces within the
Okay,
building.
So it's sort of like a hotel, the size room.
Right. But you would have a shared within, typically what we've seen is you would have 2 or 3 like bedrooms sharing a common living and kitchen area.
Imagine we work for housing, like dorm room.
There's some entrepreneur right now watching this thing. That's a good idea.
Oh, well,
We
it's
do
already
it.
here.
We have
That's
them in
what we're
downtown
doing.
Miami. Yeah.
That's what we're doing.
Had we had any other applications? I'm just trying to understand why we're not gonna.
Well, there was some talk about the application we saw earlier for 1509 Washington. initially when that came to us, there was uncertainty whether or not they were going to propose co-living units. Ultimately, they did not in the end.
So Yechiel, you said that you have a project, a co-living project. Can you tell us about that?
Sure. So the idea is, let's just take Wynwood as an example. So in Wynwood, we have co-living, so we'll have a 3-bedroom apartment, and they can rent, by the bedroom, essentially. So instead of, the price point for Wynwood being $2,000, right now it's $1,700. So it allows people who might otherwise not be able to afford moving into a community to allow them to move in.
And then you have more common areas within the building
Yeah,
for
so
recreation and
we have
television.
incredible amenities.
Right.
We give them a sizable kind of living area, so that they don't feel like they're stuck in their room. But then if they want to rent by the bedroom, they have the option. And what we've seen actually is it's a great entry into each of the neighborhoods. So people kind of come into the neighborhood for $1,700. They love the neighborhood. Then they'll maybe spend a little more to be in a studio or a 1-bedroom, and they kind of graduate throughout.
And they're long-term rentals, they're not short-term rentals. So.
All long-term rentals, yeah.
I should, before I forget, I should just mention that the Land Use and Sustainability Committee did review this on February 5th, and they did recommend that the planning board transmit this with a favorable recommendation.
Right. Okay, someone want to move it?
Yeah, I'll move it. And I think that, if perhaps they see in other parts of the region that it's a successful model, that, they could come back to the city commission and look for another change in the future. But right now, I think it's a good idea for us to repeal this.
I'll second it.
Okay, so the motion is with a favorable recommendation. Great, okay. All in favor?
Aye.
Any opposed? Okay.
Okay.
All right, last but not least, Planning Board File 13, Planning Board 240664, Sexually Transmitted Infection Testing Regulations.
And this report can be found starting on page 195 of the board packages. And just to update, the Land Use and Sustainability Committee did review this on February 26th and did recommend that the board transmit this to the City Commission with a favorable recommendation. So currently, STI testing is considered a Class 1 medical use, only as part of a retail clinic or medical office, and a Class 2 medical use as part of a lab or healthcare clinic. These types of Class 1 medical uses are allowed in all zoning districts except, Class 1 medical uses are allowed in all zoning districts except residential single-family, townhome, RM1, which is residential multifamily, RPS1, RMPS1, and RPS2 districts south of 5th Street. Also, as a Class 1 medical use, STI testing can only permit it as part of a medical clinic or office. Our land development regulations designate uses that are exempt from regulation as a medical office. This would include, for example, a home health agency, homemaker and companion services, home hospice services, massage therapist. These are not designated as medical uses.
So it would add it to the list.
This ordinance would add that to a list to allow more expansive testing facilities within a place of residence, as well as within multifamily, commercial, and mixed-use districts.
Can I ask a question about that? I marked this when I was reviewing the staff reports. What exactly does that mean, as well as within multifamily, commercial, and mixed-use districts?
So it means that someone they could come in and offer testing services in that district without being classified as a medical use and and have to meet the requirements of a medical facility or a healthcare clinic.
Well, what's the problem? Do we don't have enough of them?
The problem is we don't have enough testing, and it's been indicated as referenced in the actual ordinance that by rate of transmission, Miami-Dade County ranks 17 nationally.
I get that.
Right.
But it's the problem we don't have enough testing facilities because they're zoned out?
Right. Well, they're
Okay.
limited in areas, so
Right.
this would expand the availability of testing services.
Right, okay.
But so just to follow up a little bit, my question is, would a STI testing facility be allowed to open up like a storefront in these other districts that you mentioned?
Yes.
Well, but this is for
in their home, though.
Well, no, that's separate, so that would allow someone to have someone come to your residence and do testing individually, or for example, it would allow testing at out of the closet. They could provide testing services there, which otherwise they could not provide.
My understanding also is, because I'd asked the question of the sponsor, what health regulations would be covered under that, and this is just a zoning ordinance.
Right.
So anything that would come after that would be up to the state and how they regulate that. So that was my question. So I too had questions, so.
Michael, just to clarify, Class 1 medical uses are allowed in all zoning districts except the ones you state here. So this ordinance basically allows STI testing,
Specifically.
whereas they don't need to do it, they don't need to be part of a
Clinic, right.
clinic, that's
Right.
one. But would it?
Which are limited in where they can be.
Which are limited, but would it allow it in these districts? In other words, if someone's gonna do it on his own, he's got to, out of his house.
No, not out of a house.
No, and
So
it'd have to be a commercial area.
It would
but-
still be a commercial area, so
Commercial,
it
right.
wouldn't allow it in the RM1,
And we can,
RPS1.
we can put together language to clarify that
Yeah,
if
that-
needed
it just isn't
before this
clear.
goes to the commission.
So
yeah.
it's just allowing it, whereas it doesn't have to be part of a clinic.
Correct.
Correct.
Okay.
Correct.
But it's not changing the zoning areas where it could be,
no.
like, okay.
Which seems to be a trend in the country. It's one of those things you search and you just hope no one looks at your search history, right?
Yeah.
You were typing it in, but it seems to be like an ongoing thing, and a lot of the states are doing more of that kind of.
Michael, I
push
think
too.
it's important that you do that clarifying.
Yeah, we'll
Because it's a
Yeah,
little
it's not
Yeah.
RM3, RM1, no residential area.
With that understanding,
And it's
someone want to
not
move
gonna
it?
be-
Make a motion to approve
Second.
with a favorable recommendation.
Who was the second on that?
Jonathan.
All in favor?
Aye.
Aye.
All opposed? Okay, and I guess we're deferring the last item.
Correct.
Discussion on resiliency's code updates. All right, guys.
Michael, you wanted the copies of
Bless
the
you, bless you.
1509
The 1509,
Washington?
if you want to leave those here, and we'll send them to you.
Meeting adjourned.
Yeah.
Michael,
or-
good job on your first meeting back.
Thank you.
Nick, great
Nick,
to have you
welcome back.
It was a
Always
long
good
day.
It's like you never left.
Yeah.
Yes, if you want to leave
It's all
the
good.
1509